Morning, everybody. Happy Friday. Happy Friday. Happy first full day of the defense case in the prosecution of Karen Read. First defense witness. Always exciting. I was thinking yesterday once we finished the stream, I was thinking back to trial number 1. And I remember one of my favorite parts about David Yanetti's opening statement was when he said, wait for the defense. Wait for the defense. You'll be glad you did. I remember really liking that. And because it's such an important concept and kind of reminder to the jury anyway. Hey, just because you've been here 23 days doesn't mean you know a lot about the case. You might think you do. It's kind of structured maybe to give you that impression. But you got to wait for us. You got to see what we have to say, what we bring to the table. I think that's a good reminder. And I appreciated that he did that. So I hope that the jury is as enthusiastic about being able to finally hear from the defense as I am, because there's a whole different perspective here that they've just gotten little hints of, but sometimes transforms the whole case. So we were told by Karen on the courthouse steps yesterday afternoon that the first witness is supposed to be Matthew DiSogra. Who's that? Who's Matthew DiSogra? He's their accident reconstructionist. And this maybe is a little bit confusing. It was a little bit to me because I didn't deep dive this guy or the witnesses, the new people, anything like that. I didn't go look them up on the internet, try to research them and stuff like that. But boy, there are people that do that. And so the way I became aware of Matthew DiSogra was in between the two trials. Defense has hired new people. Prosecution has hired new people. They want to do more work on the vehicle infotainment system. Shanon Burgess apparently files his protocol. And we get this delightful affidavit from Matthew DiSogra, because he's the one who explained, hey, dude, you don't know the difference between your bits and your bytes. So I'm going to share it real quick. This is, of course, courtesy of Dee, who's always got the documents for us. I don't know if that's quite big enough to be able to see. But he tells us, and he attaches a copy of his CV. He's a professional engineer, works with this forensic engineering company. He specializes in chip and board level digital forensics. So my impression when we first hear from this guy, he's Shanon Burgess's equivalent. He's the Aperture has Shanon Burgess. Delta V has this guy. Turns out that might be a little bit understating what it is that Mr. DiSogra does. Part of why I'm eager to hear from him today, if that is in fact what we get. So he's a professional engineer specializing in chip and board level digital forensics. He's reviews their protocol, and there's some problems, some statements that form the basis of his opinions that are factually inaccurate. In his analysis, Mr. Burgess misstates the memory storage capacity of the chips in question by failing to account for the differences between a megabyte, megabit, gigabyte, and gigabit. Conversion between and among these units is a foundational digital forensics concept, which necessarily impacts data acquisition protocols and analyses thereof. That was a call out. I mean, it's the most professional white glove call out really that you can do. But when you're like, these are factually inaccurate and this is really fundamental to the task of computer forensics, this is a slap down. So he has personally obtained and reviewed the manufacturing specifications of the chips at issue. Mr. Burgess misstates the memory storage capacity of the chips, which were removed from her Lexus infotainment and telematic system. As follows, he identifies all these chips, and all of them, they are not gigabytes, they are gigabit chips. All available data was successfully retrieved based on the amount of data capacity on the chip and the amount of data they actually got when they went in and extracted these chips the first time. And so then he proposed some amendments to the protocol that include besides whatever it is that's going on with this this first process that they're trying to establish with the protocol, that needs to be modified. But above and beyond that, defendant's expert needs to have eyes on whatever this guy is going to do with this board. And also, guys, this is so fundamental to forensic stuff, and this guy gets it so basically wrong. He is so untrustworthy that I, Matt DiSogra, I should be permitted to immediately halt it. If these guys are out there clowning around and have no idea what they're doing, and have the what they're doing threatens to put the integrity of the data at risk, then I get to halt it, and we'll bring it in here to the judge. This was a smackdown, and so that's where I got to know. That's where I got to know Matthew DiSogra and who he was and what he's going to bring to the case. So we're going to get a contrast with Shanon Burgess, and that how could that not go well? Like, how could the contrast with the guy who lies about his degree? How could that not go well? But anything is possible, right? We don't know. We get a vibe. I get a vibe from this affidavit. The vibe from this affidavit, this guy is very professional. This smackdown is extremely professionally delivered. There's nothing snide and snarky about any of this. There's nothing, juvenile. This is just, we got to call things how they are. And how they are is, this is like so basic that this guy needs eyes on him. So that was kind of fun. And then, of course, the one and only fabulous Olivia Lambeau, of course, who has everything and knows everything about everything with this case. She's got the resume. She's got the CV. So we can take a little peek at the CV and see what this guy does. So he does, in fact, not only have a Bachelor of Science in Mechanical Engineering, but a Master of Science in Mechanical Engineering. Unless we hear otherwise, but he's not currently working on them. They have dates on them. So 2013, we're expecting that degree was awarded. He has a license to work as an engineer, and he's a certified IPC specialist. I don't even know what that is. I'm going to look that up real quick. What does that even mean? What's a certified IPC specialist? Certifications in electronics manufacturing is what it sounds like. What is an IPC specialist? IPC International appears to be the organization that does this. IPC certification, blah blah blah. They're built around IPC standards, but what does IPC stand for? Somebody tell me what IPC stands for. What is the acronym? Certified IPC Specialist. Well, designer certification. I thought that this might be helpful to try to look out, but nobody wants to tell me what the actual acronym is. Do you guys, anybody in chat? Anybody in chat know what the IPC? Oh, hey, why's my banner on? Didn't even turn it on. Anybody in chat know what the IPC is all about? I don't know. Well, tried to answer, couldn't get it quick, so we see he is currently with Delta 5 Forensic Engineering down there in Charlotte. He's a consulting engineer specializing in motor vehicle accident reconstruction and vehicle system analysis. Look at that. He does both. He does both. Aperture needed a Judd Welcher and a Shanon Burgess. Matt DiSogra, he's both of them in one person. Accident reconstruction includes analysis of collision dynamics, vehicle speeds, collision avoidance, collision simulations. Oh, no kidding. Event data recorders and advanced data recovery methods. Yeah, that sounds good. That sounds like what we're looking for. Somebody who can analyze how all this would work and maybe run some simulations for us. So that'll be interesting to see. Before that, he was an associate engineer with Delta, where he assisted senior engineers in motor vehicle accident reconstruction, including scene data collection. Oh, you know what information we need from a scene. Perhaps you're going to have some critiques about the quality of the information that we have from the scene. If only this guy's from Charlotte, North Carolina. Doesn't mean he hasn't done work in Massachusetts before, but it sure would be nice if he's got some grounding in Massachusetts so that he could talk about the kind of information he's been able to get from them before. Kind of information you would maybe even routinely expect to get from a motor vehicle investigation that you'd get from the state police, the scene investigators, and so forth. One thing that hasn't really jumped out so far in this trial is we can look at the evidence handling and the decisions that were made and all of that and recognize that this looks problematic. There's a series of bad decisions, bad judgment about what to do, what not to do, what to secure, what not to secure, when to secure it, how to secure it, etc. But we haven't seen any kind of comparison of, is that just normal for them? Is that just normal for them? Is that their baseline that they're this incompetent? Or were they like specially incompetent for this case? Because those tell us a little bit different things, don't they? If you're just routinely incompetent, then there's no malice, maybe no cover up. We're just so incredibly sloppy that we can't necessarily keep a case free of reasonable doubt. we can't get our cards in order. But if this is different, if we actually have a fairly extensive record of doing perfectly adequate and competent collision investigations, then this would stand out. And then we would wonder, well, why would this one be special? This one, if anything, should stand out in a positive way because this is a law enforcement officer who died. This is a Boston cop who died, who's being investigated. If it's special, you would think it would be special on the side of we're being extra careful, extra thorough, extra diligent. But it seems to be that that's not what happened. So it would be, he's done a lot of this work. Don't know how much of it he's done in Massachusetts, though. I wonder if we're ever going to get any kind of a comparison. Just get to see, like, what's their baseline? What's their baseline? And then how does this work that they did, how does it add up? So then before that, he was an intern and worked on other things. He's done all this continuing education. Now check this out. Because I already have a preview of this cross-exam, guys. I already have a preview of where we're going to go with this. All this continuing education, autonomous technology and long-haul trucking, advanced applications of heavy vehicle EDR data, advanced driver assistance systems, sensors, conference, all of these, different trainings and things like that. Oh, did we skip? Is it on here? No, it's not on here. It's still to come. His publications now. A lot of these publications as recently as 2024, but in fact, he's got an even newer one. Gotta see if I can find it real quick. Oh yeah, this one that I think he's the lead author on. We'll get back to that. So another whole bunch of different publications. Testing of heavy truck advanced driver assistance systems and crash mitigation systems. Examination of Detroit Assurance 4.0 video radar decision unit records for use in crash analysis. Whole bunch of different presentations. And then professional organizations. He's a member of the Society of Automotive Engineers as both an instructor and a member, and then the National Association of Professional Accident Reconstruction Specialists. So, it's a perfectly respectable CV. He's got work that he's done. That's impressive. I don't know what I wouldn't know how to simulate vehicle speed sensor data for use in heavy vehicle event data recorder testing. I'd have no idea. So this guy has some very specialized knowledge and expertise. Now, what stands out about it to me, and where I can already see Mr. Brennan going on his cross-examination. Mr. DiSogra, your curriculum vitae shows that you have a specialty, you have a specialized expertise in heavy truck, heavy vehicle data recorders. Isn't that correct? You've done presentations on heavy, and that's really what you focus on. Mr. DiSogra, is a Lexus LX570 a semi-truck? No. Is it a bus? No. What other sorts of vehicles qualify as heavy vehicles? Is it a combine? A combine? Is a Lexus 570 a combine? It's gonna be shit like that, guys. He's gonna one, try to flog this witness with his own credentials, okay? As if it's like a bad thing that he's got this specialty of heavy vehicle analysis. The guy analyzes semi-truck accidents. Like, that's kind of cool. That's kind of cool. I mean, major forces, big impacts, complicated stuff. But he's going to try to like make that a problem, as if that means he's unqualified to do the same type of work for just an ordinary passenger SUV. He's going to try to flog him with his qualifications. I can already see this coming. And then he's going to flog him with the incompetence of the Aperture witnesses. You didn't even put any paint on your arm. When you did your testing, you weren't wearing the right clothing, were you? I mean, he's going to take some of these most ridiculous things that came out of the mouths of these Aperture witnesses. He's going to take those things and he's going to try to flog DiSogra with them, as if not being on board with that makes him bad. Makes like him the bad guy. So that, I think, is that's what I'm expecting. Before we get to anything else, before we get to any substance of what he has to say or anything, that's where I see this cross going. Like, this is already out there. He's got this CV. He's going to look at it, be like, oh, heavy vehicle event data recorders. That's not what's at issue here. So the recent report that Mr. DiSogra filed, the recent paper that he filed, I believe in April of this year, so just a month ago, examination of the data structures of the Bendix data recorder, some specific data recorder that's in some vehicles. Apparently, they've been able to extract the raw data, but they have not been able to parse it, make a report out of it, except for the manufacturer has been able to do that. But the forensics folks had not cracked the code, so to speak, until apparently Mr. DiSogra, as the lead author, was able to do that. So he says the raw BDR, it is demonstrated the data follows uniform and repeatable patterns. The raw BDR data is converted into a conventional report and then validated against translation reports performed by the manufacturer. The techniques outlined in this research allow investigators to access and analyze BDR records independently of the manufacturer and in a way previously not possible. The guy invented something. He went in and figured out the code and broke the code and showed people how to go straight to the code to understand the data that they're getting out of this particular data recorder. So that gives us another, I think, little bit of insight into his expertise, particularly where it relates to vehicle data. Okay, this is not some guy that needs to plug in the Bosch or whatever, tool, the Burla, whatever tool we're using to get the data out of the car, out of the different systems in the car, and then have it make a report and then flip through the report looking for what the report tells him that the data says. That's not this guy. This guy may not need the report at all. This guy understands the data as data, and he understands the data architecture, the way that it's reported, the systems of it, and so forth. So I'm expecting a pretty deep level understanding of what is going on in Karen Reed's SUV, potentially also John's Traverse, maybe also John's Traverse if that's been put in issue. Maybe we'll be talking about that too. So we still got the fan going on in court. We didn't know if we were going to be allowed to attend the business that the court is up to this morning. We just know they have something going on with argument that needs to be made or something. So keeping an eye on that, but not actually sure if we're just going to be waiting until they're done or not. So something else I'll share, just because we're in kind of show and tell mode this morning. Why not? Actually had a little bit of time yesterday to go around and read what people are thinking and get some of the takeaways and things like that. And I wanted to share this particular thing. I don't know if you can read it, that Mark Bederow had to say, because Mark has that skill of being able to say things just really well. It's a great lawyer skill, being able to say things really well. And something that Mr. Bederow says in here just encapsulates what I was trying to get at yesterday, but he just says it a million times better. So I want to share it. One of the problems with Welcher's scientific analysis is that he, in essence, turned himself into a very unscientific fact finder whose task was to assess the credibility of inconsistent witnesses regarding the presence of other vehicles in the path of an SUV, allegedly going backwards at a specific distance at a specific time. This is so very artfully put, because this is what I was trying to say when I was talking about how similar this guy is to Dr. Hughes and why I'm getting so many of those same vibes and that same just off-putting kind of reaction to him. And it's this is encapsulating it. It's because he just turned himself into a fact finder. He has this engineering credential and this CV that he uses to justify being put on the stand in the first place. But the actual opinion that he offered was not scientific at all. It didn't even arise from the work that he did as an engineer. And how do we know that? Because he told us. He told us his opinion there was a collision. What was that based on? It was based on the totality of the evidence, including the DNA and the statements and the interviews and all that type of stuff that has nothing to do with engineering. It has nothing to do with engineering. And so it's so much like what Dr. Hughes did in the Depp trial, where she's like, well, you know, there was this and that thing that happened. Why? Well, because, you know, one of the witnesses testified to that. And so she just took as true certain parts of the factual record that were in dispute, and she made herself the decision maker. Oh, I think this person was telling the truth, and therefore that's what happened, and therefore we're going to assume that that's what happened for purposes of me coming in here and analyzing, you know, abuse dynamics. Just kind of roughly speaking anyway, what she did. Ostensibly, she was supposed to be a psychological expert. She was supposed to be there to talk about testing and so forth that she did. But that isn't what happened. She testified. She made herself the jury.
Thank you.
She made herself the jury.
So
she took
I
the
was
jury's
told counsel
job.
want to see me at Sidebar?
Sure.
Great. We're going to start at Sidebar. And so that's what Mr. Bederow just articulated that so well. That's the problem. It's the same thing that Mr. DiSogra, or that Mr. Welcher, Dr. Welcher just did on the stand with his testimony. Is he didn't come in as an engineer with an engineering problem that he analyzed and hopefully solved and gave that answer to the jury. He came in and waved his hands around with engineering speak and principles and things like that, and then ultimately said, hey, I looked at the case and I think she's guilty. But you're looking at the things that the jury gets to decide. The jury gets to decide who they believe. The jury gets to decide the significance of if any, of, you know, trace DNA on the taillight. The jury gets to decide all those things. Those aren't engineering. The jury gets to decide if a Jeep was there or not. You don't come in and say, well, it was this because the majority of the people said that. That's not within the scope of your job as an engineer. That's the job of the jury to make that decision. Was a white Jeep parked in the way or not? So that I think it really nails down for me what was so particularly aggravating about that guy and what's aggravating about experts like this in general, because they're coming in under the guise of offering helpful, scientific, specialized, technical type of information. But what all they're actually doing is just coming in and trying to put their thumb on the scale and saying, look at me. I'm really smart and I've looked at everything and I think she did it. So you should think the same thing. That's really all it is. It's really all it is. And so I think that gives me some insight too into why this was so just obnoxious to Mr. Alessi. You know, he did not come back with his humor. He came back even more pissed. And I mean, it worked. It worked. He was able to control that witness a little bit more effectively yesterday than he was before. But I think that's part of why he struggled, perhaps, during the early part of the cross, is just the incredulity that, you know, somebody is so shameless as to do that, you know, as to pretend that that what you're doing, when you just come in and say, well, I'm going to do the jury's job for them, and I've looked at all the evidence and here's what I think it means, and it has nothing to do with your scientific qualifications or work. It's like offensive, you know. I could see that being, you know, something that would disgust somebody like Mr. Alessi, who, has a pretty good, especially for a lawyer. For a lawyer, he's got like a top-notch understanding of science and math. It's not the forte that most of us have. There is a reason why we all went into law and not into medicine. So yeah, I wanted to share that just because we're big fans of Mark Bederow here, and he is a very excellent lawyer, and that's a good example of why. Very important to be skilled at your wordsmithing as a lawyer, and he was just able to distill that in a way that I wasn't able to come up with. Identifying and articulating exactly what the problem is. But he was able to do that. He, in essence, turned himself into a very unscientific fact finder whose task was to assess the credibility of inconsistent witnesses. You're exactly right, Mark. You're exactly right. That's what he did. That's what he did. That's why it's so annoying. That's why it's so evocative of Dr. Hughes and what she did in the Deputy Heard trial. Because they just appointed themselves the jury. I'm going to sort out the disputes and the evidence. I'm going to make those decisions for myself, and then my decisions are going to be the basis for my opinion. Not whatever work I did, not my psychological evaluation of Amber Heard. None of that. None of that. Just I went through and read through all of this extraneous information. And based on that, I decided I thought I knew what happened. And therefore, that's my opinion. Pretty nuts. But then he's also going to dress it up with a reasonable degree of engineering certainty. Dude, what does taillight DNA have to do with engineering certainty? It doesn't. It has nothing to do with the engineering problem. If you can solve the engineering question of trace DNA ending up on objects, and you can model that and predict that and so forth, you are going to be a billionaire. Like, you are going to absolutely kill it in the forensics field, because that is a big unsolved problem. We have absolutely no idea. There's so many variables involved. We got people shutter status. We got environmental conditions. We got surface conditions. There's all kinds of stuff going on trying to sort out what the presence of trace DNA on any particular object may mean. It's not even part of your engineering process. Where in your testing, your examination, where did you do anything at all with respect to the DNA? Another thing I was doing was trying to go through, I'm aware Massachusetts is a little weird in that they don't technically have like rules of evidence and stuff like that. They have things that they call rules that the court has adopted, but they aren't like really binding in and of themselves. They're just things that the court has kind of put together as guidelines based on the court's own reading of the case law in Massachusetts. So this is like the common law tradition, sort of embodied in rules, but they're not really rules and they don't really apply. But they give you a pretty good start. And so I've been going back to this section 703, which is in the Massachusetts Guide to Evidence, which is dealing with the basis of opinion testimony by experts. Because I can't wrap my head around why they're not allowed to ask Dr. Welcher about stuff that he read and considered and relied on, at least in part, but then, rejected other things. And they're not allowed to ask about, why did you pay attention to this, but not this other one? Why did you agree with this, but disagree with that?
We'll start with the required finding argument.
Ugh.
So I'll hear you whenever you're ready, Mr. Jackson.
Thank you, Your Honor.
Sure.
Thank you,
Well,
Your Honor.
what's
We
going
filed
on?
This morning, motion for required finding of not guilty under Massachusetts Rule of Criminal Procedure 25A. I think that's before the court. My comments will be relatively brief, but it's important, and the points that I'm going to make in the next couple of seconds or next couple of minutes are equally important. It comes down to the following. The Commonwealth has simply not proven, even in a light most favorable to them, that there was a collision on January 29th, 2022 at 34 Fairview in Canton, Massachusetts. There was no collision proven to have occurred. There was no eyewitness presented. There was no video evidence, no audio evidence, no evidence in the form of physical evidence at the scene by searches that were done by officers on the morning of January 29th, 2022. The Commonwealth, through suspect experts based on circumstantial technical data, only sought to prove a backing event, and that's important. They sought to prove that at 34 Fairview, the SUV went backward. They did not prove, and every single one of their experts was asked this question, they did not prove that there was actually a collision associated with that backing event. The Commonwealth experts said at best that the car went in reverse, and it was suspect whether it went in reverse at 34 Fairview or some other place, time, or date. The Commonwealth also put on an expert who said that she found no injuries, none, mind you, indicative of a vehicle strike on John O'Keefe's body. And she, Dr. Irini Scordibello, was arguably their most important witness. The Commonwealth cannot and did not say or prove a collision at a particular time, a collision at a particular place, a collision with a particular person, or that a collision even occurred on January 29th, 2022 at or around or at or after 12:30 in the morning. Their own expert, I think it was yesterday, if not the day before yesterday, was asked on examination by Mr. Alessi, can you tell us the particulars of the collision, pardon me, as you suggested in your testimony? And his answer was, there's simply not enough evidence. He was asked specifically, why didn't you try to recreate the circumstances, the force impact? That's what you do, sir. You're a biomechanic expert. Recreate it for us. And he said, there's not enough evidence. There is evidence, however, that Brian Higgins and Brian Albert were sparring at 34 Fairview. There is evidence, however, that was just minutes, not hours, not days, minutes before John O'Keefe ultimately met his fate at 34 Fairview. There is evidence that Brian Higgins was love-struck, that he was jealous, that he was aggressively coaxing John O'Keefe out of the waterfall, that he was passively aggressively coaxing Miss Reed to engage with him rather than John O'Keefe.
Well,
again, there's not a single eyewitness to a collision.
Very passive.
There's not even a single eyewitness to a backing event at 34 Fairview. The court will recall Jennifer McCabe testified that she basically watched the SUV the entirety of the time it was in front of the location at 34 Fairview with Miss Reed in the driver's seat. She saw it pull up once. She saw it pull up twice. She saw it pull up a third time. And then she saw it was gone. And at no time, did she ever see the car go in reverse. She certainly didn't see the SUV go in reverse at a high speed. And she darn sure didn't see the car go in reverse at a high speed and strike a pedestrian. Her focus was defined enough to see thin tire tracks in a dusting of snow, thin enough, I think the phrase was, to track a cat. That's how detailed she was in her observations, yet she did not see John O'Keefe hit by an SUV, she did not see John O'Keefe's body in the snow, in the yard, laying prostrate, a 216-pound, 6'1" man in the snow, directly in front of the SUV she was tracking the entire time. There are two other witnesses, Ryan Nagel, Heather Maxson. They both noted that John O'Keefe, not that they didn't see him, Your Honor, that John O'Keefe was not in the vehicle when they were behind him. The dome light was on. They could see inside the interior of the vehicle. Ms. Reed was sitting there with her hands at 10 and 2, and the passenger seat, notably and markedly, was empty. He was not outside the vehicle. He wasn't standing. He wasn't sitting. He wasn't lying down. There's only one place he could be: inside the curtilage of the home, inside the house, or inside the garage. Not one witness that was inside the house, not one passerby, not one neighbor, not one plow driver ever saw John O'Keefe's body laying prostrate in the snow that morning. Not one. Not until Karen Reed found Mr. O'Keefe at about 6:03. And again, the Commonwealth's chief medical expert, Dr. Scortibello, their medical examiner, who's the only person that the court heard from or will ever hear from who actually investigated John O'Keefe's physical body, the only person to have physical access to John O'Keefe, testified he did not have any injuries consistent with being struck by a vehicle. But she did indicate that the injuries, as did the firefighters, the first responders, indicate that he had injuries consistent with a physical altercation.
With being punched.
And certainly, as to counts 1 and 3, no evidence has been presented or proffered whatsoever by the Commonwealth that Karen Reed intended to run over and harm John O'Keefe in any way, shape, form, or fashion. Hearken to the video at C.F. McCarthy's. Hearken to the video at the waterfall. Every witness confirmed what our eyes could see. That night, John O'Keefe, Karen Reed were loving, caring, affectionate. There's absolutely no evidence that Karen Reed had an intent to harm John O'Keefe, or that she that after the fact, that she intended to leave him for dead, because there was no fact to be after. There was no collision in the first place. The Commonwealth's case, certainly on counts 1 and 3, taken separate from count 2, because of the mens rea associated with counts 1 and 3, fails miserably. The Commonwealth, at the end of the day, has presented their best case. They've done their best. Some would say they've done their worst. And their case has failed. No reasonable jury, hearkening back to the standard under Rule 25, no reasonable jury could find Karen Reed guilty of count 1, count 2, or count 3. But taking count 1 and 3 aside, those are separate counts because of the mens rea required and the high burden that's required, even taken in the light most favorable to the Commonwealth. What evidence have they proven that Karen Reed intended to kill or harm John O'Keefe, or that she intended to leave him for dead in the snow? The answer is none, 0. No reasonable jury could find Karen Reed guilty. This case never should have been brought in the first place. There are reasons that I won't go into here. The court knows those reasons, or knows our position on those reasons. This was a vindictive prosecution, and I believe that the court is duty-bound pursuant to the precepts of Rule 25A, as well as the principles of justice, to dismiss all 3 counts. And certainly, taking count 1 and count 3 aside, the court is duty-bound to dismiss those 2 counts. Thank you.
It's a good argument, but we know she's not going to. Because it'll be circumstantial. It's inferential, taillight on the lawn, et cetera, et cetera.
In a light most favorable to the Commonwealth, the first issue the court should look to is intoxication. The reasonable fact finder would find that the defendant was in fact intoxicated. Based on the serum conversion and based on Karen Reed's statements herself, you've heard many admissions by the defendant about her level of intoxication, which far surpassed the statutory mandate that she consumed alcohol in a way that would affect her ability to operate safely. Those are just two of the cornerstone pieces of intoxication, which are clear, light most favorable to the Commonwealth, a reasonable fact finder could find beyond a reasonable doubt. The evidence of collision is abundant. I do not want to go through an entire closing argument or rhetoric, but suffice to say there are taillight fragments from the defendant's own Lexus from her shattered right taillight that are found in Mr. O'Keefe's clothes. Mr. O'Keefe is left at the very spot where she expects to find him, according to her statements, where her car does a backing maneuver at least 24 miles per hour. He is left with injuries on his arm consistent with the damage to her Lexus right rear taillight. The scientific data is substantial. Telestream data, Apple Healthcare data, battery temperature data. And again, Ms. Reed's statements herself about clipping, hitting. The evidence of a collision in this case is overwhelming. It is a public way. Lieutenant Gallagher told us about Fairview as being a public way. And so as to the operating under the influence of alcohol manslaughter, the conduct of driving in that forward and backing maneuver after being intoxicated meets clearly the standard for OUI manslaughter. Regarding second-degree murder, as highlighted in my opening statement, the defendant engaged in intentional conduct that was her maneuver of driving forward, stopping, and then driving back to Mr. O'Keefe on January 29, 2022. Under the conditions at night after being intoxicated, that conduct was intentional, and any reasonable person could find that her conduct that night
That's not enough. You need
created a
specific
plain and
intent for
strong
murder.
likelihood of death. There is no predicate of intending to kill or even intending to hit.
Oh,
There is clearly a plain and strong likelihood of death driving a 6,000-pound SUV forward and then back. In
Really?
addition to state of mind, again, the
did you
defendant
know
tells
he
us
was there?
herself
Where'd you prove that?
through firefighter Becker. They're arguing, they're upset. We see the text messages, evidence of attempted breakup, and we hear the words of Karen Reed when she leaves numerous voicemails that night, and you can hear her voice. There are statements, I do not want to go through a summary of all of them, but statements from the defendant herself where she acknowledges an injury to Mr. O'Keefe. She's the last one with him, where to find him, and her hypothesis is about hitting and clipping him. As to leaving the scene, again, the defendant tells us that when she leaves, he doesn't look mortally wounded. She leaves him, makes dozens and dozens of
I knew
calls,
he used that statement.
but never goes back to help him and leaves him to die. And we heard from Dr. Wolf about the life-saving procedures that could have been initiated. The chance of survival was never given to John O'Keefe. All of those facts suffice under Lattimore, a light most favorable to the government, that a reasonable fact finder would find beyond a reasonable doubt, or could find beyond a reasonable doubt, each and every element of each and every one of these charges.
All right, thank you. So the motion is denied as to all three indictments. On the other topic that we were discussing at Sidebar, I don't need to hear argument on that right now, Mr. Yanetti. I'd prefer to get started. I would like you and Mr. Brennan to talk to see about proposal. So are we ready to bring the jury in? I did not ask you at Sidebar. Are you ready for this witness, Mr. Brennan? Mr.
I'm ready.
Okay, so.
Thank
Are
you.
you
all right,
ready
so
for this
we'll bring the
witness?
jury in. That will
When is
take
it up
5
to
minutes
you?
all. All right, so we'll take the recess.
All right, please.
Well, I saw Rob here in the chat make this point. It's a good effort by Jackson, but circumstantial evidence gets the Commonwealth over the directed verdict hurdle. 100 bazillion% agree. Because all you have to do is just accept the gaslighting. If you accept the gaslighting and that this evidence means what the Commonwealth is telling you that it means, then you would convict her. And that's essentially what the standard is. If you interpret it the way that they want you to, could you find these elements? Yeah, you could. You pretty much always can. Maybe not for second degree, but first charge they cleared. Appreciate Jackson tone here. No hyperbole. He did keep it minimal. He also gave us a little Alessi flavor with his hearken. Wanted to make sure that we hearkened to what we needed to hearken to. Had to look up the etymology of that real quick, just because gotta nerd out on some of this stuff sometimes. Apparently, it comes from Old English, an Old English word that means listen. So, hearken to this. I'll listen. So yeah, this is largely formal. I think from probably the lawyer's perspectives, this went exactly as expected. Routinely, these motions are made at the close of the prosecution's case. Basically, look, they haven't met their burden, and the motions are made because the case is weak. Because that's why the case went to trial in the first place. Nobody pled out. But a weak case, whether that means it's just a weak case but still establishes guilt, or a weak case that doesn't establish guilt, that's for the jury to decide. So weak is not grounds to throw it out. Weak is a reason to tailor your closing to the weaknesses that you've observed. I thought it was a good tone, not over the top. It's just it's not going to work. That there's no physical evidence at the scene the morning that Gallagher and Good are out there is important, but it's not dispositive because of course they claim they found stuff later. And even if their claim that they found stuff later is unbelievable, lacks credibility, can't be substantiated by the chain of custody of the stuff, we don't even necessarily know exactly what they found. Those are credibility issues for the jury to decide. These people said they found that. Do I believe that or not? And as soon as you have a credibility question enter the equation, you have to have the jury make that decision. The judge doesn't get to make the decision. Yeah, you know what? These guys are full of shit. So we're going to throw out this case. You can't believe that. That's not the judge's role, and it shouldn't be the judge's role. Imagine a world where Judge Bev gets to decide the credibility of witnesses and make decisions kind of like the way Welcher did. I'm going to go through and evaluate things and make my own determinations about what happened, resolve the conflicting evidence the way I think it should be resolved, disputes between witnesses. I'm going to decide what is real and what is not real. And then we're going to evaluate our legal posture with all of those things being assumed. That would be bad. That would be a very, very bad state of affairs. I think Brennan was pretty subdued in this argument too. I'll give him credit, where he deserves it. He doesn't want to give away his whole closing. We know that, but dude, we already know what your closing is going to be. Your closing is going to be all these things Karen said, because that's what you had. Even in this, you got to try to point to Karen's statements about clipping, Karen's statements about intoxication, Karen's voicemails, Karen's statements where she acknowledges, I knew, did I or did I not call? He was going to misinterpret that one particular clip where she talks about he didn't look mortally wounded. And she's clearly talking about the next morning when they found him, but he's going to deliberately misinterpret that and suggest that it means she saw him that night injured before she left. I knew he was going to do that. Such a major reach. And yeah, he did. Yeah, he did, because that is that you have to have that to get to get to intent. You have to have something like that to get to intent. The driving rapidly backwards creates a risk of harm, foreseeable risk of like grave harm, or whatever exactly that standard was. I wrote it down somewhere. Oh, strong and plain likelihood of death was the language he used. Creates a strong and plain likelihood of death to drive forward and then back up at 24 miles an hour. Well, if you know somebody is in the way. If somebody's not in the way and you're just, I don't know, out on a ski trip like Dr. Welcher, then it's fine. There's no problem. It's only if you know the person is there that you might hit the person. If there's nobody around, or you think nobody's around, then that wouldn't be a dangerous maneuver. And so you have to read into a lot of these circumstances, quite a lot to get to intent. That's why he desperately needs that one statement to be misinterpreted. He didn't look mortally wounded. That's clear. It's, to me, so obvious. She's talking about when they found them the next morning. He doesn't have, his skull, in the front anyway. He doesn't have it all bashed in. He doesn't have guts hanging out. He doesn't have, the obvious sorts of things that would make you think, he's been in some type of traumatic accident and has died because of that. He doesn't look mortally wounded. But they've got to try to turn that into when she left, she saw him.
You are unmuted.
The only person apparently that saw him outside 34 Fairview the whole time out of 16 or whatever people that we've established was 16 that night. Came back, but I think they're still just bringing the jury into the room.
Hear ye, hear ye, hear ye. All persons have any business before the Honorable Federally Canonical Justice of the Norfolk Superior Court and for the country of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Good morning again, counsel. Good morning again, Ms. Green. Good morning, jurors. Happy Friday. So I do have to ask you those 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? No. As you know, yesterday the Commonwealth rested, and as you know, the defendant has absolutely no burden of proof in this case, does not have to put on a case, but I hear that you are. So your first witness, please, Mr. Jackson.
Thank you, Your Honor.
With the court's permission, we would ask that Matthew DiSogra join us.
Okay.
So the rumors are correct. Matthew DiSogra going to be our first witness.
So you're going to step up, face the clerk, and raise your right hand.
solemnly swear the evidence you give to the court and jury in the case down here is for the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Okay, look, he only needs one tiny little binder, not like 8 gazillion laptops and a calculator, etc.
All right, Mr. Jackson, whenever you're ready.
Thank you. Mr. DiSogra, could you please state your full name and spell your last name for the jurors, please?
Sure. Matthew DiSogra, last name Disogra.
What do you do for a living, sir?
I am a licensed professional engineer. I practice in the field of accident reconstruction. And within that field, I specialize in analysis, interpretation, and accessing all types of vehicle data.
How are you currently employed?
I'm employed by Delta V Forensic Engineering, which is an engineering firm that specializes in accident reconstruction, all parts of accident reconstruction.
Tell us a little bit more about Delta V. What is it? What kind of company is it? But other than that specialty, what else does it do?
So accident reconstruction is a broad field. There are a lot of subspecialties within that. So accident reconstruction is everything from the initial investigation phases of crash all the way through testimony, like here today. Some of the specialties within that could be things like biomechanics, could be human factors, and my specialty is data, vehicle data, and event data recorders.
Staying on that topic, what is your current title or position with Delta V?
I am the Director of Engineering for our EDR services line.
What does EDR services mean?
So, event data recorders. So EDR is a general term we can use to talk about all types of data from all types of vehicles.
And how would you describe your role as the Director of Engineering for EDR services for Delta V?
I wear a couple of different hats. First and foremost, I'm still a practicing engineer. I still conduct investigations. I still perform analyses, and I testify. On top of that, in the director role, I oversee a group. It's not just me doing this kind of work. I have 3 other engineers that work with me, all specializing in EDRs. So I oversee that group and focus on kind of the day-to-day operations as well as the direction we're going. You know, with things like autonomous vehicles coming, the role of data is growing, so we're kind of looking to the future in a lot of those ways.
As a consulting engineer, you've indicated what your specialization is. Do you specialize in motor vehicle accident reconstruction as well as vehicle system analyses?
I began my career at Delta V doing traditional accident reconstruction in the broadest sense. And as I have progressed, I have sort of narrowed myself down and now specialize in that. But I still consider myself an expert in accident reconstruction because ultimately,
No, please finish.
Ultimately, anytime we're doing EDR data analysis, it is in support of an accident reconstruction.
You talked about event data recorders. Do you also engage in the specialty of advanced data recovery methods? In other words, methods of pulling the data. It's one thing to have it sitting in a car. It's another thing to pull it out and make it useful, correct?
That's right. There are a lot of different ways data can be accessed, all the way from just plugging into a port on a working vehicle, all the way through when a vehicle is catastrophically damaged and even the modules themselves are damaged, accessing the data at the chip level. So no matter what condition a vehicle or the remnants of a vehicle are in, generally we can still get the data from that.
Do you have any specific knowledge about Toyota data?
I do.
Describe that for us.
Beyond Toyota being a common vehicle in general, so we run into that data quite frequently. Just this year, we published a paper specifically studying some of the behaviors of the additional data recorder that's in Toyota vehicles.
Does Toyota make another sub-brand, for lack of a better phrase?
Lexus, I believe you're.
So Lexus is a Toyota brand. Right?
Correct.
Okay. What is infotainment? It's kind of a combination of a couple of words, information and entertainment. What is infotainment data as it relates to vehicles, modern vehicles?
So it's a generic term, which more or less means the thing that's in the middle of the dashboard with the screen on it. A lot of manufacturers implement that a little bit differently, so they all look different, but it's a general term we use in the industry to describe that system.
And what about, I'm going to change gears a little bit, what about your experience with regard to GPS as it relates to vehicles on the road, on the common roadways of the country?
GPS is a pretty fundamental part of vehicle data as a whole at this point, and we run into it in a lot of different places. We see GPS data from infotainment systems, so we're analyzing that data. Most of that's GPS based. I do a lot of heavy truck work, and almost every heavy truck has some kind of GPS system in it for the fleets to track them, so we're analyzing that as part of data. And then the last area would be when we conduct testing, any kind of research, we're generally going to put our own GPS systems on vehicles so we can study that data. So analyzing GPS is a regular part of my job.
GPS, global, I'm going by memory, global positioning satellites?
Global positioning system.
System, got it. GPS is a mechanism to figure out where on Earth a certain item might be, whether it's this pin or an 18-wheel tractor trailer, correct?
That's correct.
Is there any difference inherently in the GPS mechanism that's installed in an infotainment center in a Toyota/Lexus,
She does have
versus a heavy
GPS
truck
in
or
her
a heavy
car.
vehicle that's on the road?
The core technology behind how it works is fundamentally the same.
What is instrumented testing as it relates to Toyotas and VCH testing and things of that nature? Can you explain that for the jurors?
Sure. What instrumented testing means is, let's say we want to study, let's say how accurate some data is that comes out of one of these vehicles. So we need an independent source of that information. So what we'll do is we'll equip a vehicle with one of these GPS data acquisition systems. Basically, we can drive the vehicle around and we know exactly where it is, how fast it's going, all these parameters. We can do some maneuvers with the vehicle. Then we can download the data that the vehicle stored, and now we can compare the two and say, okay, well, if we have really high confidence in our system, how accurate is the vehicle system? Because the reality is there's always some small errors in these vehicle systems. And in a lot of cases, what's important is quantifying that error.
So you're obviously familiar with GPS systems in many different platforms.
That's correct.
Okay. How many cases have you been a part of in terms of investigating and or analyzing infotainment center or infotainment system data?
Infotainment specifically, probably around 30.
And are you also familiar with engaging in some sort of analysis that's referred to as clock alignment?
Yes.
What is clock alignment?
Clock alignment would mean that anytime we have a timestamp in any set of data, a singular clock value, there's a good likelihood that that's not 100% accurate. So clock alignment would mean finding an independent source of time to compare that to, preferably one that's more reliable, and then making the necessary adjustments so that time can be considered real time.
How many cases have you been involved in that deal with clock alignment specifically?
Thousands, over 1,000. That's a regular part of data analysis. Any data set that has a timestamp, it's normal. It's part of the analysis. It's really the first step is let's get that clock aligned. So it's something I'm doing regularly.
And how long have you worked for Delta V?
It'll be my 13-year anniversary next month, actually.
Okay. These things that you just described that we've talked about for the last few minutes, these are all duties that you perform within the rubric of your employment as the director of engineering at Delta V, correct?
Correct.
Now let's shift gears real quick and talk about your education, training, and background that qualifies you to perform these duties that you just talked about. Go ahead. The road is open and it's yours.
Certainly. So I began my academic career. I got an undergraduate degree in mechanical engineering from the University of North Carolina at Charlotte. I then went on and got a master's degree also in mechanical engineering from the same school. And then when I came out of school, I immediately started working for Delta V Forensic Engineering. In order to get a professional engineer license, I then needed to acquire 4 additional years of work directly under the supervision of another licensed engineer. So then I completed that phase of work. And then in order to maintain my license, I have to complete continuing education every year in the field that I practice.
So you got both a Bachelor of Science, correct?
Correct, Bachelor of Science.
Did you mention the year that you got your Bachelor of Science?
2011.
And you have a Master's
Correct.
in engineering.
That is correct.
And when did you secure that degree?
2013.
You just mentioned engaging in continuing education. What is continuing education in terms of the engineering field or the reconstruction field in your world?
So in the state that I'm licensed, in North Carolina, they define that really as any activity you're participating in that's keeping you abreast with the field, keeping you up to date with what's going on. So taking formal classes counts for continuing education, but also some of the other work that I do, like publishing research in peer-reviewed journals, also counts as continuing education.
Do you regularly attend symposiums or symposia, I guess is the right
Yes.
word? Have you attended symposia related to EDR research and training?
Yes.
How about advanced applications of heavy vehicle EDR data?
Correct. Yeah, I attend. There's a couple of regular conferences in our industry specifically tailored to EDRs as a whole for passenger vehicles and heavy trucks. I'm a regular attendee of those. I'm also a regular speaker at most of those. And I'm usually presenting some of the new research that we have for that year.
So not only do you attend, you actually teach.
Correct.
Have you attended data? I'm sorry, have you attended data? Have you attended events that deal with data, event data recording systems and event data recording system extraction?
Yes.
What about vehicle crash reconstruction?
Yes.
What about electronic control module imaging?
Yes.
What about electronic control model analysis?
Yes.
Applying automotive EDR data to traffic reconstruction?
Yes.
These are samples of the type of continuing education that you routinely engage in, correct?
All that's accurate.
You talked about additional licenses and professional registrations. You're a licensed professional engineer, correct?
That's correct.
In North Carolina?
Correct.
You're also a certified IPC specialist?
Yes.
What is an IPC specialist?
Thank you.
IPC is an organization that offers certifications in basically soldering. I could say it in more technical ways, but it boils down to soldering.
Cool.
So as it relates to what I do, when we are recovering data from damaged EDRs at the chip level, that involves some really precise soldering work. And so IPC offers courses in how to do that at basically the highest level, and then they offer certifications for that.
Cool.
Are you a member of the Society of Automotive Engineers?
I am active member.
When you say an active member, is that a nationally recognized society for academic engineers?
Yes.
The teaching roles that you've held within organizations, have you been an instructor concerning accessing and interpreting heavy vehicle data event recorders?
I am. I'm currently an instructor of that course, which is offered through the Society of Automotive Engineers.
As a matter of fact, next week, are you going someplace to teach?
I am. I will be in Wisconsin next week teaching that very course.
Are you a member of any subcommittees within that organization, within the organization of the Society for Automotive Engineers?
I am. I am a voting member in the J2728 subcommittee, which is a subcommittee for event data recorders on trucks and buses.
Are you also a member of the National Association of Professional Reconstruction Specialists?
I am.
Does that require a certain level of education?
It does, and it requires, as far as I know, when I joined, sort of proof that you are active within the field of accident reconstruction.
That was my next question. It requires you to stay current on accident reconstruction issues, correct?
Correct.
Have you also authored peer-reviewed articles on within your field and
Yes.
subfield? Is it fair to say that you've authored or co-authored a number of peer-reviewed papers in the field of accident reconstruction specifically, as well as EDR data retrieval?
That's correct.
Have any of your peer-reviewed articles that you've either authored or co-authored specifically focused on Toyota vehicles?
Yes.
Can you name one, please?
Specifically, this year published a paper where we studied the effects of collision-induced power loss on the way data is recorded in Toyota systems. And that would include Lexus systems. Fundamentally, they're the same components, it's just a different brand on top.
In January 2025, did you co-author a publication entitled Simulation of Vehicle Speed Sensor Data for Use in Heavy Vehicle Event Data Recording Testing?
Mr. Jackson, you're going to have to repeat that.
Of course. Sorry. In January 2025, did you co-author a publication entitled Simulation of Vehicle Speed Sensor Data for Use in Heavy Vehicle Event Data Recorder Testing?
Yes, I was the lead author on that paper.
when you're dealing with retrieving data from a vehicle, an EDR, an event data recorder, Toyota paper, whatever it might be, and that's a term of art, Toyota paper, correct?
Sure.
Does it matter if the vehicle is a heavy vehicle, a small vehicle, a passenger vehicle, a moped, or a skateboard if they happen
Getting
to have
out ahead of that
infotainment
criticism.
center on it?
It's not a truck.
There are differences, of course, between the data that comes out of passenger vehicles and the data that comes out of heavy trucks, but there are also a lot of fundamental similarities to those. Like, for example, they all record vehicle speed. They all have accelerator pedals. They all have brake pedals. So a lot of the core data we're analyzing is very similar.
In January 2020, did you co-author a publication entitled Chip and Board Level Digital Forensics of Cummins Heavy Vehicle Data Event Recorders?
Ooh, Cummins.
Yes, okay. And what was the fundamental, without getting into the granular details, the fundamental aspect of that paper?
So, in that research, we introduced a new technique for getting data out of damaged modules. So, they're either burned, they've been submerged in the water, they're crushed physically from impact. We demonstrated a new method to be able to get data less invasively, but still at the chip level. And we also demonstrated that we could translate that data from the chips outside of the software that was provided. So you could use the software and get the data that way. And we demonstrated we could basically do it ourselves if we wanted to.
Mr. DiSogra, have you been qualified in other courts to testify as an expert in the area of accident reconstruction, EDR data retrieval?
Yes.
How many times?
Once.
When was that?
In New York.
You were deemed qualified as an expert in that court in this field that you're talking about today.
Specifically with as it relates to data, yes.
I want to talk a little bit about what you were asked to do in this case. We asked to undertake a review of certain work performed by a person by the name of Shanon Burgess with Aperture LLC.
Yes.
Are you familiar with Aperture?
Yes.
Before you were asked to undertake that review, were you familiar with Aperture?
Yes.
Were you familiar specifically with Shanon Burgess?
Yes.
Were you asked to engage in any original analysis in this case?
All of my analysis is fundamentally based on all of the data and the numbers provided in the Aperture reports. So more or less the answer to your question is no.
So you were asked specifically to give the court and the jurors clarity on data that Shanon Burgess had analyzed and provided a report about, correct?
Correct.
And that dealt with data obtained from Ms. Reed's SUV, Karen Reed's SUV, correct?
Correct.
Did you in fact review Shanon Burgess's report summarizing his findings and conclusions regarding clock drift? That report was dated in January of 2025.
Yes.
And what did you do in that regard?
I analyzed the methods that Mr. Burgess proposed for aligning the clocks in that report.
Were you also asked at some point to review Judson Welcher's report and PowerPoint presentation regarding the timing of the text stream event known as 1162-2?
Yes.
Did you determine whether Dr. Welcher had based his report on Shanon Burgess's analysis?
Yes.
Before we get into that, I want to ask you a couple of questions about text stream events. So we're all talking sort of with the same vocabulary if we could. When I say text stream event, have you ever heard that called a trigger event?
Yes.
Are those sort of synonymous?
The event, in order to be generated, has to be triggered by something. So, yes.
You became aware in your analysis, I'm assuming that Dr. Welcher reported a trigger event at a particular time or span of time, correct?
Correct.
What span of time was that? I should say, what time was that?
For which event?
For the 1162-2 event, sorry.
Do you mind if I reference the slide? Because I don't have the number committed.
With the court's permission.
Go ahead.
Do you have a copy of it in front of you?
I do, Your Honor. So the original analysis places event 1162-2 ending at 12:31:43 a.m.
Now, Dr. Welcher, and this is what I want to talk about for just a quick second. Dr. Welcher indicated that the trigger event began at 12:31:38, correct?
I believe so.
That would suggest that a trigger event lasts 5 seconds, 12:31:38 to 12:31:43, correct?
Objection.
Sustained as to form.
How many
Let me ask you
seconds did
this.
that trigger event take under his
Does a
analysis?
trigger event or does a text stream event last 5 seconds or 10 seconds?
The trigger is a singular point in time.
That's my question. All right, so if we're thinking about a trigger event, it's like that clap, snap, right? It's a point in time, not a series of, not a time span, correct?
It's a singular point, correct?
Okay. Does a trigger event or a text stream event cause a recording to bookend the trigger event itself?
Yes.
Explain that for the jurors so that we're very clear about that.
Sure. So when an event is triggered, what we end up with is some data from before the event was triggered and some data from after the event was triggered. The way it does that is it's kind of always recording. And as soon as it sees a trigger, it says, aha, and it goes and it grabs the previous 5 seconds. That number can vary. It can be more or less than 5, but for the specific trigger we're talking about, it grabs the previous 5 seconds of data, and then it keeps recording for an additional 5 seconds, and that completes its recording phase.
Right. So if Dr. Welcher indicated that the text stream event, the trigger, was at 12:31:38, would it be accurate if he said that trigger ended at 12:31:43?
Objection.
Sustained as to form.
What's wrong with the
Is
form?
there any, if a trigger event is one point in time, one snap in time, would it be accurate to say that the trigger event itself lasted 5 seconds and ended 5 seconds later?
It wouldn't be accurate to say the trigger lasted that long.
That's my question.
The event lasts that long, but the trigger is only one point within the event.
The recording lasts that long,
Right.
correct?
Correct.
So in other words, it captures, or does it, let me ask you this, does it capture 5 seconds before and 5 seconds after? But the trigger event is the singular point right in the middle.
That's correct.
Okay. If we were to calculate the window between the trigger event or the text stream event and a lock event on John O'Keefe's phone, you analyzed both, correct? Or you reviewed both, correct?
Correct.
Would you calculate from the point of the trigger, would you calculate from 12:31:38, that point in time, and I'm using the tip of my pen to represent the point, at 12:31:38, or would you calculate it from 12:31:43?
Customarily, when we're doing any analysis, we're referencing everything off of the trigger. That's the normal way. Everything in the Aperture reports was referenced off of the end of the event. So
Of the recording event,
of the recording event.
not
So,
the trigger.
correct. And I didn't correct that. I just went with that convention for all of the analysis I did.
But you noted it, correct?
Correct.
And you noted that that would be 5 seconds inaccurate. I'll withdraw it. I'll ask it a different way. What would be the effect of timing if you were to start at the trigger event, 12:31:38, versus timing the event if you were to start at 12:31:43?
There'd be approximately 5-second difference in every subsequent calculation.
And if, in fact, there was a lock event, which you reviewed, at 12:32:09. How long would the actual window be from the trigger event to 12:32:09?
It would be larger by 5 seconds, approximately.
So it would actually be 31 seconds, correct? Did I do my math right?
You did.
Let's get back, if we can, to the offsets that you identified in Shanon Burgess's, the time offsets that you identified in Shanon Burgess's report. When you applied the potential offsets identified by Mr. Burgess to the text stream event at 1162-2, what opinions or conclusions did you come to with regard to that analysis or that question?
Sustained, ask it differently.
What conclusions did you come
apply
to?
the
Is the
potential
problem?
offsets identified by Mr. Burgess in his January 2025 report to the text stream event 1162-2?
Yes.
Did you also apply Dr. Welcher's analysis based on that same Shanon Burgess analysis to reach an opinion or a conclusion?
Yes.
And what was your opinion or conclusion with regard to that event and the timing following that event?
Based on all of the data in those two original reports, regardless of what adjustment is made or which 2 points are used to try to correct the clock, the phone lock event always occurs after the end of the event, using their convention of referencing off the end of the event, not the trigger, but it always occurs after.
And that was based on Shanon Burgess's January 2025 report, correct?
Correct.
Sustained.
What was that based on? Which report? We're dealing with two different reports, May and January. I want to make sure we differentiate. Which report are you just now talking about?
I'm talking about the January report.
Now, did Mr. Burgess, were you supplied with a supplemental report by Mr. Burgess?
Yes, I was.
When was that?
Slightly after he issued it, but I don't know the exact date.
Say that again?
It was issued on, his report was dated May 8th, and I think I was provided it a couple days after that. I don't
Okay.
remember the exact date.
So after, well, do you know when this trial started?
No, I don't know the exact date.
I know you're not watching the trial, but it was in the middle of this trial, correct?
Sustained.
I'll ask you a different
Leading.
question.
Ellen
With
is being a
regard
bit
to the
leading.
original report, the January 2025 report, was there any circumstance in which Mr. Burgess and Mr. Welcher could conclude that the lock event on John O'Keefe's phone, that lock event, occurred before the trigger event?
Objection.
Sustained. Ask it differently, Mr. Jackson.
What is your opinion about whether or not there was any analysis done by Mr. Burgess or Mr. Welcher that put the lock event occurring before the trigger?
Objection.
Sustained.
There's nothing wrong with these questions. What's wrong with these questions?
May we approach, Your Honor?
Yes, of course you're going to have to approach because, we're supposed to be reading the mind again. Jackson has been a little bit leading with this witness. It can be a little bit troubling with an expert. It's hard. It's difficult to work through with an expert sometimes. You have to invite them to provide the information that's in their report, but you also have to guide them to what you specifically want to talk about. And so finding that balance can definitely be a little bit tricky. You're also like trying to signal, I understand what you just said, so we can move on and so forth, but you can't really do that. But this is just trying to get to some details of his review of the analysis, the conclusions that he reached. That was a very open very open question, the way that he phrased it. So I don't know whether there was any analysis.
May I, Your Honor?
Yes.
Thank you. Back to my question. Was there any circumstance based on your review that if the tech stream event occurred at 12:31:38, that there was any circumstance that the lock event occurred before that trigger event?
There was not.
Did you create a PowerPoint for clarity's sake in March of 2025?
Yes,
Did you provide that to us?
I did.
What was the purpose of creating the PowerPoint?
The purpose of the PowerPoint was really to take a bunch of different data elements that were kind of placed throughout Mr. Burgess's report and Dr. Welcher's report in PowerPoint, and compile them into a single source, a single table, essentially, to show as clearly as possible what the conclusions would be if we look at the data as a whole.
When you created that PowerPoint presentation, did you create it with the intention of providing it to the defense, which would then be provided to the Commonwealth?
Yes.
Are you aware of whether or not that was disclosed to the Commonwealth as part of the normal discovery process?
No.
So the answer is no, the answer is.
Following your
The
presentation,
tank would never ask a question like that.
the PowerPoint to us, at some point, did you receive from Mr. Burgess an amended report, an amended PowerPoint?
I received an amended PowerPoint by Mr. Burgess, not from him, though, from you.
Fair enough, fair enough. Did that report, or did that PowerPoint, however you want to put it, markedly, was it any different than
Markedly.
his January 2025 report?
Yes.
Did you note any conclusions? Did you note the conclusions that he came to in January 2025? Going back to the original report?
Yes.
Did you note conclusions and opinions that he came to in May of 2025?
Yes.
Were those two things different?
Sustained.
Were the conclusions, not his opinions, were his conclusions different?
Sustained.
What's wrong with
Was there any
that?
difference in the two reports?
There was.
Tell me the differences.
In the first report, Mr. Burgess did some of the calculations that are necessary to correct or adjust to the times based on certain approaches, but never went through the final step of applying those calculations to the times and coming up with a final time. In the supplemental report, he then essentially took that analysis to the end. He approached it in a new way, a different way than he had previously laid out in the first report, but then he also took it all the way to the end by applying those calculations to the times.
What were the main differences? Explain for the court and for the jurors, what were the main differences that he changed in the May 2025 report?
Contrasting it with the original
Correct.
report. In the original report, he laid out some methodologies for correcting the clock using phone calls that were shared between the vehicle and Mr. O'Keefe's phone. And in the supplemental report, he moved away from the phone call analysis and moved to attempting to align the clocks using a shared maneuver between the vehicle and the phone.
What was the shared maneuver?
It was a 3-point turn.
Was that the same analysis that he had in January 2025?
He did not have that analysis in the January 2025 report.
Thank you. Based on the new information in the May 2025 report, what was the effect, as you see it, regarding the possible scenarios?
So I did the exact same process I did using the supplemental report as I did on the first report. And when I ran all those numbers and those calculations, it turned out there are now some scenarios in which the phone lock occurs after the end of the event. There's some scenarios where the phone lock occurs simultaneously, like literally at the same second. And there are some scenarios where it occurs before. So now there's a range.
So Mr. Burgess's report, his new report, his amended report, widened that gap to allow him to opine that there were scenarios that occurred after the phone lock event, correct?
Objection.
The objection is sustained.
Did you prepare a PowerPoint presentation in furtherance of clarifying Mr. Burgess's analysis?
Objection.
Sustained.
Did you seek to clarify Mr. Burgess's analysis?
Objection.
Sustained.
Your Honor, may we approach?
Yes.
What is wrong with this question? What's wrong with this question? Seek to clarify his analysis? It's not leading. It's not leading. What, you think that's too loaded? You think that's too loaded coming from Hank Brennan? Who's like, witness, before you got out of bed and ate babies and otherwise demonstrated yourself to be the devil that you are, did you first do a calculation of the event data recorder? Coming from Hank, is that really too loaded? Clarify his analysis? Did you make a PowerPoint to assist with understanding what you did? Your role here was to review the analysis. Did you find it confusing? Yes. Then how did you clarify it? I mean, this is just unnecessarily nitpicky. Unnecessarily nitpicky. I saw as soon as Hank was saying that, I happened to see, oh yeah, there's this article, April 1st of 2025, the effects of collision-related power loss on Toyota Safety Sense 2.5 plus event data. Huh. Mr. Alessi in the cobalt blue today.
Yeah.
Yes.
Did you prepare a PowerPoint presentation in furtherance of your analysis?
Yes.
What was the reason, or what was the purpose for your PowerPoint presentation?
I needed to include in my analysis the approach and the conclusions from the supplemental report by Mr. Burgess.
May I have a moment, Your Honor?
Yes.
May I approach?
Yes.
If you wouldn't mind taking a look at that document, it's a multi-page document I just handed you, and just flip through it and let me know once you've familiarized yourself with it. What is that document?
This is a printout of the PowerPoint presentation that I prepared.
Is it true and accurate?
Yes,
And it's complete?
it appears to be.
Your Honor, I would move for its admission, please.
I have no objection.
Okay.
May I have that back, please? Just a quick second.
208.
Thank you.
They've already got his report. Now they get his PowerPoint.
Your Honor, permission to display the PowerPoint presentation?
Okay.
Mr. DiSogra, can you still see with the lights off sufficient to see what's on the screen and what's in front of you?
Yes.
Okay. Do you recognize what's on the screen?
Yes.
What is that?
That is the title page of the PowerPoint that I prepared.
And what
That's your
is
cue, cameraman.
how would you describe the PowerPoint?
So this PowerPoint is largely identical to the first PowerPoint I prepared in that it seeks to take all of the different approaches between the initial Burgess report, the supplemental Burgess report, and Dr. Welcher's report, lay out all of those approaches in one kind of coherent fashion so we can look at what conclusions we can draw from all of that data.
With court's permission, can we go to slide 2?
Yes. Mr. Jackson, you can just use this PowerPoint. It's in evidence. You don't have to ask slide to slide.
Thank you, Your Honor. Taking a look at this next slide.
How magnanimous of her.
Looking at?
This is a slide from Dr. Welcher's presentation that I was provided. Specifically, this is his slide number 33.
And what does it show?
This is where he introduces the first, acknowledgement that there's a difference between the time that Aperture calculated for the end of event 1162-2 and the lock event on Mr. O'Keefe's cell phone.
Is there anything in this slide that you disagree with in Mr. Welcher's presentation that you disagree with? It's up on the...
I added the 2 green boxes and the text, the word after. That's not Dr. Welcher's. And I added that because it's stated here that the event occurred within 26 seconds. But if we do the math, and he actually does the math, he really means after. It means the phone lock event occurred
26 seconds of the end.
26 seconds after the end of the vehicle event as calculated.
We'll strike.
No, I'm going to allow it.
The phone interaction happens how many seconds after the text stream event?
Based on this slide, 26 seconds.
Thank you. And the text stream event that we're talking about is what number?
1162-2.
And this slide, other than the green, is this slide or the portion of the slide that we're looking at, other than what you've described, is this directly from Mr. Welcher's own analysis or his PowerPoint?
Right. I added the green box around within, the dashed green box around the whole paragraph, the line, and the words after. Those are my additions.
Let's go to the next slide. Can you tell us what this is?
This is more or less a repeat of what's on the first slide, but just shown with a little more focus. The first slide is a little busy. So
I'm sorry, Mr. DiSogra, did you create this or is this from Dr. Welcher's report?
I created everything on this slide apart from in the top right. That came from Dr. Welcher's slide 33.
Although you created the slide, where's the data coming from for this slide?
All of the data on this slide and all of my subsequent slides comes from the Aperture reports collectively, either Dr. Welcher's report or slides or Mr. Burgess's first and second reports.
What did their analysis reveal in terms of the exact time of the lock event for Mr. O'Keefe's phone?
So in their analysis, in Aperture's analysis, they report the Lexus event 1162-2 ends at 12:31:43. And they also report there's a phone lock at 12:32:09. So if we just simply take the difference in those two times, we get 26 seconds.
If you were to add the 5 seconds back to 12:31:38, which is the actual trigger event, what would you come up with?
31 seconds.
Which of the two, in your expert opinion, which of those two numbers is more accurate as it relates to the trigger event?
If we wanted to conduct the analysis relative to the trigger, it would be better to use the actual trigger time. However, as long as we're consistent through the analysis, it's not entirely wrong to use the end. It would be wrong if I suddenly switched up and started talking about this relative to the trigger event, but they present it as the end of the event, so I conduct the rest of my analysis using that convention.
Is another word for the end of the event the end of the recording?
End of the recording, yeah. When I say event, what I mean by that is the data event, the data recording event.
But the trigger event itself, 12/31/38.
Correct.
Okay. Did you put a name on this gap, if you will, this time frame?
Yes, I did. For the sake of the rest of the analysis that I'm going to do, I thought it would be helpful to just refer to this difference in time as John's interaction window.
And that refers directly to the interaction with the phone, the human interaction of locking the phone.
The 12/32/09 lock.
Okay, let's go to the next slide, please.
That's your cue, cameraman.
What does this slide show us?
So here, what I'm doing is I'm kind of laying out the bounds of what I mean in John's interaction window, which should make, you have a lot of numbers to go through here. And so this should give us a very easy metric for kind of determining whether we have an event before or after. So what I mean by that is when we calculate John's interaction window, if that number comes out and is positive, that means the phone interaction occurs after the end of the vehicle event. And if we calculate John's interaction window and that number becomes a negative value, then that means the phone interaction occurs before. So now we have just a convention we can use really quickly to say, is it positive or is it negative? And we can maybe spare ourselves some of the math with 1,000 numbers.
So positive means what? One more time.
Positive, John's interaction window positive means the phone lock occurs after the end of vehicle event 1162-2.
Got it.
You know we're going to look at more
slide,
slides, cameraman, so just keep it over there. Stop with the scanning.
So what I'm saying here, I'm kind of laying the foundation for why we're going to even do this. Why do we need to start doing math on these clocks? So fundamentally, the phone, Mr. O'Keefe's phone, and the vehicle, Ms. Reed's vehicle, they're separate clocks. And it's very unlikely that they're going to be aligned perfectly in time. Right? If I compared my watch to your watch, it would probably be off. And that's the same case for any two independent clock sources. So Aperture, in their collective reports, propose a number of different ways in which that can be corrected. So I'm going to go through all of those ways that Aperture has proposed and show if we align the clocks based on how they laid out, does John's interaction window stay positive or does it ever become negative? Where does it end up when we run all those analyses? Or another way to put it is, does the phone interaction always occur after the end of the vehicle event?
And what did you determine?
Based on the initial reports,
yes,
the phone interaction always occurs after the end of the vehicle event.
Did all of the information that's on this slide come from the same source or multiple sources, meaning Mr. Burgess and Dr. Welcher?
In the PowerPoint as a whole, all the information comes from the Aperture reports collectively.
Okay.
From Dr. Welcher and Mr. Burgess.
Did Mr. Burgess make any adjustments from his original report to his subsequent report in May of 2025?
Yes.
Let's go to slide 6, please. Tell me about this slide.
Yeah, so this is the first adjustment we're going to talk about. And this one comes from Mr. Burgess's original report. And to summarize this adjustment, this is a key on timing adjustment. And we're going to show that the key on, the actual turning of the vehicle on, occurs about 3 seconds before that time gets registered in the infotainment. So the time we see is basically stale by 3 seconds.
We're all familiar with how computers turn on. When you say key on, do you mean a physical key or could it be the push button to turn the car on?
In this case, it's a button. I refer to key on because generally that event is considered the key on in vehicle parlance, regardless of whether there's a physical key or it's a push button.
So those 3 seconds mean what? What's the difference between pushing that button and the 3 seconds later that you just described to the jury?
It means that when we're trying to use the timestamps that were recovered from the infotainment system that show when the vehicle was keyed on or turned on, that the vehicle was actually or likely turned on 3 seconds before that.
Do you know where the 3 second conclusion came from in Mr. Burgess's report?
That came from the testing that Aperture conducted with the exemplar Lexus that they purchased.
Was there anything in the report that indicated testing, this type of exact testing on Ms. Reed's actual Lexus?
No.
Do you have an opinion as to whether or not all Lexuses, at least of this make and model and year, would have the exact same 3 second delay, or could that be different?
It could be different in their testing. In their testing, they only tested one exemplar vehicle. So I think there was a solid foundation that the exemplar that was used exhibited this 3 second delay. It was a very close match in terms of part numbers and software versions to Ms. Reed's Lexus, but without any kind of testing of, let's say, a second vehicle, a second exemplar, we wouldn't know, we wouldn't have any basis to say it must be 3. We could test a second vehicle and it could be 5. So we say, well, there's a delay, but it varies vehicle to vehicle. They could have tested a second vehicle and found it's also 3, and then you start to build some confidence that maybe it is 3 across every vehicle. But with only testing one and not testing the subject vehicle, it is difficult to say with absolute certainty it would be 3 seconds.
What is your opinion about best practices with regard to trying to create this gap for purposes of coming to an opinion or an analysis?
So because we don't know whether or not this specifically would apply to Ms. Reed's vehicle, the best way to conduct that analysis would be to do the entire thing with the key switch adjustment at 3 seconds. Because if we're going to use a value, 3 is the most reasonable one because that's the one shown in testing. But we should also do the entire analysis without it in case we feel that that's the most appropriate. So in fact, that's what I do and will show is I ran the analysis both ways, with and without, to be as conservative as possible.
Did your review of Mr. Burgess's report indicate that he ran the analysis both ways?
He did not.
Let's go to slide 7. What are we looking at here?
This is an excerpt from Mr. Burgess's original report. His
you woke
page
up, camera
28
guy?
and his page, there's a screenshot also from his page 30 at the bottom. And this is where he states in that report that when they were doing the testing with the exemplar, they observed across 4 different key-on cycles this 3 second difference. So what I mean by that is they had a video camera in the car that had a timer on it. And so in the video, you can see the button pressed. So in their testing, for example, they pressed the button at 21:48:05, and that's sort of nailed down. When they went back and downloaded the data from the infotainment, the key on was logged in the infotainment as 21:48:08.
They're doing
So
this
there's the
testing
3
at
seconds.
10
That's
at
where they're
night.
getting that from. And that's what he states highlighted in red there. It's a little hard to read, but it basically says the average across 4 runs was 3 seconds.
The 3 second delay, was that actually in his report?
This is the only point in the report it's mentioned.
And I guess what I'm asking, it was an inartful question. The portion to the left, is that his report or your report?
That is his report. Everything on the left-hand side of this slide comes from Mr. Burgess's report.
So the 3 second delay was noted in his report.
It was noted.
Did he apply the 3 seconds in his analysis?
He did not.
Did he indicate in his report why he ignored that 3 second delay?
He did not.
Sustained as to that question.
I'll rephrase it.
Strike the answer.
Did he indicate in his report the reason that he did not apply the 3 second correction?
He did not.
When you do apply the 3-second correction, what do you come up with as it relates to the 26 seconds from the end of the recording?
So the positive 26-second window, if we only apply the 3-second key on, grows to positive 29 seconds.
If you applied the same 3 seconds to the trigger event time, now what does the gap?
The gap would grow to a positive 34 seconds.
Between the trigger event and what?
The phone lock.
In
Do we
your
know
opinion,
if we should apply it to the trigger event?
was it best practice to not account for that 3-second delay between the on switch and the data coming on?
Sustained, ask you to.
What, in your opinion, would be the best practice in terms of this 3 seconds that was noted in the exemplar vehicle?
The best practice would be to run the analysis with that adjustment included and without that adjustment included. Because like I stated, without testing of an additional vehicle, we really don't know if the 3 seconds is just a specific behavior of that exemplar or if it's representative of all Lexuses of this type.
Let's go to slide 8, please. Tell us what we're looking at in this slide.
So now we're going to get into the next adjustments. That first adjustment we just talked about was really a vehicle-to-vehicle adjustment. We haven't talked about the phone yet. We're going to get into the phone now and talk about aligning that. But we had to get through the internal adjustment that has to get done first. Now we're going to look on the subsequent slides here at all of the different ways the Aperture reports compared the vehicle to Mr. O'Keefe's phone.
Is there any additional adjustment that you believe should be made?
The Aperture reports lay out 2 methodologies for adjusting. There is a methodology based on phone calls, and there's a methodology based on the 3-point turn.
And where did you get that information from?
From the Aperture reports.
In Mr. Burgess's original report on differentiating, the January report, which did he use to determine his determination of the clock skew?
In his initial January report, he never actually takes the calculation to the end by applying the differences in times to the calculated time for 1162-2, but he does do the math, which I'll show, for the differences on these phone calls.
In terms of Dr. Welcher's report, did he identify a GPS point of 154 at all?
Yes.
How did he describe that GPS data point?
He describes in his initial PowerPoint slides as 0.154 aligning with the end of vehicle event 1162-1, talking about a different event now. This is the 3-point turn event. So he uses that as an anchor point.
And that anchor point, you said, was the end of the text stream event, or the end of the recording of that text stream event.
Correct. The Aperture reports consistently reference everything from the end of the events.
Let's go to slide 9, please. What are we looking at here?
On the left is an excerpt of page 33 from Mr. Burgess's initial report. And what he shows here is he has identified 7 call logs that exist both in the infotainment from Ms. Reed's Lexus and in Mr. O'Keefe's phone. He puts them in a table form. Then he actually goes on and calculates the difference between those 2 times. So that's what I meant by he sort of does the math. He makes my job a little easier, and the numbers are already there. He just never applies these to any of the times. So that's where I step in and say, if I take that 3rd column that he lays out Those are in seconds. If I apply those seconds, that adjustment to 12:31:43, where do we end up with John's interaction window in those times?
What did you conclude in terms of finishing the work?
Sure, I did all of them. And so I highlight on this particular slide, I just highlighted the very first one he has in here. In that case, he identified that Mr. O'Keefe's phone was 2 seconds slow relative to the infotainment system. So if we apply only that adjustment, then John's interaction window becomes positive 28 seconds.
Did Mr. Burgess apply all of the potential offsets?
He didn't apply any of the offsets. He calculated all of them, but he didn't apply any of them.
Did you ultimately apply all of the offsets?
Yes, I did.
And what did you determine?
Regardless of which offset you apply, John's interaction window remains positive. The number changes, but it remains positive.
Let's take a look at those one at a time if we can. Let's have the next slide.
So on this slide, I just took the other end of the spectrum. There's a large range in values in this table. He doesn't actually, Mr. Burgess doesn't show the sign conventions on here, but actually
sign conventions.
Sign conventions, he doesn't show when he calculates the difference, whether it's positive or negative. All the numbers in the table don't have a sign, don't have a plus or minus in front of them, but there's an implication. Some of them are plus, some of them are minus. So the first one, that we just looked at showed we had 2 seconds slow. There's another value in here that's on the other end of that. It shows that Mr. O'Keefe's phone is 21 seconds fast now relative to the infotainment. So that's the largest value in the table we could take that would bring John's interaction window down now. And so if we apply just that adjustment, John's interaction window becomes a positive 5.
Take a look at slide 11, if we could, please. What are we looking at here?
So I've shifted now from the phone calls, and now we're going to talk about the 3-point turn alignment. And the 3-point turn alignment is first presented in Dr. Welcher's slide from his presentation here. And in this, he doesn't say it explicitly, but he provides some math on the screen, which is a little hard to read. But he puts some math on the screen that shows he's aligning this 0.154 from Mr. O'Keefe's phone to the end of event 1162-1. This is the prior event. This is a 3-point turn. And so he aligns, he says this is basically how you align it, and he doesn't do the math. Again, he lays out that he says a 19.2 second difference. I actually just adjusted that to 20, which is the most conservative way to interpret that. I don't think we have the accuracy here to talk about tenths of a second. Nevertheless, I just rounded that up to 20, and when we apply that 20 seconds to our event 1162-2, then John's interaction window becomes positive 6. That's just applying this. We're not combining anything. We're just applying the difference shown in this slide.
And that positive interaction window, is that calculated based on information directly from Dr. Welcher's report?
Yes.
Let's go to slide 12. What are we looking at here? What is this table?
This is a table I made. We've talked about a lot of different approaches to how these clocks can be aligned and a lot of different variables. So I tried to summarize them in one table, put them all together, because some of them we can combine. We can combine the key on with either a phone call or a 3-point turn, but we can't combine, for example, a 3-point turn and a phone call. That's not valid. So I put all the possible combinations, all of them, without key switch, phone calls, and 0.154 on one table, and I calculated John's interaction window for all valid combinations from the Aperture reports. And when we do that, the result is that regardless of what adjustment we make, all of the numbers are positive, meaning regardless of what adjustment we make, The phone lock event always occurs after the end of event 1162-2.
Did Mr. Burgess, in your review of his report in January of 2025, did he ever undertake all possible offset calculations?
No.
Let me
In
guess.
his May 2025 report, did he undertake all possible offset calculations?
No.
What is your opinion in terms of best practices regarding calculations of this sort?
I think if there's sufficient data, if there's testing or research or literature that in a specific case supports there is a best path or a best method, then we should use that. In this case, I don't think there is a best practice. There isn't any literature I'm aware of that would specify exactly the best path to align all of these. So in the absence of any external data to support one path, the most valid approach is look at all of them as a whole and then draw the conclusion from the totality of that data rather than cherry picking a single point.
Can you testify to a reasonable degree of scientific certainty whether all potential offsets that were described in Aperture's original report, January of 2025, result in a positive interaction window?
Yes.
And what is that opinion?
Regardless of what adjustment or combination of adjustments we make from the original reports, Sean's interaction window remains positive.
Does the positive interaction window mean the lock event occurred after or before the text stream event?
It means the lock event occurs after the end of the text stream event, 1162-2.
You've already indicated that you received a second report, May of 2025, correct?
That's correct.
In that report, is there the same clock skew alignment or a different clock skew alignment that Mr. Burgess now undertakes?
Mr. Burgess undertakes a different alignment in that report.
Let's go to slide 13. Describe what we're looking at in this slide.
So what I have here on the left is a screenshot of page 42 from Mr. Burgess's supplemental report. And so now he's done two things new here. He's identified a new method for aligning the data based on the 3-point turn. So now he's kind of following where Dr. Welcher started. But he's approaching it a little differently. And secondly, he is now calculating the actual time. He's doing the difference calculation and he's applying that to the time. So now he's taking the calculation all the way through, which is a little different from the prior reports. And so when he does that, he makes my job really easy because I didn't have to do really any math now. He comes up that there is a range now. So prior to this point, the original report by Mr. Burgess and Dr. Welcher reports all used discrete points in time, right? They sought to find an event that occurs at a singular second and another event at a singular second and align based on that. This is a little bit of a departure from that approach. Mr. Burgess is now using a range of times, a range of uncertainty. He basically assesses that the 3-point turn data from the phone and the 3-point turn data in 1162-1 cannot be precisely aligned down to a single point. Rather, they overlap in this range of seconds. And so he then says that range must be applied. So now we have to apply a range. And what we end up with is 9 possible values. So it kind of looks like one conclusion, but really there's 9 conclusions on this slide. And so if we just applying the math he has in the supplemental report, John's interaction window now has a range of 9 possible values. And that range spans from +5 now to -3. So we have 5 positive values. We have 1 value that's 0, and the 0 would mean it's simultaneous. And then we have 3 negative values.
Does Mr. Burgess indicate in his report that any one of those values is more likely than any of the other values?
He does not provide any data or analysis to support one point being preferential over the other 8.
And are there more or fewer positive results in his analysis than negative?
There are more positive numbers in that range of 9 than there are negative numbers.
Does Mr. Burgess's new data indicate anything about Dr. Welcher's analysis about the GPS data point 154 being at the end of the 3-point term?
He opines in that aligning the 3-point turn on a singular point is not, and I'm paraphrasing because I don't know the exact way he states it, but not the preferred method.
Is Mr. Burgess's analysis consistent or inconsistent with Mr. Welcher's determination that GPS point 154 was at the end of the text stream event?
Objection.
Sustained.
Does Mr. Burgess in his report indicate whether he agrees or disagrees with Dr. Welcher's analysis?
I don't remember specifically.
In your opinion, I asked you about Mr. Burgess's report. Now I'm going to ask you about your opinion. In your opinion, is this new offset any more likely or reasonable than any other offsets previously proposed by Mr. Burgess?
I don't think it is more or less likely. I think it is a valid approach, certainly. And so I think the results from the additional analysis should be included with the analysis of all of the results so far.
And none of those results are more or less likely than any of the others, correct?
Sustained.
Are any of the results, in your opinion, to a reasonable degree of scientific certainty, are any of the results any more or less likely than any of the others?
In my opinion, they're all equally weighted.
Did Mr. Burgess account for the 3-second offset that we talked about earlier in his May 2025 report, his new report?
I did not see any mention of that in his supplemental report, and certainly the 3 seconds isn't present in his math. I don't see it there.
Let's go on to slide 14, please. Describe what we're looking at here in this table.
This is very similar to the table we looked at previously, where I look at all possible combinations. Now, however, I just have a lot more data points to show, so I've had to break the table into 2 tables. So we're going to look at this, and we'll look at slide 15 next, which is the second table. I just couldn't cram 30 lines onto one slide.
Let's move to the next slide then. Is this a continuation of the
second half? So think of these as a singular table. I just had to split them up. If we head back to slide 14, we'll start there. So this slide, I'm not accounting for the key on, and that's the main difference between my 2 tables. Table 1, I'm not accounting for the 3-second key on. In table 2, I am.
When you say key on, you're talking about that 3-second delay.
Correct.
Okay, go ahead.
But again, I want to make sure we're thinking about this as a singular table because that's where we'll draw our conclusions from. So the first lines of the table, we've already seen those. Those were in my original table. I haven't changed those. That's the same math that's been there. All I did was I added the 9 points now from Mr. Burgess's supplemental report using the range he shows. And so now we can see if we include that, now we get some positive numbers for John's interaction window. We get that 0. And again, the 0 would imply that the end of event 1162-2 is happening exactly at the same second as the phone lock. So it's kind of not on one side or the other. So I think it should be thought of as separate. And then we have 3 negative values, which would imply that phone lock occurs before the end of 1162-2.
And did you already mention the one that was simultaneous?
When John's interaction window is 0, correct?
0.
That would imply simultaneity.
All right, is this 14 or 15? This 14, let's move to 15. Now, this is a
Same.
continuation of that. Mentally, we'll just continue that same table?
Correct.
Okay.
Just a continuation. Imagine in your mind is just rows 16 to 30.
Okay.
And it's the same thing, same format, except for now we're just adding in that key on adjustment because, again, I think the analysis should be run with and without it. And so now when we run this with the key on adjustment, we get 14 of these 15 are John's interaction window is positive to various degrees. And one of them, it's 0, again, simultaneous. And there are no negative values with this adjustment.
Can we go to the next slide, 16, please? What are we looking at here?
This is the summary then of that table, kind of a verbal summary of the giant 30-line table now. And if we look at all of the possibilities from all of the Aperture reports collectively, then we can draw some pretty straightforward conclusions. 25 of those 30 possibilities result in interaction with the O'Keefe phone after the end of event 1162-2. Looking at all the possibilities, 2 of the 30 result in interaction where it's simultaneous. That's the zeros, they're present in both tables. And then looking at all 30, 3 of the 30 result in interaction with the phone before
Pretty
the
small
end of event
minority of
1162-2.
possibilities.
Do you have an opinion as to which of these particular offsets that you've described, these 30 possibilities, should be applied in this case?
No.
Why is that?
Each of the approaches have their own individual strengths, and each of them have their own individual weaknesses. And there is not really any published literature, any research, or any testing done that I'm aware of that would suggest one really stands head and shoulders above another one of the methods. So I think the most fair way to present it is to look at, again, if we combine everything together, then we can draw some conclusions like this in terms of how many of the total result in one outcome or another.
Is every data point that we're looking at and that you've been talking about, are these all drawn directly from Aperture's reports?
That's correct. I have not proposed any methods for aligning the clocks myself. All of the methods that comprise these 30 are from the Aperture reports themselves.
Based on your analysis of the Aperture, or your review of the Aperture analysis, is there any ability to say to a reasonable degree of scientific certainty that the text stream event occurred after the last physical interaction with John O'Keefe's phone?
Yes, there would be three out of the 30 possibilities would result in that.
Do you have an opinion to a reasonable degree of scientific certainty that it did happen after the text stream event?
Okay. Sustained.
Is that something an expert can opine on?
Of the 30,
which one of these?
what's the percentage of possible events that occurred, possible scenarios, I should say, wherein the text stream event occurred after the last interaction with John's phone? What's the percentage?
That's sustained.
You said it's 3 out of 30, correct?
Yes,
Is that 10%?
that is 10%.
Yeah, it's sustained and a move is stricken.
What percentage is 3? Just
He
do
doesn't know
basic
why he
math
can't
for
do
me.
math on the
What
stand
is the
either.
percentage between 3 and 30?
Sustained.
If I told you hypothetically,
Look at how bemused he is.
I'm going to see you type out for a second.
He can't opine about the opinion that Shanon Burgess gave on the stand that he believes it's more likely that the trigger event occurred after, or the phone lock occurred after the end of the trigger event. He's not allowed to opine on that. He's not allowed to do the math about what percentage of the possibilities give you that particular outcome. Oh. And does anybody know what the problem is with this line of questioning? No, of course we don't. Of course we don't, because Mr. Brennan is not having to state the basis of any kind of objection. So it isn't being required. I'm going to go back and see what I can find in Burgess's direct. So many notes from the cross, taking me a while to get to what he said on the direct. So we remember he looked all of this, he looked at all of this on his own initiative. It had nothing to do with getting Matt DiSogra's report and understanding, oops, we got a lock event occurring after this catastrophic collision that we're trying to establish. So what are we able to do with that? Okay, so going through doing the adjustment, he gets a 21 to 29 second variance. He gets a 12:32:04 to 12:32:12 on Johnathan's phone, 12:32:09 being the last lock event. And that's all he basically said. He didn't explain the range at all. And apparently this guy's not going to be allowed to explain the range either.
Following your analysis of the totality of the possible scenarios, did you come to a conclusion that the vast majority, let me rephrase that, did you come to any conclusion about the numbers as they relate to the positive interactions versus the negative? And when I say positive versus negative, I'm talking about the phraseology that you used. John's phone interaction being in the positive side versus John's phone interaction being in the negative side.
Yes.
And what were those?
Of
Leading
the
was
30
the problem?
possibilities, 25 of them, it's a positive. John's interaction window is positive for 25 of them.
And only 3 were negative?
Correct. Only 3 of the 30 were negative.
Okay. Okay, we can take that slide down. Is there a data recorder on the Toyota SUV that we've been talking about, that 2021 Toyota SUV 570, that's designed to record impact?
Yes.
What is that? What is that mechanism?
That would be the airbag control module,
The ACM?
ACM.
Did you look at that?
I was provided a copy of the download from the ACM.
What did the data recorder indicate, if anything, related to any impact on January 29th, 2022?
There were no recorded events whatsoever on the ACM.
Did the vehicle control history record whether there was any history of a collision on that car, ever?
No.
What does the vehicle control history record specifically?
It records a lot of operational parameters about the vehicle. What I mean by that is it records things like what the driver is doing, for example, steering wheel angle, accelerator pedal position, whether the brake is being pressed. It also records what the vehicle is doing, for example, speed, or the engine RPM, or the accelerations of it.
does the text stream data event indicate that there's a, and I'm talking about very specifically the text stream data, does that indicate whether or not there's a collision in the car?
No.
Does the text stream data event mean that if you find a text stream data event or a trigger event, does that mean that the airbags are deployed?
No.
Does it mean that the vehicle impacted with something solid?
No.
Does it mean that the vehicle impacted with a pedestrian?
No.
You reviewed the raw text stream data associated with the entirety of Ms. Reed's vehicle, did you not?
Yes.
How many text stream events or triggers were found on Ms. Reed's vehicle during the course of the 8-month period prior to January 29th?
Objection.
So can you narrow that, Mr. Jackson?
Sure.
Why?
Objection to the whole line.
And I need to see what's up.
Can establish a baseline. We did talk to, I think, Mr. Burgess about this one in the cross-examination. Remember, is it trigger happy? Is the Lexus trigger happy? And in fact, I thought we heard about it directly from Welcher too, didn't we? Didn't we hear directly from Welcher? So you got all of the data. He acknowledged that there were other trigger events. I think it came up in cross. We acknowledged we had a number. Didn't we have a number like 18? We already know. We already know it exists. It's already in the record. I just don't have it right at the top of my head. Because we had the whole line of questioning about how none of those means that the trigger isn't registering a collision. Okay. Before January 29th of 2022, there were 18 vehicle control history events before the subject one. He didn't conclude that any were the collision. How many of those were forward events? How many of those were reverse? He was going to have to get into his second laptop to answer that question. So they decided it wasn't important. This came up in cross of Welcher. The only event he decided there was a collision was the one on 1162.2. He didn't look at the others because they were so far away with the mileage. Is that why? Is this, we're getting into this whole, if he discounted it, we don't get to ask any questions about why he discounted it? He says they didn't matter, therefore we just pretend it doesn't exist because Judge Welcher gets to decide what are we supposed to find important and what not. It's all I can think of. What this is going on. He didn't rely on it. Part of his opinion, so it's improper rebuttal or something like that. We don't know where it's going at this point. But so far, none of this is anything that Welcher himself didn't already acknowledge on the stand. 18 prior events, but this is the only one he looked at and the only one he decided this one constitutes a collision. I would have liked a question. We already know that there was no ACM event. We've gotten that from everybody. The part of the car that is designed to register impacts, that's its function. It did not register an impact, not only on January 29th, but on any day. It's never registered an impact in this car. So we already know that. The question I have, though, is would you expect one under the framework that the Commonwealth has proposed here with a, clipping pedestrian incident while reversing backwards at 24 miles an hour? I think it's important to know if we should expect one before we can put a lot of weight on whether there is one or not. Because if you wouldn't expect one, and we've talked before about kind of some of the reasons why you might not expect one, because the backing up in reverse, it's going to implicate different safety kinds of considerations than a full frontal while driving at highway speed, type of collision incident. And so I think generally the assumption is it's going to be lower speed when you're going in reverse, more likely. But also the concern, I think, with the backing up is much more about the damage to the person in the back and not so much the person in the vehicle. Because if you're in a frontal collision, momentum's going to carry you forward. You're going to smack your head into the dash or the windshield. So that's why the airbag needs to deploy. It senses that there's about to be, contact, it deploys, and then you protect your skull. But the protection from your rear, from a rear side contact, is your chair. It's your seat. You don't have an airbag in your seat that's going to deploy and keep you safe. So is there any kind of monitoring in the car then that's going to track if I get an impact from the reverse? I can expect maybe it's not going to deploy the airbags, but is there going to be something registered? Now then we have to throw in this whole clipping / side swipe thing. Side impacts, cars now have side airbags. Would you expect that to deploy? What sort of event trigger is required for side airbags to deploy? It would just help put all of this into context to understand if it's significant or
Mr.
not.
Jackson, how much longer? I'm just trying to figure
How
out.
much
I'm wrapping it up,
longer?
Judge.
He's
It's not gonna be
really
long.
going
A few
there?
more questions.
I'm not curbing you in any way. We just
Understand. Respectfully, it won't be very much longer. You reviewed the tech stream data, otherwise known as the triggers, for the entirety of Ms. Reed's vehicle, correct?
Yes.
How many trigger events did you find in the life of the car?
Not counting 1162-2.
Let's stop there. Right.
Prior to 1162-2, there were 19 prior events.
And 19 total events, correct?
Correct.
And how many collisions were clocked by any recorder on that car?
None of the events were triggered by a collision.
And last question, do any of the tech stream events or any of the data that you've reviewed, either yourself through Mr. Burgess's report, through Dr. Welcher's report, do any of the data indicate that there was a collision on January 29th, 2022 at any time? Objection.
ask it differently.
What did you find in terms of, I want to narrow this question to January 29th, 2022. What did you find in terms of any data regarding a collision?
Neither of the events that occurred on that date were triggered by a collision.
Thank you. May I have just a moment, Your Honor?
Okay.
I hope so too. And then compare it with how many times she does it to the Commonwealth, because I don't recall she's ever done it to the Commonwealth.
Jurors, we're going to take the morning recess. There's some things that I need to do with the lawyers. That we'll have you come back at 12.
Jury.
Taking our morning recess.
Can I see counsel at sidebar to save us some time, please?
Save us some time. Now we're all concerned about the time after we were ahead of things just a few short hours ago. Few short court hours ago, we were ahead of schedule, but now we need to keep things moving and see you at sidebar to save time. Well, so Mr. DiSogra, apparently limited purely to rebuttal of Shanon Burgess, did not go in and do anything independent. Guess that is kind of how the distinction maybe between ARCA, what ARCA was going to do, and what Mr. DiSogra was going to do, because we already know then that whole issue with the timing of everything, and they get this May 8th report, and ARCA needs to do additional testing and so forth, and so they're going to produce late, all of this back and forth. And so we know they've done their own independent work. We don't know at this point if they're going to be allowed to testify about any of it, or if there's going to be a little bit of interference coming from the bench. Well, so where did we get from this direct? He's this highly qualified guy, does all of these different certifications, but all he did was just review the work of Aperture. So all he did is critique what they did and explain a little bit more, I guess, about what they did, break down the significance of it. It's not anything that we haven't heard so far, because we heard it all on cross when Mr. Alessi was crossing Shanon Burgess or Dr. Welcher. When we were at that point in time, he kind of pre-elicited all of these things because they, of course, are aware of the criticism and they have their own response to it. So we already kind of knew that, there's procedural shenanigans with the clock skew analysis, but then also a little bit of kind of the detail of what exactly they did. They shift methods between the January report and the May report. They go from these fixed points of a phone call to the range of points that you have with the 3-point turn, etc. Surprised he thought that was valid. Does not seem remotely valid to me as a way to evaluate the clock skew, because it just incorporates so many more variables, doesn't it? I don't know how you account for all those, but hey, he's the engineer, so he's the one that knows if it's going to work or if it's not. I'm a little bit confused about the 3-second key on offset that's proposed. So I understand this. I remember it from Shanon Burgess's testimony. You turn the car on. We talked about this. Kind of works like that in my own car. If you just push the power button, it doesn't come on right away. It takes some time for the infotainment system to boot on. And I was told it had something to do with the battery, how the battery power works or whatever. Is she going to say anything? No, they're just going to go straight to but I have a little workaround in my car because I have a manual. And so you can just push the button without hitting the clutch. So it doesn't actually start the car, but it gets the power going. And then you hit the clutch and push the power button and the car fires up and the infotainment system starts at the same time. So that's my little workaround on my car. But, so we're kind of familiar with this, but it's not clear to me that offset applies to then every single event that's recorded by the infotainment system, or if it's just the power on, power off event. I didn't get it clear, because this is where we get timestamps from the infotainment system. We didn't get them on the text stream, right? We only got them from the infotainment. So he describes needing to do this sort of 3-second eternal adjustment to make sure that the text stream and the infotainment clocks are reconciled to each other. And he says that Mr. Burgess has acknowledged that this 3-second difference between those particular measurements, I guess, exist, but did not apply any of that in his math. He didn't see it in the math. He didn't see it being accounted for. But it's not clear to me. It's not clear to me the relationship is the text stream. Okay, here's the question, because the text stream is the one that has the running clock. And so it's recording, maybe this answers the question. It's recording the data. So the 1162.1162.2 event, it's measuring that on a running clock from the point of the ignition being on. Like, is that what we have here, that the ignition being turned on is the point that we can sync between these two clocks? It makes sense. It makes sense that that's what we do. So then the running clock is based on the actual power on and not when the infotainment system records the power on. Is that why? Is that how these two reconcile to each other? It just hasn't really been crystal clear to me. I think that makes sense, but I haven't seen it like explicitly spelled out like this. But that would then make sense, because if the running clock is triggered by the ignition being turned on, that's going to be, the continuous. The clock is going to run continuously. And so the 3-second offset would apply then to every, second in that running clock to try to compare those things. Is that about where we're at? But then in that scenario, aren't we kind of taking the text stream running clock? The text stream running clock is the accurate one. So we're adjusting the infotainment system time back by 3 seconds to accommodate that lag in the time that it turns on and it turns off. So the timestamp itself, and then to the extent we just add the running clock onto the timestamp to kind of correspond the infotainment and the text stream, that's how we get times for the text stream events. I think I'd maybe just figure that out. I don't feel like this has really been crystal clear. Maybe it is. Maybe it's just me. I didn't really see, like, why does this one measurement mean we have to adjust the whole clock? But if I think it through, I guess I can make sense out of it. From a pure science standpoint, it seems pretty clear that running all of the possibilities, if you don't have any reason to choose one over the other, is the thing to do. That is the scientific, unbiased thing to do. Is just establish if there are different possibilities, different ranges, then what are they all? If there is some reason to identify one as being more likely than the other, one being more valid, one being a better method, then we would go with that. And that would be, again, purely from an engineering standpoint. If there's a reason in the data or in the methodology or something like that would be able to tell you, hey, this one is the one within the range of possibilities it's more likely, then you could maybe just go ahead and report that, or you'd report, why you think it's the most likely. But you know, notice what none of that has anything to do with. It has nothing to do with, well, I think maybe this one is more likely because Jen McCabe testified to something and then other people testified to things and there was some trace DNA on the taillight. Those are definitely not the sorts of things that he discussed as being a reason why you, an engineer, might choose between these different possibilities. Now, it may very well be part of what the jury considers if they need to try to decide. But that's not your job as the engineer to incorporate all this non-engineering, non-technical, non-scientific data that you take it upon yourself to be the truth finder and use that as a basis to say this one is more likely than these other ones. That's not the scientific way to do it. Scientific way to do it is to say these are all possibilities. I think it's visually very effective to point out, look, here's every possible scenario that these guys, their own work analyzed. I didn't make this stuff up. I didn't choose what to analyze with what. Got some more insight now, once again, into Burgess. Burgess likes to blame other people for his mistakes, doesn't he? Aperture is to blame for his resume problems, if not just the rest of us for not, taking his word that he's totally working on that degree, bro, for like 17 years. He's totally been working on it. We misinterpreted what he was saying, not that, yeah, maybe you shouldn't have put that on your resume at all. It's not even a degree offered by this institution. Blames other people for that. Blamed Gaffney for the chip off, or for the mistake in the bits versus the bytes. And then, of course, he blamed Mr. DiSogra for using the call data that he himself had evaluated in his initial report. Right? He comes back and says the whole reason he needed to do this refinement is because Mr. DiSogra made a mistake in his analysis by including those calls. Mr. DiSogra didn't make the decision, Mr. DiSogra. He didn't make the decision to analyze it based on those calls. He just reviewed what you did. He didn't come up with that. He didn't come up with anything new. All he did was critique what you did. So somehow now that becomes Mr. DiSogra's mistake. Yeah, I think we're all getting the message loud and clear that taking what Shanon Burgess has to say at face value is a mistake. It is definitely our mistake. Thank you, Mr. Burgess. Lesson learned, won't be repeated. We won't have that problem again. Don't worry about that. But all he did was review. So I don't know that there's really anything revolutionary in this. It just puts things together and presents them in a way that is maybe a little bit easier to understand, has a little bit more of an impact. Yeah. If there's 30 total possibilities at stake here and 25 of them have the phone lock event occurring after the end of the trigger, that sounds like a lot of doubt. Sounds like it's overwhelmingly more of the possibilities are on the side of the phone lock occurred after. 5 of the 30 are simultaneous or before. So one in 6 times, if you roll the dice on this data, 1 in 6 times, just in terms of like pure mathematical likelihood, 1 in 6 times you get it at or after the trigger event, or at or before the trigger event. 5 out of 6 times you get John locked the phone after this event. That doesn't sound like proving beyond a reasonable doubt that there's that what this data actually shows does in fact relate to the collision that the Commonwealth is claiming took place. A lot of interference, obviously. A lot of interference from Bev. None of this is really particularly clear why these are problems. Sometimes it's leading. That's easy to fix. Other times, it doesn't seem like any of these objections that Mr. Brennan brought were substantially granted. There was no point where Mr. Jackson came back to the podium and had to completely change his line of questioning. He got to go there every single time. It's just, oh, maybe you have to back into it a little bit more this way with this foundation first or whatever. It's just so micromanaging and hyper technical. Quite obnoxious. No, I don't like those words. Use some different ones. We should maybe start a countdown. Now that we're in the defense case, the hurry it up countdown. Are you going to be much longer? The much longer countdown. We have one incident so far. I'm gonna keep count. Somebody suggested that should be done. I think I'm gonna go ahead and do that. We have a one hurry it up today so far, and a lot of days still to come. So let's see what we get. Oh, are we ready for Mr. Brennan's cross and hearing about how heavy vehicle SUV is not a semi-truck? I laid my marker down on that one. I think that's what's going to happen. I think we're going to get that. We'll see. But no, one of the real questions here, I think, is does Hank understand the expert testimony enough to be able to effectively cross-examine this guy? I mean, one of those kind of key points there has to do with using the phone calls, right? That was Mr. Burgess says that's Mr. DiSogra's mistake. You shouldn't use those phone calls from 1 a.m. or whatever, because that's when the Lexus was off. So it would have been just synced up with Karen's phone once she turned the car on. So it's not a comparison of the infotainment clock. It's a comparison of Karen's clock, the clock on Karen's phone with the clock on John's phone. That was the critique that Mr. Burgess had, that he said was Mr. DiSogra's mistake, but Mr. DiSogra just got it from Mr. Brennan's or Mr. Burgess's report. So, I mean, that seems to be like one of the key things to kind of critique him on here. But it doesn't really change the bottom line, does it? Because he looked at every single possibility. So great, take those ones out of the chart. You still end up with, even under the assuming no offset between the text stream and the infotainment data, that's like the most conservative, assumption that keeps us with the trigger event having some possibility of occurring before the phone lock, the end of the trigger event occurring before the phone lock. But then if you apply the clock adjustment, the internal clock adjustment that, again, apparently came from Mr. Burgess, he acknowledged it, he just never actually did it, then you still end up with no possibilities, only one possibility where these things occur simultaneously. And every other possibility, the lock event is happening after the end of the text stream event. Does Hank understand all this well enough to get into sort of what the nitty-gritty of the analysis is and the issues with the analysis? I'm not sure. We're going to find out. We're definitely going to find out. Let's take some time to see what some of you guys have been thinking this morning. Summertime. Hi, Andrea. At this point, what do you believe the Commonwealth has proven, and what do you hope to see from the defense in the next few days? Thanks for all you do. The Commonwealth has proven that John died The Commonwealth has proven what the nature of John's injuries were. The Commonwealth has proven that there was this social event going on the evening of January 29th. The Commonwealth has proven that there was at least some degree of tension in John and Karen's relationship. The Commonwealth has proven that Karen has said a lot of things about her perspective on the events, the trial, the case, the investigation, etc. What else has the Commonwealth proven? They've proven there's lots of data. They've proven there's lots of data. Everything else just depends on your assessment of the credibility of people. And everything else I can think of off the top of my head. What of this information of what they have proven is significant it's a judgment call for the jury. What does this data mean? That's going to be for the jury to decide. They're going to decide that based on the input from the experts about what it means. But the experts are not in agreement. We have a battle of the experts. So the jury is going to have to sort out the significance of what that means. Do we believe Judd Welcher? Do we believe Matt DiSogra? Who do we believe about what when it comes to this data that the Commonwealth has proven exists? But what does it mean? So, from the defense in the next few days, I mean, I want to see them. I want to see them to the extent they can. They need to answer what's the significance of a lot of this stuff. That I think is just going to be basic. What's the significance of the busted taillight? What's the significance of the glass that doesn't match? What's the significance of the testing that was done? What's the significance of the testing that was not done? What's the significance of Proctor's involvement and his absence in this case? What's the significance of any of that? It's, I think, going to be on the defense to try to tie some of these pieces together so that it does become a coherent story that the jury can understand. If they are just left with pieces of data and things that look weird and it's hard to reconcile all of it, I mean, structurally that kind of benefits the defense, right? Because you can argue all that's reasonable doubt. Commonwealth's job is to sort that out for you and explain it. So if you don't understand it clearly, it's their failing and you hold it against them. But you want to be helpful. You want to give them what they need to be able to see things your way. And so I think to the extent that some of these things that aren't in question depend on interpretation. Well, now it's time to hear the defense's interpretation of that stuff that's not in question. So that's maybe a broad answer, but that's generally what I expect. But does your mom deny it? Bring on the wolf pup. I'm ready. I'm ready for him anytime. It looks like this is probably going to be pretty quick. I mean, it wasn't a very long direct, right? Took us just to the morning break with a motion being argued ahead of time. So cross going to be super long. I don't know. I guess we're going to get our flavor of that as well. Our first little taste of Hank on cross-exam. Miranda Bauman, can you speak to the impact that Aperture's conduct in this trial may have on the firm's future trial/litigation work, aside from the obvious issues associated with private equity-driven firms? Yeah, I mean, what I pointed out before, this, a lot of people are like thinking this is going to end their career. No, guys, I hate to be the bearer of bad news. They'll probably get more business because of this. Everybody knows. It's not a secret that these are hired guns. Of course, everybody knows that. The Commonwealth had Trooper Paul at their disposal. They had ARCA at their disposal. They didn't like what those people had to say, so they've gone out shopping and they found this crew. And that's what somebody who wants to go and win a lawsuit, whether they're right or not, is going to look for. You know, it crossed my mind when I saw that decision the other day from the other court in I think it was Suffolk County, the one where Welcher's testimony had been thrown out as being unreliable. And I honestly wondered, hey, I wonder if that's Hank, if Hank heard about that and that's why he chose this guy. Why else are you picking some random guy from Long Beach and a guy from Texas? Why them? What was your selection criteria that led you to these people as opposed to anybody else? They're willing to say freaking anything if they can get a court that's willing to let them do that. Yeah, that's actually like a benefit to somebody who wants to win a case and they don't care if they're actually in the right or not. They just want to win and they want somebody who will say anything. So I hate to be the bearer of bad news on this, but I don't think this is going to hurt Aperture at all. I think this is actually going to be it's going to be favorable, particularly with folks who are regularly engaged in a lot of litigation of this nature, insurance defense firms, for example, folks like that. All they deal with are these types of collisions and wanting to win. Unfortunately, I think this is largely just going to help. Sandra, did Welcher testify that 2 people said there was no Jeep, but only one did, so he used that in his analysis? If so, does anyone know which day? He said a majority. He did not give numbers. He said a majority of people said that there was no Jeep there. And so that's what he decided, I believe. Let me see if I can find it. It was on day 22. I think it was the first day of cross. I don't know. I'd have to go through my notes pretty well in detail. But he didn't give a number, and that's why I saw some folks had gone and looked back at who testified to what in the first trial. And so we had Jen McCabe, Matt McCabe, and Brian Higgins all testified in the first trial, putting the car out on the street in front of the mailbox. Brian Albert, I think Caitlin Albert, I forget. There were 3 other witnesses who just said it wasn't in the driveway, as far as I recall. And the reason they knew, right? Higgins was the first one to arrive. He was the first one to get to 34 Fairview. His testimony in the first trial was he pulled into the driveway to do a swipe with his plow and clear it, and then backed out and parked over there by the mailbox. So then when everybody else arrived, oh, thank heaven their driveway has been plowed of this cat track of snow. What else would we do if we had to, walk on stuff that's barely sticking? But, the driveway was clear. They didn't pull behind the Jeep. The Jeep wasn't in the driveway. So I don't recall anybody other than, Maxon, D'Antano, and Ryan Nagel saying there was no Jeep there. They certainly said there's no Jeep there. But so this is what this is what the tell was that Judge Welcher has decided. I'm going to be the fact finder on this because I'm going to weigh this competing testimony and decide there was no Jeep there. And he tries to science it, make it look like there's a reasonable basis to choose that because the majority of people said there was no Jeep there. The majority of people can and sometimes are, maybe not even that infrequently, be wrong. So it's not a good metric for reality, what people say. But in terms of like, does it make it more likely? Did it make it more likely that the sun revolves around the earth when most of the earth thought that? Of course not. But it's not your job anyway. It has nothing to do with engineering. There's no engineering solution to are Jen and Matt and Brian Higgins telling the truth, or are Heather Maxon, Ricky D'Antano, and Ryan Nagel telling the truth? There's no engineering answer to that. That's why you can't reach any conclusions to a reasonable degree of engineering certainty, whatever the hell that's even supposed to mean. But to the extent it's based on applying engineering principles, there's no way to apply that to whether a white Jeep was parked out front or not based on the testimony. So he tried to make it sciencey by making it sound like, oh, well, it's because there's a majority. Number one, that's not engineering. That's not a basis for choosing one over the other. But number two, you're wrong anyway. It's not a majority. It's at best a 3-3 split. Jen, Chris, and Higgins all say in the street. Maxon, D'Antano, Nagel say it wasn't there when they showed up. Mispronounced name. Institute for Printed Circuits is IPC, founded 1957. Thank you for that. I was running around trying to find exactly what that certification was, and then he went and told me it's like advanced soldering. That's cool. Sandra M. Morning. Can the defense ask ARCA, please give us an example of past clients? And ARCA can list NHL, NASA, FBI, like try to sneak it in there somehow. They should be able to ask about the type of work that they've done and the context in which they've done it, just like every other expert has been allowed to do so far. It's part of the information that's helpful to the jury to evaluate how much weight do we give these people. There's an argument that it's not necessarily to ARCA's benefit that they did all this like preventative work with the Department of Justice and with the NHL and so forth, because that's different from the task that they are being asked to do in this particular case. Those aren't accident reconstruction things. And so a jury might be inclined to give them less weight because they're not specialized in this type of thing. On the other hand, maybe Aperture is more specialized in this kind of thing, car, the very specific field of motor vehicle reconstruction, collision reconstruction. So, they shouldn't have to sneak anything in. I mean, if you mean the FBI sneak something in like that, I don't know that inherently is like any kind of issue. Because they're not saying I worked for the FBI in this particular case. They should be able to just talk in generally who some of our clients are, what is some of the work that we've done. So I would, in a normal world, of course, expect that would be perfectly fine because every expert has been able to do that so far. It is helpful to the jury to assess what significance does this testimony have. But we are, of course, in this courtroom, so who knows what we're going to get. Go Georgia. Andrea, do you think our Subarus have this fancy stuff? Pretty sure with the eyesight safety system, etc. There's a fair chance certain. Love my Outback touring in Oz. So my BRZ does not have anywhere near the bells and whistles of your Outback. It's got safety stuff, but not a lot of visible things. I don't have, when he talks about, you have the screen in the middle, that thing. I mean, I have a screen, but it's my aftermarket one that I put on. The one that came, the base model was, nothing. It didn't do anything fancy. It's a radio, and I don't think it even had like Bluetooth to your phone and stuff. Trying to remember now what even was in that original module. So, I'm sure it recorded a lot of this stuff, and I'm sure it's actually got, good safety stuff because, yeah, it's Subaru. But I don't actually know that much about it, and most of it isn't particularly visible on my car like it might be on some others. V Grave, what's your skincare routine? Oh man, I don't have like a, skincare routine. I try to wear sunscreen. I use retinoids. Don't use a lot of like, heavy cleanser stuff. I use like very, very mild cleansers like, Neutrogena, Cetaphil, things like that. I don't use salicylic acid. I don't know. And just, try to moisturize. And really, honestly, nothing fancy, no fancy products, nothing like that. If this is an implicit compliment, you like my skin, thank you very much. I attribute probably 99% of it to being very lucky to have the genes that I do. You should see my grandma. Okay, my grandma is 96 years old. She looks at least 20 years younger. I mean, she looks great. My mom's the same. Mom is in her 70s. Mom looks considerably younger than she is. I just have my fingers crossed. I'll share some of that luck. But, the rot comes for all of us. One way or another, one day, one moment. Robin Hall, I recall you telling us during Delphi, but what kind of mascara do you use? Lashes on point, girl. Thank you. I'm actually using a different kind this time. During Delphi, I was using the Kat Von D, which I did like. It was a good one. I'm using Milani now. Lucy Fair, Commonwealth's whole case has the vibe of we're going to confuse you and then tell you why you're stupid for feeling confused, like an abusive relationship. Yeah, a lot of you're confused, dumbass type of vibe coming out of it for sure. But then also that whole blaming everybody else for my mistake. Boy, isn't that an abusive relationship dynamic? No accountability whatsoever. None. If you don't buy my explanation for why there was a vehicle collision here, it's because of your dumbass mistake, not anything that I did. It does have, and that's part of that's why we keep saying Ipsy Dixit, and the gaslighting comes up a lot. Because it is just a lot of expecting you to comply because that's what you're supposed to do. And so if you have an abuse dynamic, there's certain expectations. Of course, you wouldn't question me. Of course, you wouldn't undermine me. Of course, you wouldn't criticize me, and you'll be punished if you do. And that's very similar with the the Ipsy Dixit. I say so, therefore it is. You're a dumbass. You're unethical. You're improper. You made mistakes if you don't believe me, that kind of thing. Aaron White, Jackson during summation. So, members of the jury, do you feel the $400,000 you and your fellow Norfolk residents sent to Aperture was money well spent? I do wonder what they're thinking. I wonder, is Mr. Brennan going to elicit what DiSogra charged for Delta V? Is he going to elicit that? Are we going to get a tally? We're going to be able to compare the tally of the defense engineers with the tally of the Commonwealth's engineers. That would be interesting. Odin's Martyr, question: if a governor appoints a judge, can the governor dismiss the judge? It depends entirely on the process that is set out usually in a constitution for a state about how these things are going to be done. If the Constitution says they can, then they can. If the Constitution says there's some other method, then you got to use that other method. So I've looked at this before, but I don't have it, fresh on the top of my head, how exactly the whole judicial selection and appointment and retention and removal, if any, goes. I do remember that there's authority for the Commission on Judicial Conduct to remove a judge for things like, severe, like really, really problematic behavior, but also like disability. Lawyers are unfortunately kind of known very frequently for dying at your desk. Just keep working, keep doing stuff maybe beyond the point where they should be. You know, things start to fall through the cracks. We'd love to think we're all still, you know, super sharp at, you know, 85, but chances are pretty good you've had a little bit of decline, and so maybe you won't be doing your best work. It's all very individual, of course, but I think probably if you've been in a legal community, you've probably seen more than one lawyer who probably should have hung it up, yeah, quite a few years before they actually did. So the same kind of thing can apply to judges. You can linger on the bench and, you know, develop dementia or things like that. So there's some authority for the Commission on Judicial Conduct to deal with that. But as far as, you know, can we remove a judge just because we want to remove her? That I don't know. I can see if I can find you an answer, maybe if I get a chance to do a little research, maybe during a break or something. Earbuds in the kitchen. Bob should have asked Judd Welcher if tail light could have come from space and what other null hypotheses he rejected on the tail light ending up there. I appreciate that Mr. Alessi, you know, I did advocate for go ahead and needle the guy, you know, mock him a little bit. It's a really fun way to deal with the troll type of personalities, because the troll expects to be the provocateur. You know, that's the dynamic they're trying to work with. They troll, you get mad, they win. Like that's the formula. And so when you turn it around and kind of deliver that same method back, you're not performing as expected, and so that can sort of, you know, defuse, I guess, the situation a little bit. And just that whole there's this whole line of thought. I'm trying to remember who it was that it originated from. Alexander Pope, maybe, like way back in the day, about the devil hates to be mocked. The one thing the devil hates is to be mocked. Devil is proud and arrogant and full of himself. What's the one thing he can't stand? Being mocked. So you can extrapolate that to people who manifest those same kinds of characteristics. Yeah, you're really pompous. You're not going to like to be mocked. This maybe would have achieved a little bit of that. But I'm going to give credit to Alessi for keeping it clean, just getting done what he needed to get done, not getting involved in the drama of it, and just making his points and getting out. So yeah, it might have been fun. It might have been a little bit more the mocking style, but at the end of the day, is that the most professional way to handle it? Well, probably not, but it certainly is fun, isn't it? Mittens, will Karen be put on the stand? Common wisdom is going to be no. Common wisdom is going to be no. I'm going to say she should. You know, I say that in pretty much every case. I realize I'm the minority. I want the defendant to testify. The jury wants the defendant to testify, even though they'll tell you, you know, we're following the instruction that says it doesn't matter. They actually will take it into account. They actually will penalize the defendant for not testifying. I think it would be foolish to overlook the, you know, reams of studies that there are on that with juror behavior, juror decision-making. They will penalize the defendant for not testifying. So everything else being equal, I want the defendant to testify. But that's not the common wisdom. It's not the common wisdom. Common wisdom is that it's risky and that, you know, you open yourself up for criticism, or the jury may not like you or whatever. This really isn't my experience. It's really not my experience at all. Talked about it many times. Find juries extremely forgiving of people and their personal traits and things that you might not like and so forth. One of the most unlikable human beings I've ever met in my entire life. One of the few people I can count on one hand that I represented that I'm like, you actually just suck. Like, no real redeeming stuff about you whatsoever.
Mr. Brennan? And Mr. DiSogra, I'm going to ask that you keep your voice up because we're going to try and keep the air conditioning on. And the fans, it's a little stuffy in here, so if you just speak directly into the microphone, that would be great.
Not a problem, Your Honor.
Thank you.
May I proceed?
Please.
Good morning, sir.
Good morning, sir.
Sir, are you trying to offer an opinion suggesting that Ms. Reed's Lexus never hit John O'Keefe on January 29, 2022?
Objection.
I'll allow it. Is that what you're doing?
Is that your opinion?
No, sir.
Are you offering an opinion that Ms. Reed's Lexus never got in a collision before?
The way I stated it was none of the prior events were triggered by a collision.
What I'm asking you, are you offering an opinion that Ms. Reed's Lexus never got into a collision before January 29, 2022 or on that day?
No.
So when you were talking about collisions to the jury, you weren't making any suggestion that that Lexus was not in a collision, are you?
I think you threw a double negative in there. Can you just clarify what you meant? Yeah.
You are not suggesting to this jury that Ms. Reed's Lexus did not ever get in a collision before?
No.
Okay. You're just saying that there's no data on the text string to suggest a collision.
Specifically, none of the events were triggered by a collision. That's
Text stream data can be triggered by a number of different things other than a collision. Isn't that true?
correct.
And in fact, when you talk about text stream data, you know that text stream data does not record a collision. You know that.
A collision is not one of the triggers. That's correct.
Right. So when you were saying it wasn't triggered by a collision, it's never going to be triggered by a collision ever on text stream data.
Not the collision in and of itself, correct?
Right. Right. So there's other things that will trigger text stream data,
Correct.
like sudden acceleration.
The only acceleration trigger that I'm aware of on text stream is if there's a large acceleration during what Lexus calls a PCS or a pre-collision safety event. But a large acceleration on its own, I do not believe is one of the triggers.
Are you sure you know a lot about text stream data?
Yes.
Sustained.
Do you know a lot about text stream data?
Yes.
And you're saying that if a car accelerates over 30% in and of itself wouldn't initiate a trigger?
I'm not sure I understand.
You just said pre-collision is the only time sudden acceleration, from your perspective, would cause a triggering event. Now, I'm asking you,
I'm allowing this.
if someone accelerated Ms. Reed's Lexus at over 30% acceleration, would that cause a triggering event?
I am not sure what you mean by 30% acceleration.
Accelerator, 30%.
Accelerator pedal.
Yes.
Oh, yeah, there's a lot of triggers there's a number of ways that these VCH events can be triggered based on the accelerator pedal angle. I think, yeah.
And what is the percentage from your experience that would create a triggering event?
There's various. Toyota, Lexus calls it high, medium to high is what they put it.
Do you have a number? Do you know the actual data on what percent of pressing the accelerator on the same Lexus as Ms. Reed's would create a triggering event? Do you know?
Off the top of my head, I don't know the exact percentage down to this percentage point, no.
There is something different than the text stream data. That's the EDR data, correct?
Yes.
You would not expect, it would be abnormal for the EDR to register data based on a side swipe between a 6,000-pound Lexus and a 216-pound person, wouldn't it?
Objection.
I'll allow it.
That would be abnormal to register that data into the EDR, wouldn't it?
I don't know if I would use the word abnormal, but I would state it that there's a minimum threshold to record in the EDR, and a pedestrian impact generally wouldn't meet that.
I'm sorry.
A pedestrian impact generally wouldn't meet that. But I don't want to make a blanket statement as if it's always the case.
Saying it would meet that.
Would not.
Would not. And a side swipe or a clip has less force and impact than a head-on collision, depending on the speed, correct?
Generally, yes.
How can you possibly manage that with the angles? It gets too confusing at that point, doesn't it? Isn't that what Welcher said?
Discussing the triggering event. That is the moment that something registers to the car to capture data in the text stream, correct?
Correct.
So if I was to suggest 30% of depressing the accelerator pedal would cause a triggering event, would the triggering event be when it reaches 30%?
Yes.
The event data captures potentially part of an event, doesn't it?
I think we're into semantics a little bit, and I think it depends on what you mean by event. Because previously we'd been talking about an event as the data, but event can mean a lot of other things.
If an event's only 3 seconds long and 10 seconds of data is captured, then the data will capture more than the event, correct?
Correct.
If the event is longer, 15 seconds, 20, 25 seconds, and the data is only captured for 10, the text stream data only captures part of the event.
Correct.
Fair to say?
Very fair.
So when you're looking at the data, it doesn't tell you about the entire event, correct?
The data only tells us about the window of time the data captures. There's no way to know beyond that from the data.
All of your equations and pluses and minuses and graphs you're talking about deal with the 10-second text stream data that was captured, correct?
They deal with event 1162.2, right, and the 10 seconds it's comprised of. Actually, they really just deal with the end of the event. That's what everything in the Aperture Report's referenced.
Fair enough. But it doesn't deal with anything that could potentially happen after those 10 seconds, does it?
No.
Or anything before?
No, it does not.
The triggering event is spot in the middle, captures 5 seconds before, 5 seconds after.
Approximately 5 seconds. It's not exact.
And you would have to look elsewhere for evidence to know what might have happened before. Yes?
Correct.
And you'd have to look elsewhere for evidence to see or determine what happened after.
Yes.
Outside of engineering data, right?
Do you know at the end of this triggering event, that 10-second window of data, do you know what happened with the defendant's Lexus after that 10-second of data?
No.
You have no idea, right?
I don't.
Okay. I want to just ask you some questions about your background and then leading into this case, if I could.
Is a Lexus a bus?
You have a bachelor's degree and a master's degree.
That's correct.
You've worked for your company for some time.
Coming up on 13 years next month, correct?
You've advanced through the company.
Yes.
You presently are the director of engineering.
Yes.
Are you ACTAR certified?
No.
What is ACTAR?
ACTAR is a body that basically offers a certification in accident reconstruction.
Do you offer services as an accident reconstructionist?
Sometimes.
And you have been hired and come into court and offer opinions as an accident reconstructionist?
In the singular time I've testified in court, it was not specifically for accident reconstruction, it was data analysis.
Okay. You continue your education and you go to a number of different trainings and seminars as well as teach, correct?
Regularly.
And when you regularly go to continuing education, you have quite a bit of continuing education that you've been through, haven't you?
Sorry?
You've been through quite a bit of continuing education.
Yes.
You focus as part of your specialty on EDRs, don't you?
That's correct.
Event data recorders.
Correct.
In fact, when you promote your services, that's one of your real specialty, isn't it?
Correct.
And it's something that not only are you schooled on and you go through continuing education, you're well published, aren't you?
That's correct.
And in your publications, you speak primarily about EDR type information.
Yes.
And that's something you are well skilled in, isn't it?
Yes,
Now, forensics or data forensics is a wide field, isn't it?
it is.
And you can do some things or many things in it. But oftentimes people specialize in parts of data forensics, don't they?
Generally, yes.
Well, speaking of you, you specialize in EDRs, true?
Yes.
There is a difference in different subspecialties, isn't there?
In general,
Oh, yes.
yes.
Okay. Now, are cell phones, is that a subspecialty in digital forensics?
Yes.
Is that something you're a specialist in?
No.
iPhones, are you a specialist in iPhones?
No.
Have you ever taken any specific training on mobile forensics?
No.
Have you ever written any papers on mobile forensics?
No.
Hey, have you ever promoted yourself of having any type of subspecialty as an expert in mobile forensics?
Never.
In any of your continuing education, and you have a vast amount, have you ever taken any classes or seminars in mobile forensics?
No.
Have you ever taken any class or study about variances between infotainment systems and mobile forensics?
Classes? No.
Have you ever attended any seminars on variances relative to mobile forensics?
No.
Have you ever testified about variances in mobile forensics before you testified in this court today?
No.
Have you ever published anything to do with variances in mobile forensics?
No.
In this case, you had an opportunity to review a number of reports from Dr. Judd Welcher, yes,
Yes.
and Mr. Shanon Burgess.
Correct.
In reviewing those reports, you've offered your opinions and analysis. Did you ever engage in actually any efforts or study in this case to obtain data?
Could you maybe clarify what specifically you're asking?
Yes. Did you ever yourself, not watch someone else do it, did you ever download or obtain data in this case?
No.
Did you ever test Miss Reed's car?
No.
Did you ever get an exemplar vehicle to run any tests?
I did not.
Did you ever do any actual testing in this
Actual
case?
testing?
No.
And so your role is to look at other people's work and offer opinions and criticisms, basically.
And provide some clarity to the work, but generally, yes.
Clarity for who? Who asked you to provide clarity?
My clients in this case.
You what?
Mr. Jackson,
Okay.
my client.
Did you ever speak to me?
No.
As an expert, when you analyze data, whether you actively got it yourself or not, do you ever give an opinion in paper called a report? Do you ever write a report?
Yes.
And you've seen reports in this case that you've looked at, correct?
Correct.
A number of reports by Mr. Burgess,
Correct.
report by Dr. Welcher,
Also correct.
reports that you're critiquing, right?
Correct.
Did you see Ian Whiffin's reports?
I did not.
How about Jessica Hyde? Did you see her reports?
I did not.
You were asked to consider information from Mr. Whiffin's report.
No.
Well, you were asked to assume that the last user interaction on John O'Keefe's cell phone was 12/32/09.
That was stated in Dr. Welcher's report, so I started my analysis at that level.
So none of the information did you actually personally go and vet or analyze or make any determinations about. You're just critiquing written reports.
Correct.
Well, as an expert coming into court and testifying and having opinions, you put together a PowerPoint, didn't you?
Yes.
Why didn't you ever put together a report to share the basis of your opinions and the process you went through to arrive at your opinions before you came into court?
Primarily, I wasn't asked to, so I didn't do it. I wouldn't commission work without being asked to do it. And number two, the extent of my work beyond building the PowerPoint was just basic addition, just adding numbers together that already existed in the Aperture reports. So there wasn't a tremendous amount of complexity to what I engaged in.
What about your work product and your calculations? Did you do all this in your head, or did you type it out and go through a computer program? How did you do it?
I used a calculator for most of it, and the tables in my PowerPoint were generated in Excel, which has some calculation capabilities.
Were you ever asked not to write a report?
No.
You had provided an initial PowerPoint,
Yes.
and then you received information from Mr. Burgess,
Yes.
and then you added new slides to your PowerPoint.
That's correct.
Mr. Burgess's report was May 8th.
Yes.
You provided your PowerPoint on May 25th.
Correct.
Did it take you that long for the calculations between when you got the report and May 25th to put together the new presentation?
No, it didn't.
Why did you wait until May 25th to provide the new information?
That's when I was asked to do it.
What do you mean by that? I just want to see what the date is today. Today's the 30th. When you finished your PowerPoint on May 25th, did you send it to the defense on May 25th?
Yes, I did.
So they had a copy of your PowerPoint on May 25th? Don't be shy.
No, I'm pretty sure it was the
Don't
25th.
be shy.
Sustained.
Yeah, if it wasn't the 25th, it would have been maybe the day after, but it's dated the 25th. I'm almost positive I provided it on the 25th.
There's no reason for you to hold on to it for a couple extra days.
No, I think it was the 25th.
Do you know what was provided to the Commonwealth that report?
No, I don't.
In the 25th, the report that you provided to the defense on the 25th, it had new information in it, didn't it?
It had the information from Mr. Burgess's supplemental report. That was the additions.
Why did you wait until the 25th to put it together?
That's when I was asked to do it.
Who asked you?
My clients, Mr. Jackson,
He said, please have this on the 25th.
we had a phone call on the 25th and discussed Mr. Burgess's supplemental report. During that phone call, he asked me to update the presentation, and I did so, and then provided it.
How did the date of the 25th come about? Why the 25th was the date you provided?
That's when he requested it. I think it was a Sunday, actually.
I already heard about 3 p.m. on Memorial Day production from the Commonwealth, so
When you first got involved in this
Not
case,
sure how this is
it was
landing.
last fall,
Correct.
and at that time, you received some information that Mr. Burgess wanted to look at the text stream data or the different modules on what you later learned was the defendant's Lexus, correct?
Correct.
And there was a proposal from Mr. Burgess. Mr. Burgess wanted to go back to the car and look at the modules and try to download more information from them, correct?
Correct.
And you then got involved to look at what his request was, the procedure that you wanted to follow.
Yes.
When you did that, were you given any materials about what had happened before you and Mr. Burgess both got involved?
I don't recall specifically, and I don't think so. I think I was just provided the notice of testing that was to be done.
Well, you ended up drafting an affidavit.
I did.
And in drafting an affidavit, you pointed out some oversights of Mr. Burgess. Didn't you?
I did.
Determining the oversights required some study of actually the data and the information that was available, wouldn't it?
It would.
So, can we presume that before you wrote the affidavit pointing out the oversights, you had looked at other materials?
If I recall correctly, the notice of additional testing from Mr. Burgess contained attached to it a whole report by him documenting why he thought there was an inadequate initial acquisition, why he thought the sizes were wrong. So I don't remember referencing anything beyond all the information that was contained in that. And whether that was combined by somebody else or not, I don't know. That's how it was provided.
Did you end up looking at the report of Ms. Gaffney and what had happened in the past with the download and search of Ms. Reed's Lexis materials?
If I'm remembering right again, I think Ms. Gaffney's report was also attached to that same singular file.
You learned that the defense expert, Ms. Gaffney, had downloaded data from chips, correct?
Correct.
And Mr. Burgess was asserting that there was information missing and believed that there was missing information from the chips.
Correct.
In that form, it's sustained.
It's strict.
It's stricken.
My apologies. The conclusion Mr. Burgess had is that he believed there was missing information from the chips.
He did. He miscalculated the size of the chips.
Did you do any study to see if there was actually information missing from the original download?
No, I looked at the data sheets for the chips and then immediately realized what the error was. The data sheets specify a size in megabits or gigabits, and Mr. Burgess had written his report in the context of megabytes and gigabytes.
And then you asserted, or you took the position in your affidavit, that there should be no further chip lock, no further study of those chips, other than to ensure the amount of memory was sufficient.
It's not how I recall specifically what I said.
Well, let me read it because I don't want to try to align your words.
Please.
Mr. Burgess proposed protocol labeled reattempt chip-off acquisition is unnecessary because the file size of the acquisition performed by Ms. Gaffney already matches the expected memory storage capacity of the components.
That sounds accurate.
If you want to see this, I don't want to read from the document. If you need to see it for action, just let me know.
That's fine. I trust your reading.
However, an acquisition may be conducted for the sole purposes of ensuring the contents of the memory chips have not been altered since the last testing by recording the checksum.
Yes.
Did it cross your mind at that point that there was important data in those modules that was not seen or recovered or obtained by Ms. Gaffney?
No.
Did you want to know when Mr. Burgess was looking for more data, more information, what he thought was missing?
He stated, I think in his report or affidavit, I'm not sure what it was, but he stated what he thought was missing was there was a physical size difference. So he thought there was not corrupt data, but just missing chunks of data.
Log line information, you've heard of that. Ignition on and ignition off information.
Yes.
And infotainment system. That's important information when you're reconstructing an accident, isn't it?
It could be.
Well, you read information in this case. Pretty important in this case, wouldn't you say?
Yes.
And so you would not want to engage in that process without this pretty important information, would you?
Which process?
Of an accident reconstruction?
Sorry, so can you restate it, the whole question? Yeah. Yeah.
You said you have some experience as an accident reconstructionist.
Yes.
Don't you want all the data available? More data, the better?
Generally, yes.
You wouldn't want to ignore data on purpose, would you?
No.
I mean, the data analyst, the more data, the more you get to look at.
Yes.
And so the power log on information that actually has date and time, that's critical in an accident reconstruction, isn't it?
In some accident reconstructions, in some, there's no debate about when a vehicle was on or off, but if there is, then yes.
Not just on and off. The power log on and off gives you the date and time that you can match with the texturing data, correct?
Yes, it does.
You know, texturing data itself doesn't have date and time.
It can, this vehicle didn't. It can, but this vehicle did not.
This had a running time instead, like
That's
a stopwatch.
Correct.
So this data that was not found during the initial process, that was critical data at the time.
I don't think prior to the process anyone knew that this particular Lexus infotainment system stored those key on and key off times.
Right. The only person that found this out was Shanon Burgess.
He found it in the process, but I don't think anybody knew in advance of this case. There was nothing out there about it. So to my knowledge, this is the first time that this specific data has ever been released into the wild.
But it was on the board there. If someone knew what to look for or got creative, they could maybe find it.
Yes.
He got
More so
creative,
to
all right.
Got creative because I don't think anyone would have been able to have the foreknowledge that there would have definitely been that.
Shanon Burgess did.
Objection.
Sustained. I'll strike it.
And when Shanon Burgess went to obtain that data that everybody else overlooked or didn't know about, you went with him.
Yes.
So you had a process where he was going to now control the data and take the information that was left behind and remove it from the infotainment board, correct?
He actually never specified anything about the SD card in that initial notice. So it was a departure from his protocol, and it was a little surprising to me when I got there that the protocol was written with a specific focus on a number of other chips. And it became very apparent to me very quickly that the focus was not on those chips, and the focus was on this SD card that had previously been unmentioned. There was nothing in there about that prior to that.
Did it offend you, or were you impressed that he had found that?
I was a little confused because I went into it with an expectation. Generally, if we write a protocol, we adhere to the protocol. If we're going to deviate, we have a discussion about deviations. So I was just surprised. It's not customary to sort of shift out of nowhere. But other than that, I did not know what to think of it because I'd never heard of that.
Did you give any input? Did you have any knowledge about the SD card and how it worked?
No.
So when you watched Mr. Burgess remove the SD card, did you appreciate he'd have to engage in what you call reverse engineering?
He did not elaborate to me exactly what his whole process was at first. It sort of came out as time progressed through the first day in his office in Texas, and then I learned more as we moved to the second testing in Massachusetts. But he didn't explain it to me in one go.
Did you, at that point, understand or appreciate the relevance of the SD card relative to the infotainment system and what it could do as far as the amount of information that could then be available?
He never spoke throughout the 3 days at all about what kind of data he expected from the card or would be on the card or could be. He made no mention of the data.
Not what he said to you, but given your expertise, did it ever dawn on you the significance or importance of this SD card that was sitting in plain sight?
Objection.
Sustained. You can ask it to.
Did it ever dawn on you, as Mr. Burgess?
Dawn on you, objection.
Left behind, that there was something important or significant about it?
At the time, I thought it was a possibility. If you reference the initial work, a number of different memory components were identified in this infotainment. There isn't a singular memory chip. So if we're looking for data, it could be in any of them. So we found a new source of data storage, and there could be something there. There could be nothing there. It was unknown to me.
But it turned out there was.
There was.
Now, when you were watching Mr. Burgess work as an expert, if you felt like there was something inappropriate or he had some great oversight, you could write a report about that, couldn't you?
I could.
Did you ever write any report in this case?
No.
So you never wrote a report for your preparation of coming in and your data in the PowerPoint presentation, right?
Correct.
You never wrote a report regarding any of your observations of Mr. Burgess.
Correct.
You said that he didn't say anything. He spoke to you quite a bit during the process, didn't he?
He did.
He showed you what he was doing.
He did.
He explained to you what he was doing.
He explained the process. I think you had asked me earlier about whether he explained the data, and he didn't.
He demonstrated great proficiency, wouldn't you say?
He ended up with a successful acquisition of the card at the end of the process.
Professional.
When you are considering all your equations, did you consider the timing information taken from the SD card that Mr. Burgess found regarding power on and power off of that car?
Yes, to the extent that he considered it in his own report. Again, I'm referencing his report.
But how about you? You're coming in here giving an opinion saying what's better or best practice or right. How about you? Did you consider, you personally, the one who's giving the opinions, did you consider the significance of the power on, power off data as it relates to all these times?
Yes.
Yes, are you sure?
Yeah.
Okay.
I mean, I considered it. If that's the question is, did I consider it? I considered it.
Did you do any study yourself?
No.
Now, we agree, or you agree, that there are variances between different devices.
Yes.
So a Lexus clock that comes from the infotainment system is very common that it would be different than a different device like an iPhone.
Specifically this Lexus, I don't know if we can make the statement that it's common or not, because again, this is the only time that I know of that this specific data has been analyzed. So I don't know the answer to that question.
Did you say on direct examination that variances between devices are common?
Variance between devices are common.
In a variance of 45 seconds, that wouldn't be remarkable on
No.
different devices. It's common in the industry.
Correct.
And in your business, that's an accepted amount.
I'm not sure what you mean by accepted. The amounts are what they are, and we have to correct for them. I've done analyses of clocks that are anywhere from completely correct, 1 second off. I've done analyses of clocks that are 25 years apart. So it's a wide range of possibilities.
I understand your point.
Yeah.
If you see as an analyst a 45-second variance or 30-second variance, that wouldn't shock you, would it?
No amount of variance would shock me, is the answer.
I want to ask you questions and go through your PowerPoint. And I want to ask you your specific opinions and how you arrived at certain claims that you've made.
Sure.
Okay? If we could put up Mr. DiSogra's new PowerPoint, 52525. You've made a modification to your PowerPoint.
Yes.
You've made an amendment to your PowerPoint.
Yes.
So there's something that happened, you received new information or new data, and you updated or changed your PowerPoint.
I did.
And that's an appropriate thing to do when you receive new information, isn't it?
Yes.
If you have new data, you don't want to leave it behind. You want to make the best presentation with the best data you can.
I'd want my presentation of the data to be as accurate as possible, so I included all the data.
And you would expect that from any expert, wouldn't you? If they received new information or analyzed new data and it was important, it would be an appropriate best practice to update the PowerPoint or information they're providing, wouldn't it?
Objection.
I'm going to allow that.
I don't know if I would tell other experts what their best practices are. I would say, generally as experts, we do work that our clients ask us to do. So if we're asked to do it, we do it. If our clients say, hey, don't do that, then we don't do it.
Well, you like the phrase best practice on direct, so I'm just wondering if I can borrow that phrase.
Sustain.
Okay. We can turn to page 2. Now, this is taken from Dr. Welcher's report.
Yes.
And again, you did no testing whatsoever. You just read
I did not.
reports. Did you read all of Dr. Welcher's data, the gigabytes and gigabytes of data? Did you go through it all?
Not every slide, no.
Not just the PowerPoint. I mean the actual massive amount of data in his study. Did you go through the data?
Oh, no, I didn't look at any of the data.
Did you ever speak to Dr. Welcher?
No.
And so when you are making assumptions on what he thought or how he analyzed, you're just guessing.
I am looking at what Dr. Welcher put in his trial presentation, and my assumption that's baked in there is that he's going to stand behind the things he says in a presentation. So I'm taking them at face value, but as being correct.
It's not a matter
I'm
of
not guessing.
It's not a matter if he's going to stand behind it. You don't know why he put something in here. You just see it on the paper. You don't know what his thought process was, did you?
To an extent, yes, because I understand how the exemplar testing by Aperture laid the foundation to align the key-on events in the infotainment to the Lexus VCH events.
When Dr. Welcher made his PowerPoint, do you know whether or not he was relying on 154 on Mr. O'Keefe's phone, stamp 154, as the end of the event as opposed to the beginning of the three-point turn, 1162.1?
based on the math he uses, that's the implication. He puts a number on the screen that the only way you could reach that number is by making that assumption. So when I looked at the math, yes, that assumption seems baked into the math he did.
So this seems like it's baked in that he was assuming 154 on John O'Keefe's phone was the end of the 3-point turn.
Not on this slide, on a later slide, but yes.
Okay. And you said that variances, 30 seconds, 45 seconds, they're very common when you're comparing two different devices, right?
Yes.
Okay. Return to the next page, please. You point out 2 times for the jury, the Lexus event 11:62:2 ends 12:31:43, right?
Yes.
And that's based on the clock in the infotainment system.
That time is based on 2 things: the clock in the infotainment unit and the cumulative key on timer in the text stream data. So it's a combination of 2 values.
Which is the running clock.
Correct.
Right. And that is compared or contrasted or coordinated with the log on off time that was found on the SD card. Yes?
Yes.
And without that SD card, we wouldn't have that time now, would we?
Correct.
Okay. 12:32:09 isn't something you analyzed, but you just read in the report that that is information from Ian Whiffen suggesting or taking the position that was the last user interaction John O'Keefe had with his cell phone, 12:32:09.
That's how I understand it. There was a phone lock at 12:32:09. I did not look into the underlying reports from where that came.
And you know those are 2 different devices, 2 different clocks that will have a variance.
Yes.
You mentioned trigger event, and you said that your preference is to, when you're doing times, to point it from the actual trigger event, and there was a little slap for emphasis to target you on that, right? The trigger event. That's not a standard practice or protocol that is supported by any type of literature, is it?
It's the methodology I teach, especially in the class I teach on the analysis of heavy vehicle data. We have the exact same problem with heavy vehicles. They all have clocks on them. And so in fact, I do a lot of clock adjustment on heavy vehicles relative to other sources. And the way I teach it, I'm not the only instructor. Collectively, the way we all teach it is we generally start the analysis at the trigger, which is not to suggest you have to do that. It's not wrong to do it a different way, but that would be let's call it the default methodology.
The default methodology, do you have any professional literature that says that is the best time to start the analysis?
Not literature. I mean, that's sort of my opinion, because that introduces the least amount of variables. Once you start trying to align events off of subsequent times, you just introduce more addition, subtraction, or math you have to do. So it's easiest to do T0 and align everything from there.
If you're lining up the end of one event with the end of another event, it's more coordinated than if you take it from different spots, isn't it?
That could be a scenario where then you wouldn't use it. Right. Like I said, it's not the only way, but it's the default way.
I don't disrespect your method, but there are other ways to do it that are just as legitimate as the trigger mark.
Absolutely. And that's why I didn't change the convention here. I used their convention,
So you're not
Aperture's.
suggesting that Mr. Burgess was being misleading by choosing the endpoint when he pronounced that's exactly the point he was considering, are you?
No.
And so the word cherry picking, you're not saying he was cherry picking, are you?
I don't remember the context in which I used the word cherry picking, but I don't think it was with respect to a trigger alignment.
So there's no legitimate professional basis of suggesting your way is better or worse than going from the front or the end of the event?
No.
So you're not offering criticism on that, so just so I understand it.
Not criticism. I pointed out that it's not typical, and I pointed out not even to say specifically that it's not typical, because even that, to your point, might sound critical. I just want to be clear that I adopted their convention. It's not the way I would have done it, but I kept that convention consistent in my analysis. So I wasn't changing in the middle, trying to obfuscate what I'm saying.
I appreciate that. So if someone's looking end to end, you're not going to add 5 seconds. It's if someone went from middle to end.
Could you give me that?
Yeah, you were suggesting those questions about, well, since you're looking at the end instead of the middle, then you got to add another 5 seconds on. That's not really an accurate analysis if you look
What?
at a comparison from end to end. You wouldn't
What do you
break
mean
down the 5 seconds of time to trigger because you're starting at the end from both devices.
Objection, Your Honor.
I'm going to allow it if you can answer it in that form.
It's going to depend on if you're doing an alignment with something that is a range of values, then you have to be consistent on where you're doing it. If you're doing discrete points, then that's just a single point in time. There's no beginning or end. It's just a single second. So the best answer I can kind of give is it depends on what you're doing.
Well, in this case, you're basing it off the end of the event. The end, not trigger, the end. Comparing it comparatively to the end of a different device. So you wouldn't just add 5 seconds just for the heck of it.
You would not add 5 seconds for the heck of it.
You see 12:32:09 minus 12:31:43, the middle line, equals 26 seconds. Isn't that in Dr. Welcher's slides before, let me phrase it more cleanly. Before Shanon Burgess analyzed the data more closely on May 8th, in his May 8th report, isn't this the exact difference in time that Dr. Welcher cites in his PowerPoint, 26 seconds?
Objection.
I'll sustain it in that form.
Did you see when you reviewed reports that Dr. Welcher uses this exact number plus 26 seconds in his report?
I got the number from the PowerPoint.
I'm sorry,
not the
PowerPoint.
report, but that is all of the numbers here on this slide are from Dr. Welcher's PowerPoint. And on the previous slide, I show that. So these are all just copied straight from that.
And you've labeled this John's interaction window.
I did.
Okay. Interaction window. Do you think it might be confusing when you use interaction window to make it seem like the event was limited to 10 seconds?
No, and that's not the implication there at all.
That's not what you're trying to say.
That's not what I'm trying to say.
Fair enough. Fair enough.
If I can clarify what I mean by interaction window is that there's
Please do.
a range of times that we end up with when we start running these adjustments. So we never land on a singular point of alignment. We end up, like I show at the end, with 30 points. That's the window that I'm talking about. That's the window that I mean.
So if we could put up page 33 from Dr. Welcher's PowerPoint, just to illustrate the point you're trying to help us with. You want to add a little for me? So this represents, you've seen this, right?
It looks familiar, like it's from one of his slides. And if I've seen it, I did not spend a lot of time digging into it.
Does this look like the 10 seconds of data that would be captured from a triggering event in a text stream data? Objection.
I want to see you at sidebar.
Oh, not sure what's going on here. Oh, how do we like Brennan trying to fluff up Mr. Burgess after all was said and done? How do we like that? He discovered it. He had the foresight. Well, not based on anything he said at the time, and certainly not based on the rationale that he gave, which was off by what a factor, the 8 times, confusing the gigabits with the gigabytes. So, not a whole lot substantial here that I'm getting so far, other than the collision is not a triggering event. We already knew that, but we can reinforce that a few times. And yes, Hank, that applies just as much to the backing into the Chevy Traverse as it does the alleged backing into John O'Keefe. So then we got the answer to that question I said we wanted the answer to. It's fine that we didn't get event, black box registering of a collision, but what matters is what would you expect? Would you expect to get a collision registration from an event like this? He says no, you wouldn't. There's a minimum threshold for the EDR to record a collision. A pedestrian impact generally would not meet that. So that's what we needed to know. It does mean that there is less significance to the fact that there is no EDR recording. Doesn't mean there was no collision with John O'Keefe. So that's fairly important and substantive. Then Hank likes to play the equivocation game, right? Using the same term to mean different things, because that gets things confusing. So you talk about a trigger event, but then you talk about an event generally as meaning something else, as meaning something that's going on outside in the world that correlates with the trigger event. And he got called out for that. I think the witnesses need to be alert for these kinds of language games, but he called them right out to it. Well, you're being a little bit semantic, but no, it only tells you about the window of time where you have data, nothing about before or after. So you'd have to look elsewhere for evidence of what happened before and after that. I've got a big star by that because I would love to come back to this on redirect to clarify if there is any engineering data that you would be able to look at to help us evaluate what happened before and after that event. Or would that be based on things like witness testimony and other types of evidence that have nothing to do with the engineering task? Just to come kind of back and highlight the difference between the approach that Mr. DiSogra is taking here and the approach that Mr. Welcher took, that Dr. Welcher took, where he's like, yes, there was a collision, but it's based on stuff that has nothing to do with engineering. He didn't get into, hey, a Lexus SUV isn't a truck. Instead, he focused on nothing on mobile forensics. I don't see that he did any mobile forensics whatsoever in this analysis. So I don't know how hard of a criticism that really is. Same thing with the not being ACTAR certified. If he's not doing accident reconstruction in this case, then it's not really much of a criticism. He's an EDR guy. And so if he's talking about the data from the EDR, data from the, car systems, that is very much his specialty. So I don't see that any of that has been undermined. He didn't write a report because it didn't require a tremendous amount of complexity to do what he did. He used a calculator for most of it. And then he also made a chart in spreadsheet in Excel. So it's possible he used, the formulas that Excel has built in that you can use to process your data. Might have done that too. Wasn't really necessary to write a report saying, what type of calculator you used or whatnot. Then all this stuff about the report and the provided 525, that's when they had the call and he amended it to incorporate Burgess's report. That is not going to be meaningful to the jury. That is for the court. That's for the court. I don't know that lands when we also heard about Welcher providing his final update on Monday at 3 p.m. So then all he considered is what he's been provided. All of his information comes from Burgess or Welcher and what they have chosen to provide in support of their conclusions and analysis and so forth. Sometimes the power log issue matters. Sometimes it doesn't. Now, if he is not being brought in as an accident reconstructionist, he's not being brought in to evaluate all of this data.
So jurors, we're going to release you for the luncheon break. I took so long here to make sure that we could give you a nice full hour luncheon break. So we'll see you back here in an hour.
Please rise for the jury.
Full hour lunch, huh? Full hour lunch. We'll see if they're going to do anything while the jury is out, but I don't think that they probably are. So nobody would have had the foreknowledge, but Burgess did. Nope, that was stricken. He got lucky, dude. He just got lucky. It was not based on any sort of former analysis that he did or any reason to think what data of any kind or whatever is on this chip. May not be anything on it. Hey, he got lucky and there was something. Hank wanting to ask. He was very proficient, in fact. He's really, really, really trying to overcome that whole problem with the lying. See, that's the whole issue with the lying, is it doesn't mean that he doesn't actually have the ability to do some of this stuff, that he doesn't actually have qualifications. It just means he's not trustworthy. That's the problem with lying. It means you're untrustworthy. And that's why you don't do it, because even if you are qualified and even if you do things right, nobody's going to trust you. But he's really trying to establish, Mr. Burgess, he was actually, as it turns out, he was very proficient. And what did this witness say? He thought about that, he chewed it over, and he came up with the most diplomatic response. He ended up with a successful acquisition from the card at the end of the process. That's what we can say about Mr. Burgess's proficiency. At the end of the day, he successfully got some data. So then the variances are normal. Hank has been very argumentative, throughout this, all these, you expect us to believe, and, did it ever occur to you? He's getting objected to that, and that's being sustained very appropriately. Did it ever dawn on you is not, it's not an appropriate question to be asking in a courtroom. But I like how he responded to a lot of this stuff as well, as far as reading Welcher's mind. Well, I'm looking at what he put in his trial presentation, and my assumption is he's going to stand on his business. My assumption is he's going to stand on it. So I do understand his thought process, because I understand what he did and what it means, Hank. That's how I know what his purpose was in doing certain things, because I understand the process and I understand why different things are done and why you would choose this one over that one and so forth. And so, yes, that he assumed that GPS point 154 is the end of the 3-point turn, because that's the only way to get his result if you actually do the math. And so that is a difference between Welcher's original calculation, isn't it? And the one that Burgess comes up with the range. I don't know how significant that is, or really if it is or not, but we've established, I think, yeah, we can tell Welcher used it as the end, because that's the only way to get that result. We did this, what way do you handle the trigger event, calculate things from the trigger event or from the end of the trigger event? It's not that one way is better than the other. It's that one way is simpler than the other for purposes of trying to match up different things. If you want a discrete event, and if the trigger event is something that gives you a discrete event, and if the trigger event is what is material for your evaluation of this collision, if you have a collision and this data is material to that, I mean, this is part of the equivocation in this particular case, right? We have this trigger event, which is when the accelerator pedal reached greater than 30 degrees while in reverse. Although for some reason it didn't re-trigger, when she's still apparently going 74% throttle in reverse at the end of the 10 seconds. So not exactly clear what causes this trigger. And unfortunately, it doesn't seem like exemplar testing was done on that, but not clear to me at this point one way or the other. They've made a point of arguing that that doesn't mean that's when the collision occurred. It just shows when acceleration is happening and what's happening during that data window, but they don't know if, in their theory, John was hit before any of this data was recorded. They don't know if he was hit in the middle of it. They don't know if he was hit at the end of it. And so that's why they're being equivocal with the language here of event, because the event of this collision, it can be whatever you have decided your theory of this collision event is. And it's not tied to this data other than just by kind of time frame. I mean, in fact, it's possible that this trigger event has nothing to do whatsoever. It's possible. Consider this hypothetical. Hypothetically, Karen did, in fact, back into John and hit him, causes fatal injuries, and it has nothing to do with this trigger event. That is also possible under all of this data. So event in terms of like this hypothetical imagined scenario of Karen running into John, it's what we're supposed to be testing to see if like that happened or not, is a different event from the trigger event. The trigger event, but being sloppy about that is confusing. And what we've seen so far, we see confusion is what the Commonwealth and their expert analysis is giving us. That's like almost purposeful. We don't know. We don't know. There's too much. Can't make sense out of it. The angles are too complicated. Somehow now angular momentum doesn't exist in accident reconstruction, apparently. If it's at a side, it's just too much to handle. It seems pretty hard to believe, but that's what we were told. So it's all too complicated. Confusion. But just trying to create this like little tiny bit of signal through all this noise. Oh, well, but this trigger event, but you can't actually even establish that this trigger event has anything to do with a, proposed collision that you're saying happened anyway. So, the witness, I think, is fairly good at, he's excellent at staying, above the fray very much. This is how experts are supposed to present. You're not supposed to be in there wanting to, I don't know, just sort of blow up your own ego. You're there to provide information, acknowledge the limitations, and so forth. The facts are the facts. Hey, if you not having done continuing education in mobile forensics is a problem, that's the defense attorney's job to deal with. It's not your job to, get defensive about that or explain why it isn't a problem or anything like that. Why? Because this is what it looks like when you actually don't have a dog in the fight. So he's doing very good at staying above the fray, being very professional with that response about Shanon Burgess's proficiency. But then every once in a while, he will go ahead and just, feed it back to Hank a little bit. Hank, you want to ask a ridiculous question about adding 5 seconds on to the variance adjustment for the heck of it? He just says, no, you would not add 5 seconds for the heck of it. No, you wouldn't. And didn't that just highlight what a dumb and obnoxious question that particular thing was? So, not sure we got any major substantive stuff from this witness so far. Everything that we heard on direct was really previewed in the cross-examinations of Mr. Burgess and Dr. Welcher. Only thing I think we really got sort of above and beyond that is just the visualization of what all that means, the number of total possibilities based on their own analysis, and in how many of those does the phone lock event occur after, how many times does it occur before. And that gives us some basis to be able to evaluate, so what's more likely actually happened in this case. Everything else being equal, if we don't have a context specific reason for deciding it's one of these other things, it's one of these possibilities as opposed to any of the others, then we would just look at it from kind of a pure math standpoint. Way more likely that the phone lock occurred after than that it occurred before. Doesn't mean that it didn't, just means that the odds are against it. So let's add it to the list of extraordinary events that all need to coincide for this to all have happened and gone down the way that the Commonwealth is proposing. So nothing really new in direct, nothing really new or ground blowing in cross, but we'll see what we get after lunch, guys. Hey, she's given us a little extra time. So I am going to do my dip out a little bit earlier today. Once again, we've gotten some weather changes. Gotta take a look at the trees real quick and make sure that everybody is in good health right now. Everybody's getting all the water and everything that they need. But I will be back shortly, and then we will take a look. We got, obviously, comments and questions to look at, but there's also been some new filings that I am seeing come up. So we will plan to come back and take a look at those. Dee Dee, of course, as always, over there on X, has the goods. So we'll take a look at that when we get back. In the meantime, thank you so much for hanging tight. And I'll be back real shortly. All right, guys, I'm back. Thanks so much for hanging tight. We should still have about half an hour of the lunch break left, so lots of time to look at these interesting new things that are coming up. So let's start first with this filing, the motion for reciprocal discovery. The defense noticed that it intends to call Kelly Denver as a witness in their case. The Commonwealth moves pursuant to Mass Criminal Rule 14 for all written communications, including prior inconsistent statements and a summary of all oral communications made to any member of the defense team. So it sounds like the defense has found a new witness, Kelly Denver. Don't know who Kelly Denver is, but I saw kind of looking through the comments. It's not actually Denver. Apparently, it's Dever, D-E-V-E-R, Dever, something like that, who is former Canton Police Department on the dispatch assignment on January the 29th, and now with the Boston Police Department, apparently. So what? This is intriguing. This is intriguing. What does she have to testify about from the morning of January the 29th? Remember when Carrie Roberts first made the call, the non-emergency call, she talked to Officer Good. Good was Sergeant Good, I think, was who was on dispatch at the time. He ended up at some point leaving the dispatch and going over to 34 Fairview with the call. And so he was at the scene for at least some of it. You remember Katie McLaughlin says, go get, part of the whole I hit him story from Katie McLaughlin was it's said in front of Officer Seraph. Seraph says, go get Goody. So it kind of implies Goody is on the scene, at least from, early on, like while the first responders are still there. So he booked it over to 34 Fairview. And then at some point, I guess, that day while he's dealing with 34 Fairview, Ms. Dever ends up on the dispatch. So there's a couple of things I can think of that could be about. One, it could be about the sectioning Karen, right? Their explanation was that an emergency call came in from Karen's dad that said she was making threats. And based on that, they contacted Carrie Roberts, said, bring her back. We're going to section her. So it could be a witness about that, something to do with that. Another thing that has always kind of been out there that seems weird and just fell into the ether, hasn't been explained, was remember when Lieutenant Gallagher was talking about his response to 34 Fairview and how initially he went to One Meadows Ave because he was given like wrong information. And this was still pretty early on. This was still pretty early on in that process. Because he manages to go to One Meadows Ave and then come back and then go over to 34 Fairview and be at 34 Fairview by like 8 something, So we're probably in the like 7:30-ish range when he's going over to One Meadows Ave. And it was early on because one, how did that confusion happen? And two, this is like, when did you even identify John? What information are you getting about John? Like, this is real close in the point in time where I'm not sure that we know yet that this is John O'Keefe, Boston police officer, lives at One Meadows Ave. I mean, clearly somebody knew, but how had that gotten figured out and communicated to Lieutenant Gallagher such that he made the mistake of going to One Meadows Ave instead of to 34 Fairview? I don't know. So those are the two things I can think of that she might have something to testify about that's relevant to January the 29th. It's also entirely possible she's going to testify about something completely different. And, this is This is just kind of a side, you know. He testifies about something completely different on a different day. We don't know. So it seems like the Commonwealth doesn't have much of an idea either. They want notice. They want Mass Criminal Rule 14 disclosure for her. So if it is required by the rules, they are entitled to it. They should get it. And otherwise, that should be kind of a non-issue. But then we have this other motion here. The motion to preclude inadmissible hearsay. This one is a little bit more interesting. I'm gonna, if I shrink myself down, is that good enough size? It's all right. It's easy to flip through it, and easier to flip through it. Maybe that's better. If I leave it on the original tweet instead of making it a separate image, but then I can't blow it up doing it this way. But it looks pretty visible. So the defense has noticed it intends to call 4 individuals who have phone numbers associated with a federally protected and confidential series of text messages from Michael Proctor's personal cell phone. Footnote to that. While portions of federally protected text messages were revealed during Michael Proctor's testimony during the first trial, the records remain subject to protective orders of the Norfolk Superior Court and U.S. District Court for the District of Massachusetts. Okay, but I would definitely say the confidentiality of those things has been overcome, at least as to those ones that were introduced before. The defense intends to offer the communications of 9 individuals, only 3 of whom had partial contact names saved within Michael Proctor's personal cell phone, for the substantive truth of those statements. Of note, the confidential record indicates there were a total of 38,707 text messages exchanged within this group, beginning on October 18, 2021 and ending August 31st, 2022. What broke up the group chat? Dude, what broke up the group chat? The defense seeks to introduce a limited portion of text messages attributed to being exchanged by 9 individuals that occurred over 3 years ago. I don't know, why does that matter? It doesn't. You can introduce phone calls that happened 100 years ago if you want. We did have telephones 100 years ago, right? We had telephones not quite 200 years ago. I don't know, somewhere in there, 150 probably. Nothing to do with how long ago they happened, but that's in the motion for some reason. Preliminarily, it is the defendant's burden to satisfy the requirement of authenticating these communications by producing sufficient evidence to support a finding that the communication is what the defense claims it to be. You get that from the witness who is participating in the chat. You get the witness to identify, here's who the numbers, what the numbers are, here's who the numbers belong to. I'm familiar with those people. I've texted with these people before. These communications are consistent with our text messages. You get that through the witness testimony. So yes, they would have to authenticate the text chain, but that is a pretty low bar to be able to overcome. The defense must not only establish that the communication was authored by the witness on the stand, but also the statements of others in the group, including Michael Proctor. Wait, what on earth did that sentence say? The defense must not only establish that the communication was authored by the witness on the stand, but also the statements of others in the group, including Michael Proctor. That's a strange sentence. It doesn't match English. But I think I understand the gist of what he's getting at is that he would also have to authenticate Michael Proctor's statements as coming from Michael Proctor. Again, you do that through the witness, the subscribing witness, who's going to say, I know Michael Proctor. This is his phone number. I've communicated with him at this phone number on many occasions. I received these text messages. I assume they were from Michael Proctor. I took it as they were from Michael Proctor. Nothing in them suggested to me that somebody else was using Michael Proctor's phone to make these communications. That's it. You're done. It's authenticated. This will require the judge to determine relevance and admissibility of each communication, depending on who authored the communication and whether it is sufficient for a reasonable jury to find by a preponderance of the evidence that each and every communication was authored by the individual member of the group. Of note, prior to authentication, no communication should be displayed or read to the jury. Yes, Hank, that's because nothing that's not in evidence should be displayed to the jury. And it shouldn't be in evidence if it's not authenticated. It's going to be your job to object to that. Furthermore, so he's doing a couple things in here that I noticed already right off the bat. Yes, you have to establish authentication for the author of the text. Maybe that was just being confused. Oh, it's up here for the substantive truth of those statements. That is built into this entire objection, that these text conversations are being offered to prove the truth of what they said. That may or may not be true. Let's get through this, and then we'll chew on that a little bit. So no showing them to the jury without authentication, because that's the same rule of evidence that applies to all evidence. Furthermore, the text messages contain hearsay upon hearsay, and each statement and text message must conform with an exception to the hearsay rule. It's generally correct. There are no applicable exceptions. Well, potentially applicable exception here that it's not hearsay at all, and that's what we'll get to. Michael Proctor is available to testify and could authenticate and perhaps adopt and acknowledge the statement sought to be introduced, certainly as he did in the prior trial. While Bowden preserves a defendant's right to attack the adequacy of the police investigation, that attack is still constrained by the rules of evidence. Yeah, we know that, Hank. And this doesn't have anything to do with Bowden, so I don't know why we are citing to Bowden stuff in here. If it's offered for the truth, if it's offered for the truth, yes, it has to fit within a hearsay exception, but that's kind of the $1 million question here in this case, if you ask me. Moreover, the statements are inadmissible for the purpose of showing Michael Proctor's state of mind, nor the state of police knowledge. Hearsay testimony to explain the reasons for police action, however, carries a high probability of misuse because a witness may relate historical aspects of the case, replete with hearsay statements in the form of complaints and reports, even when not necessary to show the state of police knowledge. Okay, this is a quote. I don't even have to read this case. I can already tell you right now, this is completely out of context, and I will tell you exactly what this case is about, and then we're going to pull up the citation and we're going to check me. This case is about police officers testifying about their own why they did what they did and basing it on because this witness told me X and this other officer told me Y. And I received all of this information over the course of my investigation. It is a common way that prosecutors will bootstrap hearsay evidence, and plenty of judges out there will let them do it. Oh, it's relevant to explain the course and conduct of the investigation. Then, of course, you want to ask questions about the investigation, and you get limited. Why'd you make these decisions, and you get limited on that. We'll get back to that, but I'm just telling you right now. I'm already predicting. We'll pull up the site and check. That's what it has nothing to do with bringing in text messages that the police officer is involved in to confront the police officer with them. The police officer stating his own state of mind about the investigation. Therefore, out of court statements to a police investigator, in this case attributed to Michael Proctor in his capacity as the case officer assigned, what? Statements to a police investigator. Let me guess, like Rajiv R., like that case you just cited, and exactly unlike this situation that we're dealing with right now, where the investigator is making the statements, not receiving them and acting upon them, making investigative decisions based on them. It has nothing to do with this scenario. Are permitted, one, only through the testimony of a police officer who must testify only on the basis of personal knowledge. Two, is limited to the facts required to establish the officer's state of knowledge. And three, is allowed when the police action or state of police knowledge is relevant to an issue in this case. So it also goes to bias. Okay, the big one, he maybe tries to sort of smooth that over his state of mind. It goes to bias. That's why it's being introduced. Nobody cares about the truth of the substance of the comments. Okay, and he says some pretty grotesque things about Karen Reed. Nobody cares about the truth of those. The important part of the case is not whether those things are true. It is the mere fact that he said them, and what that says about him, what that says about his impartiality, his whether he was following the evidence. It goes to bias. The entire thing is about bias. Has nothing to do with the truth of the matter asserted. So this whole paragraph here is like really the only one that applies. I mean, yes, authentication generally is going to apply to anything, but you can get that from any single person who is involved in the text chain. That's Michael Proctor's phone number. I know Michael Proctor, communicated with him many times, communicated with him on this number. I know that it's him. I thought it was him on this occasion. You're done. That's it. That's it. And then you, Mr. Brennan, if you want to try to argue somebody was using Michael Proctor's phone to send these text messages, you can make that argument. Good luck to you. Let's take a look at Commonwealth versus Rajiv R. Shall we check? 495 Mass 646. Let's take a look, shall we? Oh, of course, it's going to be difficult to find because it's a new case. Commonwealth versus Rajiv R. Here it is. Here it is. Decided April 15th, 2005. Let's go ahead and take a look, shall we? Juvenile found it. Precluded admission of his mother's testimony. Errors. Did not err in admitting mother's testimony. Other evidentiary argument. Okay, let's get down to most of this stuff doesn't matter for purposes of where are we getting that language. In fact, why don't we just go ahead and take his quote. Hearsay testimony to explain. Here it is. Here's the quote. Here's the whole section. Hearsay to establish state of knowledge. The juvenile also challenges two statements made by the detective when testifying about the search of the juvenile's home, contending that each should have been excluded for lack of foundation and as admissible hearsay. First, after testifying that he had executed a search warrant to look for a firearm and being asked about the individual targeted by the warrant, the detective testified it was a firearm that was allegedly in the possession of the juvenile. The juvenile contends that because the Commonwealth did not establish a foundation for the statement based on the detective's personal knowledge, it was backdoor hearsay, repeating the juvenile mother's out-of-court statements to the detective. Second, the detective testified that after the juvenile's mother admitted the officers to the residence, she directed the officers to the juvenile's bedroom. The juvenile argues that this statement, too, was admitted improperly without foundation and conveyed an implicit statement from the mother that the bedroom was the juvenile's. An important piece of information, the juvenile contends, because the juvenile lived in the home with 4 siblings, and the Commonwealth presented no other evidence that linked the bedroom to the juvenile, such as identification or other belongings in the bedroom. We agree with the juvenile that these two statements by the detective exceeded the bounds of hearsay admissible to show the state of police knowledge, but we discern no prejudice to the juvenile from the errors. Backdoor hearsay, police just stating what they've been told as if it's a fact to explain why they did what they did. The reason why we went to this room is because mom told us. That's your way of backdooring in. You can't just get on the stand and say, mom told us this was the kid's bedroom. So they try to backdoor it by being like, well, we went to this bedroom because that's where mom sent us. And so you get the message. You get the message. It's mom's communication that drove the subsequent action. So this has absolutely nothing to do with the context that Hank is trying to apply it in. We have permitted the use of carefully circumscribed extrajudicial statements in criminal trials to explain the state of police knowledge. An arresting or investigating officer should not be put in the false position of seeming just to have happened upon the scene. He should be allowed some explanation of his presence and conduct. That's what all this is about. It has nothing to do with the use of these text messages. They're not asking Michael Proctor, what were you told that led you to do XYZ? It has nothing to do with this situation. It's entirely separate. The backdoor hearsay is the statement made to the law enforcement officer by a witness that the law enforcement officer, as the witness, relates on the stand. That's what all this is about. Nothing to do with the context that we're dealing with here. So that is what we have as far as the motion to preclude inadmissible hearsay. The foundation of authentication. The authentication can be established by the witnesses when they're called. So that's not grounds to exclude it. If you could prove that they would not be able to do that, okay, then perhaps it would be excluded. But they have the opportunity to do that when they testify. And then as far as it being improper in the first place, it's not a hearsay purpose. Showing his bias is not an improper purpose. It's not offered for the truth of the matter asserted. So I recall that's how they got it in the first time anyway, although maybe it was admissions because Proctor did testify at the first trial. What's interesting about that, though, is how nobody seems to want to call Proctor. I mean, I don't blame the defense for not wanting to call Proctor. Kind of blame the Commonwealth. Yeah, I get it. I understand why. The guy's a massive fuck up. He made your case look ridiculous. Made your whole department look shameful. I get it why you wouldn't want to, but he's the lead detective in your murder case. Stands out when you don't call him. Definitely stands out. But I understand the defense not wanting to call him because you have no idea what you're going to get. And you've only got him on direct. So you don't know how cooperative he's going to be. I mean, you can assume he's not going to be cooperative. He doesn't like what's going to happen. You're not his friend. He doesn't like you. He's probably, blaming you for the fact that he lost his job. Not himself. And the text that he chose to send and the conduct he chose to engage in. No self-reflection on that. But, the defense outed him in the first trial. So while we're on like abuser speak and abuser mindsets, so remember that one. It's not the thing you did wrong. That's the problem. It's the person who called you out for it. That's some abuser think right there, isn't it? It's not my fault that I did something wrong, but how dare you expose me and the truth of who I am and what I do? How dare you expose me like that? That's the problem. So you got to anticipate that if you're the defense. Of course you don't want to call. Of course you don't want to call this guy. He's a disaster. He's a train wreck. You don't know what you're going to get. He's got nothing really to lose at this point, Is he have a roofing job now that might get interfered with or something? I mean, I don't know what Michael Proctor is doing these days. So we'll see when that gets taken up. Maybe the end of the day, maybe not till next week. Who knows? But just in terms of the kind of pure legal analysis side of it, it's a very weak motion, which is really not surprising from Hank. But it's just you can see the reaching. Let me. This language looks really good. Never mind the fact that it has absolutely nothing to do with the context I'm applying it to. Just overlook that part. Maybe he can expect in this courtroom that his sites won't be checked. Maybe he can assume that. I didn't even have to check his site, guys. I already knew. Just from that language itself. I already knew what the context was going to be and that it was not going to be this. It's going to be based on the backdoor hearsay problem. So Well, guys, we got a little bit of time left, looks like, before they come back from lunch. So let's take a look at what you guys have had to say. Joshua Frost, what if she remote started the Lexus? First reverse event could be leaving the parking lot. Second reverse event could be 3-point turn. Yeah, I mean, there's so many assumptions built into all of this. There's so many assumptions built into all of this. It's a luxury car. I imagine it has remote start. I don't know if you can start it from inside the bar. I don't think I've ever had a remote start on a vehicle. So I don't know. I don't know. I don't know if it's like with the garage door opener, you know, you get a little bit too far away and it doesn't work. You got to like get within the range and things like that. But the car itself like doesn't block you being able to use the garage door opener, but something else in the way might. I don't know if it's like that, you know, that type of signal. Or if it's high quality, she could be sitting right there in the bar knowing that they're about to leave, hit a button on her key fob, and the car starts up out in the parking lot. Anybody have a Lexus? Anybody have a Lexus? Can tell us, does it work that well? But yes, of course it makes sense, especially in your luxury car, because you get the defroster going, you get the heat going, you get the seat warmers going, you get everything so it's comfortable in there before you have to go sit in it and drive through the blizzard. You don't have to stand in there and you know, scrape off the windshield, and you don't have to sit in the cold and shiver until things start to get warm. So it makes a lot of sense why you might do that, and it also makes some sense in terms of reconciling the timeline, because if we assume that they just left the waterfall, started Karen's car, got in Karen's car, and started driving over to 34 Fairview, why did it take them so long just to get to Cedar Crest? It took them like 10 minutes just to get from Cedar Crest. Now, let's maybe look that up on the old map. Let's see if maybe I can get a direction here. So we're going to start from the waterfall bar and grill on Washington Street in Canton, and we are going to drive to 34 Fairview Road. We get a 5-minute drive via Sherman. Okay, now what road did they actually take? If they came on Cedar Crest, then it looks like they went along Dedham. They would have gone like this back way. Here's the route that I get that would have taken them there. Let me just show you that. Here's the route that I get. Okay. Waterfall, you have to go the back way. Everything kind of wants to take you this way as like a better way to go, to come from the Chapman side. Makes sense if you're coming from the waterfall. But the way they actually seemed to go was more over here, because they came down Cedar Crest, needed to make that left-hand turn, but didn't. So they continued on a little bit further past, made the 3-point turn, and then came down. So this says it's 7 minutes. So, hey, maybe if there's a little bit of snow and a cat's track worth of snow on the ground, maybe 10 minutes isn't that unreasonable between leaving the waterfall and getting over to where they're going to make the 3-point turn. Everything we've seen so far has Karen kind of consistently going slower than the speed limit and stuff like that. Where we have those records, her records during the 3-point turn, going very slow, 16, 15 miles an hour, stuff like that. Taking a long time to slow down coming up to 34 Fairview. So yeah, if she was driving slowly and cautiously, I guess maybe that would make sense. It would be maybe about a 10-minute drive. So maybe that's part of the explanation that would rule out, a remote start, at least for any like significant length of time. But not, again, not necessarily. Not necessarily, because I don't see how we can rule out anything like you've described this scenario where there's 2 3-point turns taking place at different times, or even just a different 3-point turn, and then the reverse acceleration trigger from anything at all. Driving in the snow at any point where you went into reverse could have been the 3-point turn. Guess I don't know where else you'd back on the road, but I don't know that this can be ruled out. So good observation there. Nicole Kelly, I'm worried that the jury is going to be confused by all these experts, as I am in watching this 4 different ways a day. It's normal and expected for the jury to be confused by the experts. And quite frankly, most of the time when you talk to a jury after a trial, the experts weigh almost nothing because they do have a very hard time making sense out of it. They also kind of expect the experts to be the hired gun. There's a few exceptions to that. Like the coroner typically has a lot of weight. People pay close attention to the coroner. But by and large, if you've got a battle of the experts, this tech guy versus that tech guy, they tend to just sort of neutral that out. At the end of the day, it doesn't matter because they don't know enough to be able to make sense out of it. And all they see is that these are really smart people and they disagree. So if they disagree, how am I supposed to solve it? So we just kind of neutralize all of that out. We're not going to count what Burgess says. We're not going to count what DiSogra says. These guys are both smart. I can't tell who's right and who's wrong. So we're just going to neutralize it out. Very common risk in a jury trial, not really unpredictable at all that type of thing would happen. It's not ideal, and it doesn't mean, you don't do it anyway. You have to neutralize the other guy's expert or he goes unanswered, and then they can just assume, well, the defense would have countered that if there was something. So it's not the substance of what they say that has the effect. It's the presentation. Did you counter what he had to say or did you not? If you did, then we'll just even it out because you disagree and I don't know how to resolve that. If you don't counter it, then I'm just going to go what you said because I'm going to assume they would have countered it if there was a basis to do that. That works against the defense all the time. When you're in public defense, you may not get an expert. Judge may not allow you, may not give you the money to go out and get an expert. So the prosecution gets to put theirs on. You don't get to put one on. Or maybe, you go and crowdfund privately for a defense fund and you use that to hire some experts because that's the only way you can get access to them. But then you get criticized at trial because you didn't have unlimited funds to have your experts do anything and everything you wanted related to what all of the prosecution's experts did. Things like that happen. Yeah, they happen in places like Delphi, certainly, but they happen in a lot of places. So that can be a really, really damaging inference that, the defense deals with quite frequently. Or it won't give me an expert, so I can't rebut what they say. So jury's just going to take it on faith, even if it's trash. Experts are difficult part of managing a trial. It would be great if that weren't the case, and people were diligently focused on the substance of what they have to say and sorting it out and understanding, but that's just not a realistic expectation. Sabina D, a bit behind, but isn't the judge hindering AJ's ability to question this expert at this point? Hank Brennan was allowed to lead almost everybody. Well, he did get objected to for leading, and those were sustained. I don't have a problem with the leading being sustained. I don't have a problem with these little formal things being sustained. It's the ones where the question is proper. The question is proper. It's not leading. It is open. What's the problem with it? And every time we've come back, he's been able to, go where he's going. So it's not like this is a substantive issue. She's just so micromanagey. While at the same time, Hank is coming out with his little smarmy loaded questions. Didn't it ever occur to you that summertime, was defense allowed to perform tests and gather data, or did they have to rely solely on data gathered by someone chosen by the Commonwealth? No, they could have gathered their own data. They could have filed. There's like typically a process that you go through. You just file a motion to get access to the evidence. They have to sort out what kind of process you need to do to transfer possession and not interfere with the chain of custody, maintain the chain of custody and the integrity of it and so forth. And they might yell and scream about, being able to witness you doing it, or maybe yell and scream about you need to come to our facility to do your testing or whatever, because they can be a little bit control freaks about stuff like that. Once again, rules for you, the defense, if you want to access the evidence, but the prosecution, they'll just hand stuff around, willy-nilly and not necessarily worry too much about those details. So yes, they could have, but it doesn't appear that they did, at least nothing that got litigated that we saw, nothing that certainly involved Disogra. Disogra was purely in a review capacity, we're seeing. Now, ARCA, we know they wanted ARCA to be able to do additional work and additional testing, but we don't know anything about the details of that yet. So that will be intriguing when we see what that is. Did they get access to Karen's SUV to test? Did they get access to Commonwealth equipment to test? Anything like that? We don't know. Waiting patiently to find out. AK, if the system don't trust jurors to not take info from sidebars into account, why trust them to be able to strike answers from their mind and not take lawyers' questions into account? Why sidebars? Hey, you've caught on a little discrepancy here, haven't you? Which is that this fiction that the trial operates under, that you can unring the bell. You can just tell the jurors, put that out of your mind and don't consider it at all, and it will have no effect whatsoever on the deliberations. You've noticed that, in fact, even within that framework, they know that's bullshit, because otherwise you would just have your entire argument out there in open court and you tell the jury, don't pay any attention to any of this. It doesn't concern you. Put it out of your mind and don't consider it as part of your deliberations. And the jury would go through the exact same process that they went through with the improper question or the improper testimony, and just erase it and every effect it may have had on them from their memories. We all know it's bullshit. But this is how it's done. This is how it's done. Perhaps there's just a sense that maybe in very small amounts it's possible, right? Very discrete statements or things, we can just put it all out of our mind. But legal argument, or certainly something as potentially egregious as stating the basis for your objection, we can't possibly do that in front of the jury. It would be far too prejudicial. They couldn't put it out of their minds. Yeah, I can't make sense of this one for you, because the whole fiction that striking testimony does anything at all is bullshit. All it does, from my standpoint as an appellate lawyer, is it draws a distinction in my record when I'm reading through it and I want to know what has been established as at least a potential finding of fact by the evidence, something that the jury could find if they wanted to rely on this piece of information. That's all that it achieves. If it's stricken, it tells me, reading through the record, that's not established as a matter of fact. That's it. This idea that it has anything to do with the lawyer's mental processes or the juror's mental processes, complete and total fiction. And everybody knows it for exactly the reason you've just pointed out. Summertime from @Scorpion. I used to work in an industry dealing with crash dynamics, vehicles, etc. We don't 100% know airbag thresholds, but under 10 kilometers an hour would trigger in most cases. That's quite slow. That's quite slow. So, but I'm assuming that's also a forward. I'm assuming that's a forward type of event and not a reverse one. Yeah, I'd love to know more about this. I mean, I'm sure it's a very complicated system. There's lots of variables, and it depends on the precise scenario that you're confronted with. But I am intrigued by this idea that no, you totally plow into a pedestrian and the EDR won't even notice. Like, really? Really? That's wild. Wild if true. Lauren Boborin, most egregious part, Commonwealth could have told the truth about this data and used the other testimony and have a case. Not a good case, but at least an honest one. Yeah, they could have just done it the way that that most cases get tried, where you convince the jury to believe your interpretation of the DNA and the witness statements and the taillight pieces and et cetera, on the strength of your case, on the strength of your argument for how these things fit together, and show that you've proven beyond a reasonable doubt that a murder took place. It's how it's done in 99% of courtrooms in America, most trials. You do not need to go hire an expert to implicitly do that for you and then try to state that as if it's a scientific conclusion, which it very much is not. Very much is not. Everage, I get a judge putting their thumb on the scale and not seeing their bias, but this judge is sitting on it and stands up sometimes ever so slightly to hide her bias. I can't give her grace anymore. It just gets more and more apparent. It really does. She's gotten shorter and shorter now with her rulings even. Remember, like not that long ago, she was giving, at least a short paragraph that she'd written explaining why, for example, she's going to allow ARCA to testify, but she's going to let the Commonwealth have some brief rebuttal, and then the scope of it will be defined after ARCA testifies, and so on and so forth. She'd at least give like a kind of short rationale, and now she's just down to it's denied. I don't agree, it's denied. You don't agree. So I guess we got to assume you don't agree with the entirety of it. You don't agree with the entirety of what Mr. Alessi had to say about the reliance of Dr. Welcher on Trooper Paul and Scorty Bello. Don't agree with any of it. Not specifying what you didn't agree with. Didn't agree it opens the door to be asked about those things that he put in his own report. That's weird. Don't agree that the Sixth Amendment gives him a right to fully confront the witnesses? Surely that's not it. So what does she disagree with? We don't know. I must assume everything, because she didn't narrow it down any further for us. It's becoming more and more evident. The fact that it took us like an hour into the defense case to get our first, are you going to be much longer, Mr. Jackson? Totally not rushing you, but are you going to be much longer? Right in front of the jury. Right in front of the jury, she does that. No worry about how that might affect their thought process, deliberations. Don't concern yourselves with that. Yeah, we're going to keep count. You believe it. We're going to keep count. No, I've given up on giving Brev grace for her bias. I think maybe the difference in my perspective and the difference of the perspective of a lot of people watching this now is just that, to me, this is not a surprise. This is not shocking to me. It might be shocking to people who are new to the system, maybe haven't participated in criminal trials and stuff like that. Because you don't expect it. It's not how it should be. But here we are. And so it's I'm not surprised because this is really bad and it's also really normal, really
So if we
routine.
could turn to page 6 of Mr. DiSogra's amended PowerPoint presentation. Sir, I want to ask you about your opinions, and inevitably, some of the slides that you've presented to this jury regarding adjusting the clock in a time period of 3 seconds. You have given an opinion that there's a difference that you see in the reports between when the defendant's Lexus is powered on and the infotainment system begins, correct?
Yes.
There's a 3-second difference on the exemplar vehicle between when the power is turned on and then the screen lights up, the ignition, the infotainment system.
The 3 seconds I'm referring to is the timestamp in the data from the SD card. So I'm referring to the timestamp in the SD card. It seems that that's coupled to the screen, but I just want to make it clear I'm referencing the data from the SD card.
The data from the SD card correlates directly to the infotainment system itself,
The date does, yes.
because the SD card is what the other chips part of the board that makes up the infotainment system.
Yes.
That infotainment system powers the screen that goes on after a user presses the button to start the vehicle.
Yes.
So the time that the infotainment system is registering is when the infotainment system goes on, not the power on event.
Correct.
So that 3 seconds that was tested with the exemplar vehicle between pressing the button to turn the car on and the time the infotainment system turns on, the infotainment system clock does not accommodate that 3 seconds.
Correct.
So when we're talking about time on infotainment system, we're talking about after the 3 seconds when the screen comes on.
Yes.
Okay. Now you've made some slides and you've made some assumptions suggesting that that 3 seconds should be added to your analysis. And I want to ask you about your analysis regarding the 3 seconds. If we could turn to page 7, please. If you could zoom in on the left side. Sir, you told us that you didn't do any testing or data vetting yourself. You simply relied on reading and reviewing Mr. Burgess's report and Mr. Welcher's report.
Correct.
And really, the information you're reviewing is Mr. Burgess's report. There's only a few references in Mr. Welcher's report where he cites Mr. Burgess's findings, correct?
Most of it is from Mr. Burgess's reports.
There's really nothing in any of Dr. Welcher's reports that you are considering that is not in Mr. Burgess's report.
The .154 alignment methodology, I think exclusively is in Dr. Welcher's and is not present in Mr. Burgess's.
Did you read both of Mr. Burgess's reports?
Yes.
You're not aware that Mr. Burgess talks about that timestamp in his reports?
He mentions it in the second report to say that he doesn't think, basically he doesn't think Dr. Welcher should have aligned it on that.
That is exactly not what he said. Where in the report,
Sustained.
where in his report does he say that Dr. Welcher should not have relied on 154? Where does it say that in his report? I have it here. If you can give me the page, we will take a look at it.
I don't know the page, and I'm paraphrasing. By no means am I conveying that as I'm directly quoting it, but I remember that as something I read in there.
Well, I was careful in your affidavit not to paraphrase you, right?
Sustained.
So when you just made that assumption or that suggestion characterizing Dr. Welcher's state of mind or thought process, is there anywhere in the report you can cite or show me where Dr. Welcher said that?
No.
Okay. When you read Mr. Burgess's report, and you learned that he and others obtained an exemplar vehicle and did this testing, you have no other independent information to suggest that the power on, power off event and 3-second delay is inaccurate, do you?
I just want to make sure I heard you. Did you say accurate or inaccurate?
Inaccurate. I'm sorry, the fan's on. I'm trying to
I
show.
know that's the only reason I couldn't hear that. So can you state it one more time?
I'll rephrase it. When you reviewed Mr. Burgess's report and reviewed the information about his exemplar testing regarding the 3-second difference between turning on the car and the infotainment system going on, you have no other information that you looked at or studied that changes that analysis, do you?
No.
Now, when you are suggesting, could we shrink that and zoom on the right side, please? When you are suggesting that 3 seconds should be added to the time because of that 3-second gap, do you think maybe you made a mistake in considering it that way?
No.
Okay. The time that you're adding 3 seconds to is the infotainment time, the infotainment clock, correct?
Yes.
The infotainment clock begins when the infotainment system goes on. We just spoke about that, correct?
Right.
Which is 3 seconds after the power on event.
Correct.
So you're essentially double dipping. You're adding 3 seconds that has already been separated because it isn't reflected on the infotainment system. Isn't that true?
That's incorrect.
You believe that 3 seconds between the power on and the infotainment system going on should be accommodated extra on top of it.
It's not that it's extra. It's because when we're talking about times here, we're pulling a time from the infotainment and we're marrying that with a key on timer from the vehicle control history. Those are separate systems. So if the vehicle control history had its own time, then what you're saying would be correct. We wouldn't account for any delays because then it's already baked into those numbers. This is a very unique analysis. This is not something I've ever even seen, this type of analysis here where we're comparing a timestamp from an infotainment SD card to a VCH total time. And so the only way to reconcile those two is we have to align them. And the 3 seconds is the alignment between those because the VCH key on timer is going to start as soon as the vehicle is turned on. And that's the 3 seconds.
You've never seen this before.
I've never seen the approach taken here in this analysis by Aperture. That's what I meant by this. I'll clarify. I have not seen a timestamp from a key on event in a Lexus infotainment used in addition to the key on timer from that same Lexus.
You know Mr. Burgess actually looked at the data, not just the timestamp. He looked at the data. You understand that, don't you?
Sure.
You did not, did you?
Which data?
The data for the timestamp on the text stream data.
There is no timestamp on the text stream data, is my point. It's a derived value from the key on time, and then added to that is the elapsed time from the text stream. So they're separate.
Did you look at the data to make that determination that you're claiming right now? Did you actually look at the data?
Yes. Yeah.
You looked at the raw data?
I looked at, yes, the raw text stream data.
The raw text stream data from the infotainment, did you look at it?
I just don't want to mince it. The text stream data is an independent system from the infotainment, and you said from, so they're not.
Did you look at the infotainment raw data?
I did.
Okay. And did you find a timestamp on the infotainment raw data?
Yes.
Now, when you added 3 seconds, you were trying to, in addition to the infotainment data, you were adding on the 3 second delay that now you're saying might not even be accurate. Is that fair to say?
No.
I don't think I've ever said it's not accurate. I said that in the exemplar testing, they documented this behavior of a 3 second delay. And that needs to be accounted for if you're going to correct the timestamps. However, the caveat I put on that was That was only with one exemplar vehicle. So it could be that this behavior, the 3 seconds, is unique to the exemplar and would not apply to other similar vehicles. And so that's why I did either nothing or the 3, because there's nothing to support something in between.
So you disagree that the clock stamp on the infotainment module begins the run. You believe that there's potentially 3 seconds before when the ignition goes on that should be added to that time.
I know from testing other Toyota systems that the key on timer happens almost at the identical time that the vehicle is turned on. That timer starts running basically immediately.
But on this case, you don't know anything firsthand because you didn't do the testing yourself.
I don't know if it would specifically apply to this Lexus. I know that from other Toyota testing, but
And
not
you're
this specific Lexus.
I'm sorry, finish.
No, I'm clarifying. I do know that from other Toyota and VCH systems that key on timer is basically simultaneous with the key on. I have not tested it on this, and I don't believe that it was tested by Aperture when they had it either. They didn't document the accuracy of the run timer in their exemplar, so we don't know.
Well, you don't know that they didn't document that.
To be
It's
fair,
not in
if
their
they
reports.
did, it was not in their reports.
Right. So in this case, you said cars are different, and that's why you're hesitant to accept the fact that there's a 3-second delay. It's a yes or no question.
I'm saying we don't know. If had Aperture done testing with a separate vehicle, then we could establish, is the 3 seconds the same or is it unique? We don't know. The answer is we don't know.
And so when you are determining that 3-second variance, you don't have any assurance in your own mind.
Sorry
whether
for
or not
taking Aperture at
this
face
car
value.
misreads
Won't make that
Lexus
mistake
has
again.
a 3-second variance. That's what you're trying to say.
That's correct, and that's why I run my calculations with and without it.
And the way you would determine that is to actually do testing or look at the data.
More testing, I think, is the only way that would be able to be determined.
Now let's turn to slide 9. As part of your charts, could you enlarge to the left, please? As part of your charts, you took this chalk from Attorney Burgess's report and you made some assumptions about this, didn't you?
I'm not sure.
Okay.
I applied the numbers in his third column to the times. So, I mean, that's the extent of the analysis.
When you looked at the first 5 columns, 1:14, 13 a.m., 4:38, 16 a.m., 4:42:06 a.m., 4:45, 12 a.m., and 5:04, 28 a.m. You said on direct examination, oh boy. You said on direct examination that was matching infotainment to iPhone.
That's what it says on the chart, so
Okay.
that's probably what I said. I don't remember specifically, but that's what the chart says.
what
Is that
Aperture
your
said.
opinion that those first 5 columns are matching infotainment to iPhone?
The chart says infotainment call timestamp in column 1. It says O'Keefe iPhone call timestamps in column 2, and then it says offset. So I'm taking that at face value.
You're basing
Good.
your later charts on the predicate that these numbers, the first 5 columns, are infotainment compared to John O'Keefe's iPhone, aren't you?
Based on the chart, yes.
You didn't do any study on your own to determine the genesis of that information, did you?
I'm aware of the fact that these calls, the 5 you mentioned, were placed when the vehicle was in a keyed off state. I'm aware of that.
What I asked you specifically is, on those 5 columns, did you do any research or study to determine whether or not it was infotainment matches to John O'Keefe's iPhone or some other phone matches to John O'Keefe's iPhone? Did you do any independent study about that?
No.
Because in your ultimate conclusions and all the charts you've given to the jury and shown the jury, it relies on the conclusion that the first 5 columns are a comparison.
It doesn't actually. They're just
infotainment clock
possibilities.
in John O'Keefe's iPhone. Isn't that fair to say?
That's exactly how the chart presents it, and that's how I present it.
Did you know that at 1:14:13 a.m., the defendant's Lexus was turned off?
Yes.
Did you know at 4:38:16 a.m. that the defendant's Lexus was turned off?
Yes.
And did you know for 4:42:06, 4:45:12, 5:04:28, did you know that her Lexus was turned off?
Yes.
Do you know that when you make phone calls, oh, by the way, do you know on those different times, the first 5 times, where that information is generated from?
Which column?
Left column, 1:14:13, all the way down to 5:04:28. Those 1, 2, 3, 4, 5 calls. Do you know where that information came from?
It came from the SD card from the infotainment.
Yeah. Do you know where the genesis, the beginning, the source of that information? That matters, right? The source?
It would.
It would. Do you know where it came from?
The assumption, the assumption is if the vehicle has a timestamp and the phone wasn't connected, it would have been synchronized after the fact. But that wasn't tested. And Aperture didn't do any of that testing in their work to look at the behavior of a timestamp in the infotainment when a phone is synchronized after the fact.
Blaming Aperture is not going to get you out of answering the question. Did you know?
Sustained.
Sure.
Yeah, ask for him to be admonished. Alan, it is well past that because he already knows. I mean, we're, weeks into trial now. He already knows he does this deliberately and on purpose. In a normal jurisdiction, this would get you in trouble with the bar. In a federal court, you probably are not practicing in front of that judge ever again. But we're in Bab's courtroom. And he'll keep doing it and she'll do nothing. Calling it now.
Do you know the genesis, the source of those 4 numbers?
Which 4?
Definitively no.
Your entire premise for your slides and values and ranges depends on knowing the genesis of those numbers, doesn't it?
I relied on Mr. Burgess's explanation that those times were synchronized after the fact.
Did you know that those are all phone calls from the defendant's phone to Mr. O'Keefe's phone?
Yes.
You did know that.
I know that they're phone calls
From who?
Sorry, can you maybe just state it more clearly? Because I'm not sure. I don't want to fumble through an answer if I don't understand the question. So,
Do you know where those calls came from? The source?
a phone,
Whose?
Ms. Reed's phone.
Now, I know you're not an expert on mobile devices, but did you know when it's not a contemporaneous synchronization, you plug your phone in, it's going to register on the infotainment system.
Objection, move to strike.
Objection.
Not in evidence.
Sustained.
Do you know when someone plugs their phone in after they turn the car back on, how it synchronizes on the infotainment system?
I don't know if adjustments are made to those times during a synchronization or not. I think that's something that could be tested, and to my knowledge, was not tested.
If you don't know, then your conclusions and all your opinions to this jury is based on an assumption that you don't even know the predicate for. Isn't that fair to say?
My
No.
conclusions are based on all of the data that Mr. Burgess laid out. So he laid these out and went so far as to calculate the offsets himself. So there's something implied in his table by virtue of him calculating these that maybe he would decide to align them. And so, again, to provide the clarity on all the possible alignments,
all of
I
them.
included them.
But that's not what I asked. If you're making an improper assumption about the predicate, about these calls and the source of them, and you're wrong, that would change your entire analysis and conclusions and charts
No,
that we see in
it
your later
wouldn't.
charts, wouldn't it?
Sure, if there was testing that showed that that is an invalid method on this specific Lexus and SD card, then Of the 30 possibilities, some of them would end up being eliminated.
Did you know that when an iPhone was plugged into a car, it
Objection.
downloads the information from the iPhone on the infotainment system? Did you know that?
Objection.
I don't know how the clocks are synchronized when you plug an iPhone into a car.
Well, if you don't know, how can you make conclusions based on a part of it you don't even know what it is?
The conclusions are based on the data in Mr. Burgess's report.
I know you're not an expert on mobile devices.
Objection,
but
Your Honor.
So I'm going to strike that. Go ahead and ask your question.
My apologies. If you have two different devices, a Lexus clock, the infotainment system, and an iPhone, you would agree that it's not unexpected to be variances, correct?
Correct.
When you're comparing two iPhones, do you have an opinion, do you agree that you'd expect the variance to be very small, iPhone to iPhone?
I don't know.
Have you ever studied that before?
Two
He's not an
iPhones?
expert.
No.
So as you sit there today, you don't have any expertise, any education, any knowledge about how closely two iPhones would sync with each other?
No.
Do you see in the first 5 columns the numbers are small, 22121?
Yes.
Would you agree iPhone to iPhone using the same source of time is generally going to be within 1 or 2 seconds of each other?
Objection.
Sustain.
Mm-hmm.
Do you have any opinion
Objection.
about whether iPhones to iPhones will generally be within 1 to 2 seconds of each other? Objection.
You can ask if there's an opinion. Do you have an opinion on that?
No.
Next question.
If the first 5 calls are iPhone to iPhone rather than infotainment to iPhone, you agree with all of your assumptions and conclusions are inaccurate?
No.
They're not iPhone to iPhone in the sense that column 1 came from the infotainment. The values were read from the SD card. So there's an assumption baked into it. What you're saying that when a phone is synchronized, the infotainment assumes the times of the phone, but we don't know whether the infotainment would adjust those times to its own clock or not.
You're speculating now, aren't you?
We don't know. It wasn't tested. I don't know is the
You
answer.
don't know.
I don't know.
You don't know.
I do not.
Okay. Don't say we don't know. You don't know.
Objection, Your Honor.
Sustain.
So this is iPhone to iPhone. Then your assumption on the first 5, 12121. If they're iPhone to iPhone and you're wrong about the fact it's infotainment to iPhone, your assumptions and conclusions are
No.
inaccurate, aren't they?
They're not.
I'll allow this.
No.
If the title of the first column had iPhone in it as well, then I would not have used it in my analysis.
But that's not the question. I appreciate that. My question is, if those first 5 calls were iPhone time to iPhone time, and you mistakenly analyze them as infotainment time to iPhone time, then the rest of your assumptions and charts
No.
would be inaccurate, wouldn't they? Objection.
Sustain.
No, they wouldn't. He already said he would limit these possibilities and that's it. The rest of them are still out there.
At 5:21:36, do you know whether or not the defendant's Lexus was on?
You're going to keep kicking this horse,
I don't
Hank?
recall if that one was an on or an off point. I don't want to guess. I don't recall.
And so if you don't know if that was on or off, were you able to do an analysis whether this was phone to phone or infotainment to phone?
No.
5:30:31, do you know if the defendant's car was on?
That one I know the vehicle was on.
That's one timestamp on the infotainment system, 5:30:31, correct?
Correct.
And then in the O'Keefe iPhone call timestamps, there are 2 different numbers, 5:30:15, 5:30:52. Yes?
Yes.
Right. And do you appreciate that that is 2 separate calls, or do you think it's something different?
I'm going to paraphrase, again, Mr. Burgess's report as I recall it, in that he stated during the testing they did with the exemplar, calls placed in close succession would not necessarily both be logged in the infotainment. So as I understand this chart, what he's trying to say here is there were 2 calls placed. There were 2 call logs in Mr. O'Keefe's phone, but only 1 timestamp in the infotainment, and he couldn't determine which it corresponded to because of that observed behavior from testing.
I'm asking if you know.
I don't.
Did you ever look at phone records for the defendant or for Mr. O'Keefe to make a determination whether these are
What
two
does
separate
phone
calls
records
or not?
have to
Did
do
you
with
ever that?
engineering?
No.
If these are 2 separate calls, can you explain to us why there is 1 timestamp?
Again, as I stated, that was behavior that was observed. The exact behavior was observed during the exemplar testing by Aperture. I don't know why that happens. Why does the infotainment not log every call? I don't. But I know that it was documented that that is a feature of this system.
This information was not taken from the exemplar vehicle, was it?
This table, no.
No. This information was taken from the infotainment system of the defendant's car. Isn't that true?
Yes.
And the phone calls were taken from Mr. O'Keefe's iPhone. Isn't that true?
Yes.
And so, do you know why there would be 2 phone calls and only 1 timestamp?
Beyond the testing, the exemplar testing that showed an exemplar vehicle did that, no, I don't know why it happens.
Do you know that the infotainment system doesn't always capture all of the phone calls and the phone data in the downline?
Objection. Objection.
Yes.
Assumes
Well,
facts,
you know
not
that.
evidence.
Can you conclude that even though there's 2 calls and only 1 timestamp, that's because how the infotainment system works?
I think that's the most logical assumption, that that's how it works.
So when you look at 530.15, right in the middle, and 530.52, it is impossible to tell which one relates to the 530.31 infotainment on the left. Compare. It's impossible, right?
Yes.
So there's 2 possibilities.
Yes.
One is that you have a difference, a disparity of 16 seconds.
Yes.
And the other one, going the opposite way, is a disparity of 21 seconds.
Correct.
And so when you add those disparities, you have 27 seconds disparity in those. Correct?
I'll allow that.
Is there a 27-second disparity when you compare the 2?
Why are we
I'm
adding
not
6
sure I
subjects?
understand the math.
530.31 is 16 seconds different than 530.15 on Mr. O'Keefe's phone. Yes?
Yes.
530.31 is 21 seconds different than the 530.52 phone call. Yes?
Yes.
And the difference is cut each way, one's minus, one's plus.
Correct.
So you add those disparities, you get 27 seconds, don't you? Objection.
I'm going to allow that.
No.
Okay. What do you get?
You're saying if, maybe so I can be clear what you're asking, if we have a negative 16 and we have a positive 21,
Correct.
how many seconds are in between there?
Exactly.
37?
And so you can see, did you know that the defense card was turned on at 5:07 a.m.? Does that ring a bell?
I don't have any of those key-ons committed to memory.
So you can see between 5:21 and 5:30, the offset is different between them, which shows that variances change. They move.
That seems reasonable, yes.
When I said it seems reasonable, do you have the experience and the knowledge to agree with me that variances move?
Yes, they do.
Objection.
Okay. If those first 5 calls
He's gonna try it
were
again.
iPhone to iPhone rather than infotainment
Undermines
to
your
iPhone,
entire
would you agree they
analysis and
should not have been
conclusions?
considered in your analysis?
Not in my analysis.
Yes, with the caveat that because this is a novel analysis with this SD card and this infotainment, that it was demonstrated that that's the behavior. My opinions on things like that are based on testing and research and literature. And so when we have a brand new system with new data, we want to see some testing to prove it works the way we think it works. But under the assumption, then yes,
You would agree.
yes.
If we turn to 10, please.
Good job, Hank. Now you're down to 20 out of 25 possibilities that lead to no collision.
Given, could you zoom in a little, please, on the left? Given that these data points come at 5 in the morning, or 1, 4, 4, 4, 5, 5, and 5:30, did you consider whether they would be less reliable than comparing to the triggering event, the 3-point turn at 12:23 the night before? Did you consider that?
Yes.
When you said you reviewed and you're critiquing reports, did you read Mr. Burgess's report on May 8, 2025?
Yes.
Did you read in his report where he explains that this is a less reliable method to, it's a less reliable method because of the time difference between the actual event we're interested in, 1162 at 12:31, 43 to 48, than the 3-point turn?
Yes.
Okay. When he explains that the method of using 5:21 and 5:30 on January 29, 2022,
This guy's body
he
language.
explains about how the information is
He's
stored
in
in the
full what the
infotainment
fuck.
system when it's powered back on, doesn't he?
I'm not sure.
Well, do you remember when you were reviewing his report that he explains the available call log correlation is restricted to a time frame between 5:21 and 5:30 a.m. on January 29, 2022, when the vehicle was powered on. All other calls stored in the infotainment module occurred while the vehicle was powered off, indicating those entries were synced from Miss Reed's iPhone upon reconnecting to the system on the morning of January 29th. You considered that when you decided or formulated your critique, didn't you?
Yes.
This further indicated that the associated timestamps for those calls originated from Miss Reed's iPhone. Did you read that?
Yes.
Relative to those first 5 columns, correct?
Yes.
This behavior was previously documented in the initial report, which is the January 30th report. Yes?
Yes.
You shrugged. I mean, I don't want you to just agree with me. Do you remember it was in the January 30th report?
I don't remember how he phrased it specifically. But I think there was somewhere around there where he noted that some calls were placed while the vehicle was off. I think that's basically what it said in the first one. I don't remember specifically.
Okay. Do you agree generally, or can I give you the report? You can look and remind yourself. I want to get your best memory on this.
Sure.
What would you like me to do?
If you'd like me to look at it, I'll look at it.
Sure. Do you have a copy? Would you like me to bring it?
Do you have the reports with you, sir? Okay. Do you have an extra copy for him, Mr. Brennan?
Mine is marked. If you want me to show the mark. Let me see if I can get a clean copy from the witness. All right. That's mine.
Mr. DiSogra has been sitting here with the head shakes and the
I don't have a
squints.
clean
Like,
copy. I don't want to show you something that has my writing on it. Not that I
is
care
this
if you
real
read it, but
life?
This is protocol. Okay. In discussing why this is not an effective way of matching the time, did you consider in his May 8, 2025 report, when he's talking about this method, when he says, as a result, this method yields a single reference point for potential alignment?
Yes. The
And we
call logs
talked-
are discrete points.
I'm sorry?
The call logs are discrete points for alignment. Is that?
As a result, this method yields a single reference point, is referring to the 5:30-31.
I don't know. It sounds like it, but I don't know.
From the 5:21 a.m. to the 5:30 a.m. window, a plus of approximately -8 and -16 plus 21 seconds were observed between the Lexus clock and Mr. O'Keefe's iPhone clock. Did you consider that?
Yes.
This offset is measured approximately 5 hours after the time of the collision and cannot be assumed to apply to other time frames stated in the initial report.
Objection.
I'm going to allow it unless, do you have, I'll see Counselor Sidebar.
She's going to make the defense give him their copy since Brennan's not prepared with a copy of the report to give him. Let me guess that that's what's going to happen. Hank looks like he's running out the clock today, doesn't it? There were rumors that Lucky Loughran was seen in the courtroom or courthouse. I believe Turtle Boy might have reported that. So Lucky Loughran perhaps on deck. And, why not make it as difficult as possible for all of the witnesses, make it inconvenient because, the fact that your question was, objected to and sustained like 5 times doesn't mean you shouldn't try to ask it the 6th. Say a few more things and then try it a 7th and 8th time. Yeah, of course you're not supposed to do that, but we're in a special setting here. Not the kind of professional court where we expect decorum and rule following and so forth. What do we think of Hank basically impeaching Aperture? Isn't that if these were wrong, that undermines your whole analysis? No, actually, it doesn't undermine his analysis at all because his analysis was to take what Aperture did and simply clarify it and show here's the range of possibilities that you get if you apply the variance that Aperture came up with to the times from the data that they have. Here are the range of possibilities that you get. So it doesn't do anything at all to undermine all of the other possibilities that are not affected, or the whole idea of there being a interaction window, or what the outer limits of the interaction window are.
Sir, going back to my question, so you read Mr. Burgess' report, the same report that you're critiquing, and you were aware of this information, weren't you?
Yes.
And so you were aware that Mr. Burgess in his May 8th report was identifying that the section in green was the only contemporaneous information for analysis. Did you know that?
Is that how he states it specifically?
I can read it again. I just read it to you.
If you don't mind.
Okay.
Objection, Your Honor.
So let's give him a copy.
I'm sorry, Your Honor?
Let's give him a copy. Does he have the clean copy?
You are going to make the defense, give him a clean copy.
You can turn to page 3. What I read to you was where it says clock sync method 1. Do you see that?
Yes.
And this is, if you look at the second paragraph, I read that to you word for word. Do you see that?
Yes.
The 5:21 a.m. and 5:30 a.m. are the only 2 data points when that car was on January 29, 2022. Is that fair to say?
Yes.
Okay. And if you look at the last paragraph, do you agree or disagree? As a result, this method yields a single reference point for potential alignment. Do you agree with that?
No.
Okay. Because you still are under the mistaken belief
Objection.
that
Sustained.
you still have the opinion that the first 5 rows are an infotainment to iPhone analysis.
It's presented as that way in his initial report, which is what my initial analysis was based on. And in the supplemental report, there's no further testing to say one way or the other. He just has a new opinion. So I stand by the initial analysis that I had, that those points should be included with all of the other points.
But that's not my question. My question is, you are taking the position those first 5 calls are an infotainment to iPhone analysis.
They could be, and so I include them. I'm not saying they definitively are or not, which is why I never say there is one way to do it. That's why I say there's a whole host of ways to do it.
So you're now saying that you're not assuming that's an infotainment to iPhone analysis. Are you now saying that?
I never assumed it. I took the data at face
It's stated that
value.
way, and I think it could be that way. But it might be iPhone to iPhone too, if those times are just copied over.
And if it was iPhone to iPhone, your analysis would be wrong.
Certain lines would go away. So if you want to call the whole analysis wrong because of that, it might be your characterization.
Okay.
It would change the total number of possibilities.
So if we put up chart 12, page 12, please. If you were wrong about the infotainment to iPhone analysis and those first 5 should not be considered, which part of your chart would now be wrong?
What do we have? 12 lines on the chart?
I'm sorry?
Yeah, we have 12 lines on the chart. If we decided to eliminate the lines that are based on the calls when the vehicle was off, we would be left with 4 lines on the chart.
And if we turn to 14, please. And if you could enlarge, well, I don't think you can enlarge it. If your analysis about infotainment to iPhone was wrong, you would agree those first 1, 2, 3, 4, 5, 6 columns should not be there, should they?
No, the positive 16 stays, the negative 21 stays, 1, 2, 8, and 20 would go away. So we'd lose 4 lines from this chart.
And the negative 16 line, that comes from information at 5:30 a.m. the next morning.
Correct.
And you would agree that that distance is not as accurate as queuing it from the 3-point turn event 1162-1.
The 3-point turn is closer in time than the call at 5:32.
And thus more reliable, wouldn't you say?
Generally.
And the negative 21, that was from 5:30 and some seconds the next morning. Same idea. Not as reliable as the 3-point turn information.
There's greater uncertainty the farther in time we get.
So when we turn to the 3-point turn information, you mentioned in Dr. Welcher's report that it was noted that the timestamp 154 was the end of the 3-point turn event, correct?
That's how he states it.
And then more information was provided when Mr. Burgess then broke down that 154 timestamp, correct?
Correct.
And when he broke down the 154 timestamp, he actually wrote a report about it, didn't he?
Yes.
He didn't just have it in his head, he put it on paper for all to see, yes?
Yes.
And in that report, not only does he break down the data, he also shows a visual of the actual data on a map, doesn't he?
He does.
Okay.
He even painted himself blue. Did you paint yourself blue, Mr. DiSogra?
Yes. Exhibit 192A. Okay, let's start with 192B, please. If you could open that up so we could see it a little better. When you look at the data he actually broke down, do you agree that instead of at the end of the 3-point turn event as timestamp 154, that actually is at the beginning of the 3-point turn? Do you agree with that?
I don't. I don't know if the points are numbered on here, so I can't tell which point he's referencing as 154.
Do you see the green circle?
Yes.
Do you see the black line?
Yes.
Does that orient you to the direction the car was traveling?
That appears to be what he's trying to convey with this chart.
And then the yellow is facing a different direction towards Fairview, correct?
It is.
And do you see the green square rectangle?
Yes.
Do you think that correlates to the green circle?
That seems to be what this graph implies.
Okay. And it notes that
So ask it differently, Mr. Bowman.
does that heading note the start of the 3-point turn of O'Keefe's phone is 12:23:59?
I'm going to allow it.
That's what Mr. Burgess states in the report.
And do you have any information to suggest that's not spot on accurate?
No, I didn't do an independent analysis of the 3-point turn maneuver.
And then the heading of the change, end of 3-point turn to O'Keefe's home, 12:24:07. Do you have any information to suggest that's not spot on accurate?
I did not analyze the 3-point turn maneuver.
And so when you look at that and break down 154, did you determine or make an analysis that 154 that was generally accepted, because there is variances between items, when you break it down with more specificity, 154 is actually earlier than the 3-point turn conclusion? Did you consider that?
I'm going to allow that, yeah.
I'm not sure I understand the question, if you don't mind.
You mentioned Dr. Welcher's report said it relied on 154 as a timestamp for the end of the 3-point turn.
Yes.
Based on Mr. Burgess's May 8th report, and based on the data which you don't contest, you now agree that 154 was not the end of that 3-point turn. It was at the beginning.
Based on how Mr. Burgess presents it, I didn't do an independent analysis. So I'm not on one side with Mr. Burgess or one side with Dr. Welcher. They present independent methods.
Are you suggesting in any way it's inaccurate?
He has no way of knowing.
Are you suggesting it is in any way inaccurate?
I'm going to allow that.
I don't have any opinions as to the individual accuracy of the methods selected by either Mr. Burgess or Dr. Welcher.
Do you have any information you'd like to add or weigh in on to dispute the accuracy of those times?
Sustained.
And let's turn to the previous exhibit so we can actually see the data that's broken down. If you could open that. The 154 timestamp, if you go to the left, please. Do you see that right above the green line?
Yes.
12:23:58. You see that?
Yes.
And then the green goes to the orange, and that's an 8-second difference, isn't it?
Yes.
And when you looked at this, you considered that this was a more detailed study of that timestamp by Mr. Burgess, right?
More detailed is, yes, that's correct.
And do you know why he did a more detailed analysis of this? Why it wasn't in the original PowerPoint?
No, I don't.
Well, you said that variances are generally accepted in the community, right?
Yes.
But then you wrote a report suggesting numbers and additions, and you submitted that report as part of the basis of your testimony, right?
I only submitted a PowerPoint. I have no report.
PowerPoint. And after you submitted the PowerPoint, isn't it fair to say Mr. Burgess then analyzed this data to be more specific after you introduced your PowerPoint?
Yes.
So can you guess why he went through a more detailed analysis?
Objection.
No.
Sustained. Strike it.
See how Hank is still doing his
In the
improper
final
stuff
exhibit.
and Bev's doing nothing?
Let's go back to the data. You said that Mr. Burgess had an 8-second range, 21 to 29 seconds, remember?
Yes.
And you were suggesting that somehow there was some uncertainty. Do you remember that?
Yes.
Okay. Were you guessing about his state of mind, whether he was certain or not? Do you know why he gave an 8-second range?
Objection on these.
So ask it differently, Mr.
Okay.
Uncertainty
You
isn't about his
suggested
state of mind.
The reason why there's an 8-second range is that Mr. Burgess was uncertain. Remember saying that to this jury?
Not in those exact words, but that's what uncertainty is. Uncertainty is a range. If we don't know a specific value, we put a range around it. That's uncertainty. That's a
This data from the green, would you agree it indicates the beginning of the 3-point turn, and then the orange is at the end when the car is already in motion at 11.2 miles per hour?
Objection.
I'm going to allow it. Do you agree with that?
I see speed values there. I see some headings. I can't convert GPS in my head, so I don't know.
You could have analyzed this data yourself, right? Before you came in and gave an opinion.
I could have.
But you didn't.
I did not.
Do you have any reason to test accuracy of this data that's converted? No objection.
I'm going to allow that.
No.
And so by giving the range of 8 seconds, you talked about looking at different values to be fair, provide a range, right? Even though this analysis depends on the end of the 3-point turn, wouldn't you agree it's kind of forgiving to give that 8-second range to give the benefit of the doubt by starting at the beginning of the 3-point turn all the way to the end of it rather than just giving the end point?
As to that form, ask it differently, Mr. Green.
Does the 8-second range that is provided by Mr. Burgess coincide with the data and the 8-second range between the green and the orange?
That's where he comes up with the 8-second range, correct?
And so if Aperture's position is the matching times at the end of the event, by going back to the beginning, isn't that even more forgiving than the 8 scientifically? Objection.
I'm going to allow it.
Yeah, I would call it a conservative approach to use a range of values.
The opposite of cherry picking, right?
Sure.
On this occasion,
Do you have an opinion to a reasonable degree of forensic data certainty
he's like, what does that even mean? He rolled his
about
eyes.
whether text stream data provides data reflecting whether a collision actually occurred?
No.
In your opinion, to a reasonable degree of forensic certainty, is the text stream data would not reflect a collision, correct?
That's not what I said. I don't have an opinion.
And you know that there can be collisions or touching between vehicle, and it's not going to appear on the text stream data. You know that, right?
It's possible.
It's possible. Did you know that the defendant's vehicle at 5:07 a.m. on January 29, 2022 bumped into a different car?
Yes.
Do you see that reflected on the text stream data?
I'm thinking back to when I reviewed the raw text stream data, and I don't remember seeing an event from that.
I can't really hear
I don't
you.
remember seeing an event from that time in the text stream data.
Well, you don't remember seeing it. It's not there, is it?
I don't think it is. I don't remember seeing it. I don't think there's one.
You're not.
I was going to finish and say I don't have all of the events committed to memory. There's
Yep.
19 of them.
I'm sorry.
There's 19 events. I don't have them all committed to memory.
You're not testifying or offering an opinion that there was no collision with this car that night, are you?
No.
Because if you were implying that or suggesting that or insinuating that, that would be misleading, wouldn't it?
It's not.
Sustained.
I have no further questions.
Okay.
You were asked a number of questions. Ma'am,
Yes.
thank you. You were asked a number of questions a few minutes ago by Mr. Brennan concerning your expertise. I'm just going to grab a pen if I could.
Was like his sanity restored? Maybe? Where am I even?
Specifically, you were asked about your expertise regarding mobile data devices. Mobile devices and their data, correct?
Yes.
And were you being truthful when you indicated that you were not an expert in
Yes.
that field? Were you being truthful when you indicated that you have a certain expertise in EDR data?
Yes.
Were you being truthful when you indicated that you did review Mr. Burgess's data and Mr. Welcher's data as reflected in their reports and PowerPoints?
Yes.
Were you being truthful about your credentials?
Yes.
Have you ever lied about your credentials?
No.
You hold a bachelor's degree
Yes.
and you hold a master's degree.
I do.
You ever lied to anybody about that?
No.
Good one, Alan.
Mr. DiSogra, what is the only reason you amended your PowerPoint presentation from its original version to the one that you most recently amended it to?
To include the additional analysis and data points from Mr. Burgess's supplemental report,
So-
the May 8th report.
I'm sorry, I interrupted you. Go
The
ahead.
May 8th report.
So you amended yours because he amended his.
Correct.
You were asked just a second ago about all the text stream events that you noted on Ms. Reed's SUV, correct?
Yes.
Mr. Brennan asked you about a specific text stream event at or around 5:07 in the morning, and whether you had something like that committed to memory, correct?
Yes.
You said, I don't have them all committed to memory, right?
I don't.
What did you say after that? Because there's how many?
There was 19 events prior to 1162-2, 19 other events.
How about after 1162?
There were a number after 1162-2. I don't have the exact count in my head.
How about after 1162, just on January 29th, going into January 30th?
There were other events.
How many?
I don't recall the exact number.
Does 11 sound right?
That it sounds plausible. I recall seeing in the chart. I recall seeing a number of events after.
Would it refresh your recollection to look at a chart?
It would.
Wow, 11 in one day.
Thank you. Yeah, there are a lot. I would have to really use my finger to count them all.
Okay, more than 8,
Total after 1162-2,
only on the 29th.
there aren't date stamps on these because this chart is the raw text stream data, which doesn't have timestamps.
Safe to say there are many, correct?
Yes.
May I approach?
Yes.
And again, this goes back to a question that you were asked by Mr. Brennan. I want to follow up on. In no instance were any of those related to a collision, to your knowledge, correct?
Objection.
Sustained.
Were any of those that you reviewed at any time, the lifetime of the vehicle, related to a collision?
None of them were triggered by a collision.
Thank you. I want to ask you a hypothetical, if I could, based on questioning by Mr. Brennan surrounding the 12/32/09 lock event. Do you remember him asking you about those questions, about that event?
Yes.
Your analysis was based on the time span. Let me rephrase that. Was your analysis based on Mr. Burgess's and Mr. Welcher's analyses together of a span of time between the 1162-2 text stream event or trigger event and the lock event at 12/32/09?
Objection.
So the question is that what he's considering?
Correct. In other words, was he basing his opinion or analysis on that time frame, at least in part?
So I'll let that question stay.
Thank you.
Yes.
Okay. If you were told that there was another interaction phone event on John O'Keefe's phone at 12/32/16 in the form of steps taken, 36 steps over the course of 83 feet, would that change your analysis or opinion in any way?
Objection.
I'll allow that in that form.
Yes.
In what way?
If the phone event moves from 12:32:09 to 12:32:16, then of the 30 possibilities I had in the chart, all of them would become positive. That would mean that that interaction occurs after the end of the vehicle event every single time. Instead of, it was 25 for 30 in the original analysis, the hypothetical would change it to 30 for 30.
All of them, all 30 of them would occur at a point in time. Let me rephrase that. All of them would reflect a scenario in which the phone interaction took place after the trigger event.
That's correct.
Thank you.
Thank you so much for not
If
saying
you were
you're
told-
welcome.
To give you another hypothetical, if you were told that there was a Doppler state event on the phone, pocket state event on the phone at 12:33:14, would that impact your opinion in any way?
Objection.
Sustain.
You were asked several questions about what you believed Mr. Burgess may have gotten wrong in terms of his original report and one of his original analyses dealing with bits and bytes. Do you recall that?
Yes.
Did Mr. Burgess,
Hold on.
of course,
You need to, we have to turn the fans off.
and I'm not speaking loud enough?
Right.
I'm sorry. I'll raise my voice. I just don't want to scream over people, but I will raise my voice.
Let's try this for a few minutes.
May I start again?
That question, yes.
Thank you. You were asked about whether or not you believed that Mr. Burgess was incorrect in terms of certain analyses he undertook or reflected in his original report back in January of 2025, correct?
Correct.
As it relates to the bits and bytes, did you find that Mr. Burgess was incorrect or correct about his analysis concerning the size of the data set collected based on bits versus bytes?
He was incorrect.
Explain that to the jurors very briefly.
These are just different units. A bit is a different size than a byte. And so if a size for something is listed in bits, for example, and you look at the data and assume it's in bytes, you will assume it's the wrong size.
Which Mr. Burgess did based on your review of his report, correct?
Correct.
I want to change gears and ask a different question or series of questions about the text stream data versus the infotainment system data, specifically the timestamps associated therewith. Is there a timestamp associated with text stream data?
In this case, no.
Okay. Is there a timestamp associated with infotainment system data?
Yes.
All right. The infotainment system data, well, let me see if I can ask it a different way. Where did the 3-second delay come from? Your analysis of Mr. Burgess's review of the text stream data or his review of the infotainment system data?
The 3 seconds came, well, fundamentally it came from the exemplar testing where he identified, and he was actually, well, Aperture collectively in that testing identified a difference between when the button was pushed and the time that showed up in the infotainment. But they didn't actually look at, as far as I know, or at least it wasn't provided if they did, how that specifically related to the key on timer itself. But they showed that the button is pushed, there's a 3-second delay, and then the time gets logged.
When that button is pushed for the infotainment system, I'm going to rephrase again. So I'm as clear as I can be. When that button is pushed for the on event, the key on event, is that like a stopwatch? A stopwatch starts running? Timer?
In the VCH system, yes.
Okay. Separate and apart from the VCH system, is there an infotainment system that also has a timer or a clock on it?
As a clock,
Are those two things independent of one another?
completely independent.
What were you doing with regard to the 3-second delay as it relates to the key on event and the infotainment system event to marry those two things together?
Right. I'm making the adjustment, or proposing that adjustment can be made, because the key on timer is going to start generally as soon as the vehicle powers on. But the infotainment, when you go and download the data, it will say, hey, I think I powered on at this time, and it turns out that time is actually 3 seconds off. So if you're going to then apply the infotainment time anywhere else to VCH data, you've got to realign the two. And that's where the 3 seconds comes from, is these are independent data sources.
Did Mr. Burgess, to your review of his, insofar as your review of his analysis, his report is concerned, did he align the two vis-a-vis the 3-second delay?
No, he did not.
Thank you. With the court's permission, may we have slide 10 of the PowerPoint of,
Okay.
and that is, we've talked a lot about PowerPoints of Mr. DiSogra's PowerPoint. Can you highlight the table on the left, Mr. Wolk? Thank you. Did you create this table?
No,
Was this table, I don't know if you call it cut and paste or if there's some better engineering term for it, was it basically pulled from Mr. Burgess's report?
it was. It was a
Did you type-
it was a screenshot.
Thank you, screenshot. Did you type a single word on this?
I did not. I added a green box.
Put a green box around it.
Yes,
You didn't type anything on this, did you?
I did not.
You were asked a ton of questions just a few minutes ago about whether or not the column on the left and the center column were
Called the right
reflective
things?
of an infotainment timestamp versus an iPhone to iPhone timestamp, correct?
That's right.
Mr. Brennan asked you a bunch of questions about that left column being an iPhone timestamp, at least the top 5 rows of it. 1, 2, 3, 4, 5 rows of it. Remember that?
Yes.
Read the name that Mr. Burgess labeled that column.
Infotainment call timestamps.
So what, as an expert, what did you presume he, as an expert, was presuming? Objection.
Sustain.
What did you presume that meant to you, just to you?
Call timestamps from the infotainment.
So if anything is wrong with your analysis, would it be based on Mr. Burgess being wrong in his analysis?
Objection.
Sustain.
That's a fair question. Whose error was this, including these calls while the phone was not connected? If that's an
Sure,
error,
just a
whose
moment,
error
Your Honor.
was
Sure.
it?
Do you need the light on?
I don't. And we can pull that down. What was your entire analysis predicated on? What was it based on? The foundation of it? As you
Scientific
explained
method. He
your
really
analysis
wants
to Ms. Jerry during the course of the day.
to get scientific
The
method.
testing by Aperture and the collective reports and PowerPoint presentations by Aperture. That would be an initial report by Mr. Burgess, an initial PowerPoint by Dr. Welcher, and a supplemental report by Mr. Burgess.
Did you change any of their data?
No,
Did you change any of their analyses?
no,
Did you explain their analyses?
yes.
Sustained, ask it to.
Sure. What were you trying to do in terms of your presentation in your PowerPoint and your presentation to this jury?
There were a number of different methodologies presented across all of those reports and PowerPoints, and sort of all in different places. So my goal was to bring all of them into one place so we could look at the totality of the data.
You were asked whether the genesis of your analysis relies on knowing the source of the calls, correct? You remember being asked that by Mr. Brennan?
Yes,
The actual genesis of your entire opinion is based on Mr. Burgess's and Mr. Welcher's analyses, correct?
that's correct.
You were also asked why you believed Mr. Burgess did a quote unquote more detailed report in May versus January of 2025. Do you remember being asked that just a few minutes ago?
Yes,
When you presented your analysis, your math, based on Mr. Burgess's January 2025 report, how many of the scenarios indicated, based on his data and his analysis, that the lock event occurred after the texting event?
all of them.
Thank you. That's all I have, Your Honor.
All right, Mr. Brennan.
Of course, they're going to get recrossed, and he won't be limited to redirect either.
So, Mr. DiSogra, this demonstrates the danger or the difficulty.
Hold on.
This is
Start the
It's
question
cross-examination.
differently.
It is, it has to be a question.
Start. Go ahead, Mr. Brennan.
This demonstrates the difficulty in giving opinions when you don't actually study the data itself. Isn't that fair to say?
What are you referring to with this?
Well, you're giving opinions, but you can't verify any of the data because you're not relying on your study of the data, are you?
He's giving opinions
Relying
about
on
their
expert
opinions.
reports.
You're criticizing somebody's report, but you yourself can't defend data that you haven't actually analyzed and broken down yourself.
I don't think that's true.
When you're looking at, run 10 please, when you're looking at someone's report, you're guessing as to what they thought or presumed if you haven't spoken to them. Fair?
Not always.
I would say I'm reading the words that are in front of me and interpreting them for what they say.
When someone plugs their iPhone into a car after it turns on, and the car reads data that's on the iPhone, that data then resides itself or resides on the infotainment system, correct?
There's a transfer of data.
And
Yes.
so unless you actually do the study yourself, you had no way of knowing if that information, although on the iPhone, on the infotainment system, you had no idea whether it was from an iPhone or from the infotainment. Fair?
That's right. I don't think that's,
And so when you
No.
don't actually do the work yourself, and you just presume or you guess, you could get it wrong, couldn't you?
if I had guessed, yes, but I didn't guess. I used the data in the reports and I referenced the testing that Aperture did. So I did not make a guess.
1 through 5, and you telling me right now, to a reasonable degree of data certainty, that that information is based on the infotainment clock. Is that what you're saying?
I don't know.
You don't know. But if you actually did the analysis yourself rather than just Monday morning.
I'd object to this as burden shifting.
So I'm going to strike it, ask it differently, Mr. Brennan.
No, you don't need to ask that at all. No burden of proof on the
You
defense.
have to make a presumption that you'd be wrong, correct?
I don't think the analysis was possible in this case because the testing wasn't done in this case.
You don't know if the testing was done or not. You didn't do the testing.
So I need to hear the question.
You don't know if the testing was done or not, do you?
I know it's in the reports. The testing wasn't in the reports.
Did you read Jessica Hyde's report?
No,
Did you read Ian Griffin's report?
no,
You don't know if that testing was done, do you?
I don't.
I'm going to let that stand.
It shouldn't
I do not,
because
sir.
he knows perfectly
So
well
you're
it's not in those
wrong. Your
reports.
assumptions and product of that wrong.
Part of my conclusions would change. I wouldn't agree that I'm wholesale wrong.
Well, as a scientist, if they're not accurate, that would be wrong, wouldn't it?
That might be a nuanced answer.
I'm sorry?
I said that might be a nuanced answer. Frankly, I'm not sure how to give you a good answer to that
If you
question.
have the wrong data when you're doing your analysis, then the final analysis is going to be wrong if you have using the wrong data. It's
Yeah,
that simple,
garbage in, garbage out.
right? You don't have to be a scientist to figure that out.
Yes, that's
Okay. If we could have Mr. Welcher's 33. If you could open out, please. You were asked about whether the window is within the time frame of 12/32/09, the last user interaction with the phone. When you look at this data, could you go to the top, please? You see on vehicle speed, the car is moving. You see that? Could you enlarge that a little bit, please? The
Good job,
beginning of
on
that
the scope.
data capture, the car's already moving, correct?
I see vehicle speeds right in those first couple of lines. Yes.
Yes?
Yes, I see
Yes.
vehicle speed.
If you go to the bottom, at the end, the car is still moving. Yes?
I see vehicle speeds there as well.
2361. That would indicate, in your experience with text stream data, the car is still moving. Yes?
At the end of the record, there is a vehicle speed. The car is moving. That would be my assumption.
Okay. And so when you're making your conclusions that something's with or without, you're simply talking about the time of the 10 seconds of data. Yes?
Yeah, everything that I've done has been referencing the end of event 1162-2, which is exactly how it's been referenced in all of the other reports.
That 10-second window. Yes?
Not even the window, just the end. Everything in the Aperture reports talks about the end of event 1162-2. So that's what I used across everything.
And when you say end of event, you're referring just to data, not the actual real life event.
Yeah, absolutely. The end of the recording.
Okay. And so after that window, 12/32/04 to 12/32/12, you were asked a question about what might have happened 4 seconds later, 12/32/16. Remember
Oh,
you were
she's
asked
still
about that?
accelerating for another 4
Yes.
seconds?
Did you know at 12/32/16 that John O'Keefe's cell phone moved for the last time? Did you know that?
No.
And between 12/32/12, which is in the 10-second window, and 12/32/16, do you know what John O'Keefe was doing in that 4-second period?
No.
Do you know if he was walking?
No.
Do you know if he was crawling?
No.
Do you know if he was falling?
No.
You don't know.
I do not know.
Okay. May I briefly withdraw?
Okay,
12/32/16, wasn't just that Mr. O'Keefe's phone was moving, there were steps into it, correct?
I didn't review the phone data, so I don't know.
Did you review anything to indicate that steps were taken over the course of 23 feet?
Objection.
so that's sustained.
You were asked just a second ago, what about the data? What if it's wrong? Then you'd be wrong, correct?
Where'd you get the
Generally,
data?
yes.
Garbage in, garbage out. Basic scientific postulate, correct?
Generally, yes.
You're relying on whose data?
Mr. Burgess's data and Dr. Welcher's data.
Thank you.
All right, Mr. DiSogra, you are all set, so you can
Yep.
step down. I'm going to see counsel for a minute. Jurors, feel free to stand up and stretch if you'd like.
We're going to discuss scheduling. Yeah, that we knew that was coming on the redirect. That was just he teed that one up. That was a slider that hung up in the zone. Saw that one coming all the way in from the mound. If the data's bad, then all of your conclusions are bad. Yeah. If only there were some way to identify the source of the data. Assign responsibility for why the data would be wrong. We knew that was coming, using Burgess's mistake as a cudgel against this guy. So, we should, with a half hour, we should have enough time to get at least through direct of Lucky Lochran, if that's the plan. He was seen in the courthouse. He doesn't take a lot of time. He didn't take a lot of time in the first trial, not on direct. He just has a story to tell about his plowing on the early morning hours of January 29th over there by 34 Fairview, and what he saw and what he didn't see. So I don't think we'd have enough time to get to cross, but we should have enough time if Lucky Lochran is next on deck. I would think we would have time to get to him. Not a bad place to end the weekend for the defense. If I'm the defense, I'm trying to get that done. Well, I think this guy, for his second time testifying, this is pretty good. I think he did pretty good for his second time. You want to find a middle ground between
Jurors, we did that to have me decide whether I'm going to let you go now or not, and I'm going to let you go home. So that 5 minutes that just took means that you get to go home, because we know we'll be longer. We don't want to do this to you, okay? So we'll break for the day. I have to give you those same cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. Additional caution, please be very careful. Continue to be careful with your social media use. We will see you Monday. Monday will be a full day. We'll start right around 9 on Monday morning. So we'll see you then. Have a great week.
Please rise for the jury.
So I am guessing, we shall see, but that we are going to be taking up that Commonwealth motion on the Proctor stuff now. Not that she's going to rule on it, of course. I'll sit on it over the weekend or whatever. But so she doesn't have to do that in the morning next week. She can just hear the argument. She already knows what she's going to do. So, just the formality, go ahead and check the box that it's been done.
I'll come back in 5 minutes for the voir dire.
Voir dire. Coming back in 5 minutes for the voir dire. Well, that's something a little bit different, it sounds like. All right. Well, I'll give Bev her 5 minutes. They're just up on the screen. So yeah, what I was saying was that you want to find a middle balance between being a super obnoxious, obstructive, difficult person like Welcher, who's just very off-putting, and being so compliant that you get pushed around. He's already got a good instinct for that. And I just makes sense to me in general that an engineer is going to, be able to spot like problems and questions and like where this question has been loaded up and where there's a hidden assumption and things like that. And so I would love to see him in like 10 years. I'd love to come back and see Matthew DiSogra testify again and see how he responds to a cross-examination like this. Once he's got a lot more experience under his belt doing testimony in court. So I wonder if you might be able to find like little shiv moments. You stay very professional. You can stay very professional, but you just, have little things like, what's the chart that you were shown? This chart that we're looking at. It was presented as infotainment value in his report, so I took it at face value. Mr. Brennan, are you suggesting I should have not done that? No, you wouldn't do something like that. There was a point in there where I think a line was being crossed in terms of suggesting the defense has a burden of proof. Real close to the line on you didn't do the testing, you didn't do any. He has come out and said a few times, you haven't done any testing, you didn't do any testing. which in and of itself is getting a little bit into the beware zone. Okay. Sirens should be starting to ring in your ears off in the distance as soon as you're talking about the defense needing to do testing or something like that. No, they don't. No, they don't. And the jury may not draw any inference from whether they do testing or do not do testing or do, in fact, any sort of presentation or investigation of evidence or anything like that at all, because they have no burden of proof whatsoever. None. So they were getting pretty close to the line there, I thought, where he was like suggesting, well, maybe, you could have tested. No, that's not what he's retained to do. It's not his job to do that. The defense has no burden to do that. If your expert wants their conclusions to be valid, it's your expert's responsibility to ground their analysis in proper testing. You need the experimental information to be able to know what it is that you're working with. Well, overall, I think he came off as very credible. He did come across as I think, pretty good counterpoint to what we just went through with the Commonwealth's witnesses who want to argue with any and everything and concede nothing, not even very reasonable points. He conceded a lot of things, and he also did something that I think can be very effective with a witness, a good witness, like who's trained to do this. I don't think he was, but it's just a thing that you might see. Remember, we've talked before about things that jurors mental shortcuts you might make. A big one is, do I like this person? Do I not like this person? And a great way to make yourself likable with a jury is to be agreeable. But when you're on the witness stand, that doesn't necessarily work out so well. Like, you don't get to agree with everything. Sometimes you have to disagree with things. And so, but there's ways that you can handle that give a little bit of a different impression. So if you're asked, a loaded type of question, or a question that like you need to caveat, isn't it true all of your conclusions would be wrong if the data was phone to phone? And he says yes, with the caveat that there was sufficient testing to make that determination that it was, iPhone to iPhone and not infotainment system to iPhone. Yes, with the caveat that he starts from the position of being agreeable. He agrees first, and then he disagrees. And it's a very effective way of not agreeing with the guy, but in a way that still makes you look very agreeable. Makes it look like you're like bending over backwards to try to give him what he wants, but you can't on this one thing. You got to caveat it. And it's a very different approach than if you said, no, you're wrong because there's no testing to validate any of this, which is what Welcher in particular and Burgess would have done. Welcher would have heard that question about, isn't it true that all your data, your conclusions would all be invalid if that chart showing the infotainment system was actually iPhone to iPhone comparisons? He would say no, because there's no validation that infotainment system was iPhone to iPhone, because they didn't do the testing to be able to substantiate that. So my conclusions would be just fine. Number one, he's not even answering the question, right? Not even really answering the question. But two, he's starting with a disagreement, and he's leading with that, and he's making that the key feature of his answer. So it's just you're saying the same substantive thing. You're saying the same substantive thing. It's just one person is saying it in a much more likable way than the other one is. And he's saying it in a way that comes across as much more reasonable. trying to find common ground and agreement rather than trying to find conflict and disagreement and dispute and things to argue about. So I think that came through loud and clear, not because this guy is a trained witness, to do anything like that, but that's just kind of what his instincts are. And they seem like pretty good instincts for a guy testifying for the second time ever. That seems pretty solid. So, boy, since lunch, did we really have anything notable since lunch? We just kind of kept establishing he's just relying on what the Commonwealth's report did, included, and so what their witnesses said, and so it doesn't really care how granular you want to get with their analysis. Whatever I concluded is based on what they concluded and presented and did, and so, whether the 3-point turn or whatever. He did not make a mistake in adding the 3 seconds. Hank was trying to suggest he's double dipping. But no, then he explains very clearly. It's not that it's an extra 3 seconds. It's because you're pulling time from the timestamp from the infotainment system. You're trying to tie it to the key on time from the VCH that starts the VCH runner going. And so if it had its own time, if the VCH had its own timestamp, then you wouldn't do that because you'd already know it. But it's the only way to be able to reconcile those two in order to align them. So that makes sense. It got spelled out explicitly. Talking about this just over the break, like I think I figured out that's why we do this adjustment. But it hadn't been spelled out. Now it's been spelled out, and I think it made perfect sense. Very easy to understand. That's when they had the camera on Karen, and she was looking very pleased with this answer, very pleased with this witness, how everything is going. Yeah, that's right. No, Hank, it's not double dipping. Here's the explanation. And the reason why this is unique is because nobody but Aperture has tried to do this before and tried to reconcile the infotainment data and the text stream data. But yes, it makes sense. The first thing you would need to do if they're separate clocks, you need to reconcile the clock.
Floor is now open. You may be seated.
So you're going to step up, face the clerk, and raise your right hand.
You solemnly swear the evidence you give the court in the case now and hearing to the truth, the whole truth, and nothing but the truth, so help you God. Thanks. You take the stand.
Thank you.
You're welcome.
I know this is a an opportunity. There is a witness outside. You have to go back just to get her.
Sure, is she right outside the door?
Last time I checked.
Do you mind, sir, if you can stay right there?
Sure.
And it'll just be a few minutes, okay? Mr. Yanetti, when do you need this witness back? Monday?
Remember, Lucky was Mr. Yanetti's witness from trial 1.
So I'm going to need her at a microphone. Do you have one on council table there? So the podium, or one of those back where Eugenie is.
What is
Thank you.
happening? This is confusing.
No, there's a microphone a little closer. Just follow the.
Stand up. Thank you so much.
Hi, good afternoon.
Hello,
Could you tell me your name, please?
Kelly Dever.
And Ms. Dever, you've been summoned here. I think I saw you earlier. You've been here all day.
Yes.
All right. So we're not going to reach you today, unfortunately, but you were summoned to be here.
Yes.
All right. So that summons is still good until we reach you. So you're going to have to come back Monday morning. Okay.
Yes, ma'am.
Do you agree to do so?
Yes, ma'am.
Okay. Thank you very much. We'll see you Monday morning. Be here before 9. Okay.
Will do.
All right. Thank you very much.
Thank you, Your Honor.
Go ahead, Mr. Lessie. Oh, geez, Yanetti.
That was a big compliment, Your Honor. Thank you. Good afternoon, sir. Would you please state your name and spell your last name?
Johnathan Diamandis, Diamandis.
You've also been here all day.
Yes,
Sorry for making you wait.
no problem.
Do you know former State Trooper Michael Proctor?
I do.
How do you know him?
I've known him since middle school, probably the 6th grade.
Grew up with him essentially?
Grew up with him, been friends for 30 years.
Okay, and if you just keep your voice up,
Sure, yeah.
I'm sure other people can hear you, but this old
So
guy.
can we turn off the fans and the air conditioning? Are they all off? We're just gonna do that, sir, so that we can get through this a little bit.
Absolutely, sure.
Much better, thank you. So you say you've known him since middle school, elementary school?
Yes,
Graduated high school with him?
yes,
And are you friends after high school as well?
yes,
Do you have his cell phone number in your phone?
I do.
Have you texted with him over the years?
I have.
In fact, were you on a group text chain with him that lasted a number of years?
Yes,
I would like to show you a document, sir, and I'm going to ask you to read it to yourself, familiarize yourself with it, and then when you're done, look up at me. Okay?
Okay.
May I approach?
Yes.
So this is dealing with that
First, Your Honor.
Yes.
hearsay motion, and he is coming in to authenticate the text.
Okay.
Exhibit NNN for identification.
And now I'll give it back to the witness. Thank you.
thank you.
Remember this group chat? Remember being a part of this? We're gonna have to see, huh? Gonna have to see. Doesn't matter if he doesn't remember the text himself, as long as he can authenticate the number as being from Michael Proctor. The group chat as being one he engaged in with Michael Proctor. He doesn't have to identify each single message. That would be enough to be able to get in, the ones the defense wants is authentic. And if there are issues with that, they go to the weight and the Commonwealth can raise them. Guys, I don't think Bev's going to keep these out on authentication. If she keeps them out, it'll be on hearsay. She will, I don't accept these are not offered for the truth. Something like that. They clearly are, but she let him in the first trial. I don't know how you get around it. Of course, they had Michael Proctor the first trial.
I think he's all set, Mr. Yanetti.
Thank you, Your Honor. Sir, have you reviewed that entire document?
Yes,
Does that look familiar to you?
yes.
What do you recognize it to be?
It looks to be a text chain with a group of my friends that I grew up with.
Okay. And so would all of those friends have been people that you went to high school with?
Not all the same high school, but the same time. Some of us went to different schools.
And you were friends during that era?
Yes.
And you've remained friends for how many years since then?
I mean, we've been friends for 30 plus years, probably.
Do you know precisely when that text chain started?
I do not know when the text chain started.
Months, years?
Years, definitely years.
And that's a portion, in other words, there's a start time and an end time to that, but the text chain started before the start time that's listed on that document?
That's correct.
Now, I'd like to ask you about 5 different categories of information that allow you to identify the text chain. First of all, directing your attention to page 1. That is an unredacted version of this. Do you see your phone number on page 1?
I do.
And is that accurate in terms of your phone number?
It is.
Do you have a passcode on your phone?
On my phone, yes, I do.
All right, and have you had that for years?
Yes.
So as of January of 2022, you would have had a passcode to get into your phone, correct?
Correct.
With regard to the typing of text messages, you didn't appear to be too active on this thread, is that correct?
Not from what I see here.
Did you see one entry that you actually did text?
Yes, one.
Okay, and I think these page numbers, they're all numbered. Could you direct us to the page where you actually chimed in?
Oh, does he like?
If I suggested to you, it
not
might
cool?
be 4 from the end. And you don't have to read the actual text, sir. I just want to.
Sure. I'm just trying to locate it. Yes, I see it.
Okay, and the time of that, date and time of that text as it's reflected on this document?
February 2nd, 2022, 12:38 p.m.
Okay, and what you
I
type.
have a different copy.
Oh, I'm sorry. It's for the record. It's on page.
What's the bulk of page number? So the last 2 digits. 4.
And for the record, reading what is typed there, does that sound consistent with something you might chime in a text message, a text chain of this sort?
It could be. I have no memory of actually typing it, but
sure,
that's not something. I mean, it could have been something that I would say. Yeah.
At the very last line of that text, do you mention somebody's nickname?
Yes.
And what nickname is that?
Chip.
And whom do you know as Chip?
Michael Proctor.
Now, going back to the first page, there are a number of other phone numbers there. Have you checked your phone prior to taking the stand today to match those phone numbers with other friends of yours?
Yes.
And if you could, and hopefully you remember them all, can you list by first name only your friends who are included in this text chain?
Sure.
So,
I don't think it's necessary.
yeah. So let's not, if he recognizes, I don't want to put names out.
Oh, I don't either, Judge. That's why I was saying first names. But if that's sufficient that he recognizes.
Why don't you refer to the last 2 digits in the phone?
Sure.
Is that acceptable, Mr. Brennan?
It is.
Okay.
Okay. You see, I'll list the last 2 digits of the phone numbers that don't have a name associated with them. Okay?
Okay.
If I may just have a moment.
Yes.
Yeah, of course. Okay, starting with the phone number that ends in 51. After you checked your contacts, is that a friend of yours?
Yes, it is.
Who was on the text chain?
Correct.
With regard to the phone number that ends in 68, same question. Is that a friend of yours who was on the text chain?
Correct.
And with regard to 45, which is the next one, again, a friend of yours who was on the text chain?
That's me.
Oh, I'm sorry, that is you,
Yeah.
of course. With regard to 95, is that a friend of yours who was on the text chain?
Yes, it is.
And with regard to 93, same question, friend of yours on the text chain?
Yes.
And then there are 3 numbers there, one that ends in 11, one that ends in 46, and one that ends in 82. Do you see that those particular numbers have a nickname associated with them?
Yes.
Those nicknames, do you recognize them as being also friends of yours who are on the text chain?
I do.
And then finally, there is somebody listed as local user. We'll get back to that one.
Okay.
With regard to the other ones that you've just identified, sir, have you texted back and forth with them on those phone numbers over the years?
Yes.
And also with regard to this particular text thread?
Yes.
All right. Now, I'd also ask you, with regard to the content of these messages and who said what, and particularly focusing on the one that's identified as local user. Having read that text chain, were you able to determine who local user is?
Yes.
And who is that?
Michael Proctor.
And was that by the content of the messages that Michael Proctor typed that you recognized it?
Yes.
And with regard to whether this is a complete, accurate record of what it purports to be, what is your testimony in that regard?
I believe this to be a record of our text chain for this period of time.
Appears to be accurate and complete.
It does.
If I may have a moment, Your Honor.
Okay.
How cooperative is this guy? Look at him. He's got a furrowed brow. This is not easy for him, but he's being so cooperative. He wants to do this, but he knows there's going to be blowback. He's losing a friendship. Probably losing multiple friendships.
The text message chain that you read fairly and accurately represent the circumstances of the conversation that was going on?
Yes.
Nothing further.
Mr. Brennan?
Good morning.
Good morning.
Good
Good afternoon.
Do you have an independent memory of any of the text conversations in the package that you reviewed?
I do not have a memory of this happening.
Thank you.
That's it.
All right, so sir, I'm going to ask you to, you're all set.
Okay.
I'm going to ask you to step down.
Okay. Thank you.
Your Honor,
That does not make them not authentic.
unfortunately, this witness was not reached by the jury today. I would like him recognized as well.
He has counsel here with him, right? Does he have counsel here with him? All right, sir, you'll make sure your client is here when we need him?
I will do so, Your Honor.
All right, thank you.
My name is Thomas Campbell. My office is in Boston.
And I'll speak with Mr. Campbell in terms of an appropriate time of day. He's been very cooperative.
All right. So sir, you can leave,
Okay. Thank you.
right? And thank you, Mr. Campbell. We'll see you. We'll let you know when we need you back. It's probably going to be Monday first thing.
Understood.
Not a lawyer.
So watch your step coming down.
Probably Monday first thing, so we are going to let him in, right? Because they're definitely authentic.
Mr. Yanetti.
So, Your Honor, my understanding is there's an objection, so I've got to respond to the.
I want to hear you as to why this is admissible.
That's fine.
Goes to bias, Your Honor. Thank you. Sit my ass down. Christ almighty.
So, Your Honor, with regard, I assume we're just dealing with authenticity at this point?
No, we're dealing with both. You're the proponent of the testimony, so let's deal with both.
Okay. All right, so regarding authenticity, Your Honor, there are several ways that are either independent or connected with each other by which or through which a party can authenticate text messages. The majority of the case law out there are defendants having appealed judges' decisions to admit text messages offered by the Commonwealth, and the majority of the case law that exists affirm judges' allowance of text messages into evidence. The Commonwealth filed a memorandum in opposition to these text messages being admitted, and not one of the cases cited by the Commonwealth apply here or are appropriate. The case of Commonwealth versus Purdy, in that case, the Commonwealth introduced text messages from computers seized at a massage parlor. The defendant objected that there was no evidence that he had authored any of the, these actually were emails, not text messages, any of the emails that were admitted into evidence. Nobody saw him do it. Nobody saw him type it. And nobody discussed any of the emails with him. But the SJC cited a longstanding rule, including Rule of Evidence 901B1, evidence may be authenticated by direct or circumstantial evidence. And the circumstantial evidence is essentially what we covered here in court today: the appearance of the electronic communications, the content, the substance, internal patterns, or other distinctive characteristics. Commonwealth versus Welch. It was a murder case where a boyfriend killed his girlfriend, was charged with killing his girlfriend, was convicted. The Commonwealth sought to introduce text messages between them, and various text messages from the victim's cell phone were admitted into evidence because, for one reason, they referenced the defendant's distinctive nickname. And in this case, we have a text chain with 3 nicknames, all of whom the witness recognized as being his friends. We have more to authenticate this text chain than in any case I have seen, and also more than in any case the Commonwealth has cited. In this case, we have an identification of every phone number pursuant to the last 2 digits. We have an identification of Michael Proctor's message relating to the contents. We have evidence of the witness's cell phone requiring a passcode, meaning that in order for his phone to be active in this chain, he would have had to have unlocked the phone with the passcode. And he testified that what was in the content of the message that he identified as being his is consistent with something that he would have said. And not only that, but he adds a 4th nickname, that being Chip, that being Michael Proctor. The Commonwealth, with regard to Commonwealth versus Welch, which is again cited in their memorandum, this opposition, Your Honor, they state what appear to be rock solid black and white legal principles, but when you scratch below the surface and you actually read the case stands for nothing in terms of what they've represented it to be. They stated that in Welch, the court must find that each and every communication was authored by the individual member of the group. That's just plain false. The case doesn't say that at all. It's nowhere in that case. And in fact, the messages were let in, again, because of the circumstances and the content of the messages. Commonwealth versus Raposa, another case that they cite. The defense sought to call a neighbor to testify that he had seen the victim alive after the defendant had confessed to having shot him, another murder case. The problem was that the neighbor denied making the statement, so the defense wanted to call the neighbor for the sole purpose of impeaching him with his prior statement that he supposedly made to the police and use that statement as substantive evidence. So in that case, the defendant wanted to use an out-of-court statement for its truth. It was rank hearsay. That case had nothing to do with text messages or statements used to show state of mind or electronic communications. But somehow it makes its way into the Commonwealth's memorandum. Commonwealth versus Rajiv R., which is the second to last case that they cite, that dealt with a search warrant done at a juvenile's home. The police officer in that case was allowed to testify to what he was seeking, which was the goal of the search warrant, a firearm allegedly in the juvenile's possession. And he was also allowed to testify to what the juvenile's mother did during the execution of the search warrant, which is she directed the police to the juvenile's bedroom. The Commonwealth cited that case to say you can't use hearsay when trying to prove a Bowden defense or present a Bowden defense. That case had nothing to do with Bowden. The evidence was admitted to explain what the police were doing in the home. So it's a situation where
David,
you know,
no, it was overruled.
They
agreed. They thought it was harmless
somebody
error
on the street, or the police get a search warrant and then they show up at a home, and rather than just have them magically appear at the home with the warrant, the police are allowed to give some circumstances as to how they got there. Nothing to do with Bowden. It's just giving the jury a fuller picture. Yet it was represented to you by the Commonwealth that, geez, this is a Bowden issue and you can't use hearsay to present a Bowden defense. Commonwealth versus Sullivan, exact same situation. Testimony was admitted about DNA on evidence matching the defendant's DNA from a national database. The Commonwealth cites three principles. It's almost like they're setting a standard down that the court is supposed to follow with three factors. But again, none of the three principles that the Commonwealth cites is found in Sullivan at all. They're not even mentioned in the case. They're simply made up and put in a memo to ask this court to do something that the case does not support. And again, it has nothing to do with Bowden. So now we come to the arguments about the fact that the Commonwealth is claiming that these statements are hearsay. They're not. These statements contain insults of my client. I'll be kind and just mention the word.
So I read them.
Yes, okay. Well, I mean, Your Honor, if you're going to allow this into evidence, I'll stop talking. Otherwise, I have to make my argument.
I understand what you mean by insults.
Okay. So I won't even mention them then. The Commonwealth is essentially arguing that we're offering these text messages to show that the insults were true. That's a silly argument. Obviously, we're not. Hearsay has three components. These are all statements out of court. None of them are offered for the truth of the matter asserted. None of them.
Yep.
Even the statement when Michael Proctor says that the homeowner is not going to catch any grief because he's a Boston cop. We don't know if that's true or not true. It's offered to show that Michael Proctor believes it's true. He's the lead investigator in the case. He has input into the case. He can decide who's investigated or not investigated. At least that's our argument. It's all consistent with our defense. It's offered to show his state of mind. Everything that he says is offered to show his state of mind and to show his bias.
Thank you.
He, as the lead investigator, his bias in what he does or doesn't do. And in fact, Mr. Brennan said at Sidebar earlier when we started this conversation that Bowden deals with what was done or what was not done. We're entitled to explore what was not done and not done, and we're entitled to explore why.
Yeah.
We have evidence of why. We have Michael Proctor's words about why he did or didn't interview people separately, why he waited, for instance, a year and a half to interview a plow driver who was out there on January 29th, why he treated some people with kid gloves and other people with brass knuckles. He's stating it in these text messages. She's going to go down for this. We're going to pin it on the girl. We're going to make sure that there are some serious charges. She's effed. Those are what he says about Those are the statements he makes about Karen Reed in the infancy of this investigation. And to the contrary, is anything going to happen to Brian Albert? Nope. He's a Boston cop too. These are all statements about Michael Proctor's state of mind. The prosecutor and I have been over the statements. I realize he's objecting to the admission of these statements. I don't think he has a legal argument that passes muster to do that, but should the court allow them in, we're agreed on everything except for 3 entries, which I think we could deal with pretty quickly. And unless the court has questions, I'd rest on that.
No, but I'd appreciate a copy of whatever you've agreed upon.
Okay.
So it's been a long day for staff, so I don't need to sit here and go through each one. Just get me a copy of what you've agreed to.
Okay. So this is the only marked copy. I'm happy to hand it to the court.
You can take care of it and email it in.
We'll do that. Thank you, Ron.
So, Mr. Brennan, I'd like to hear you on admissibility. I haven't decided admissibility, and I'll hear you on authentication.
On the first issue of authenticity, this witness has no memory of any of the text messages. I think it's fair to conclude he's on the text message string. He recognizes the people on it, but there is no authenticity if he doesn't recognize them.
Sure it is.
The person that could best authenticate these text messages
not remembering is different.
Is Michael Proctor. This witness does nothing as far as identifying the individual text messages and whether they're reliable, whether there's been any additions, deletions, whether in sum and substance this is part of the conversation. Notably, I think, according to the questioning by Attorney Yanetti, he's made one comment at the end of the string that really has nothing whatsoever to do with the text messages that are at issue. So
why did they pick him?
I don't believe this witness reaches that conclusion for them. Regarding admissibility, I do not dispute that in the right context, these text messages are admissible. If there is an investigator in a case that makes derogatory remarks about an accused, I can't say that doesn't go to bias, nor do I reject the idea that it shows an unfairness or a motivation. But really, you need to put that in context, and I think Attorney Yanetti highlighted that. He says that this is not hearsay, it's how he thought, or whether it affected a particular part of the investigation. It may have, it may not have. Even if he denies that it affected his investigation, it's still an appropriate question to ask just because that type of negative commentary, inappropriate commentary was made. But to explore the state of mind and put it in context, you need to ask the person that you're accusing of having the bias. Because perhaps it did affect the bias.
You don't have to
perhaps
ask
the
Karen
person
about
was
all
very
your
biased and made
guilt
decisions
stuff,
based on that animus. Or perhaps the person made negative comments but had nothing whatsoever to do with the investigation.
So call him and clarify.
It is surmised to say because these comments were made, a witness was not investigated, or there was some other amorphous, undefined ill that happened. That's the whole reason why the witness who made the comments should be confronted with the comments they made so the jury can fairly assess, is this relevant, is it material, and what is the value of it? I am not opposed to the admission of bias against a witness, especially a police officer. But it should be against that witness because they need to have the opportunity to admit, deny, define, accept, and explain.
No, they don't.
Putting these messages in with
if you think that
sidestepping, calling Mr. Proctor, they are trying to gain the advantage of putting information in front of the jury that has no context.
Oh, like you did with
suggesting
those
it has a
clips,
value that
Karen?
has not been defined. And then, as Mr. Yanetti just did, making an argument that because the comment was merely made, that therefore there was a consequence, and specify a consequence where there's no factual basis to conclude. Because he made a derogatory comment, he didn't investigate or speak to a plow driver for a year and a half. That defeats the purpose of defining the value for which this is being admitted. I do have some issue that it's really not under the context of Bowden, because this doesn't have to do with the adequacy of a police investigation. It has to do with bias. And that purely is the state of mind of the person who made the comment. I would not get in the way of confronting the witness about their bias if they were called to the stand. But to put it in this way invites speculation, it invites manipulation, and it invites a party on either side to portray this in a way that is not factually
Why
viable.
you turn that mirror
It would
around,
be
Mr.
distracting,
Brennan?
confusing for the jury, and it could be unfair for either side because it will lead to arguments about what it means without a factual basis. And so my position is, I don't necessarily disagree that it's relevant, but it should come through Michael Proctor. And if the defense wants the value, they should call Michael Proctor.
Okay. Ms. Yanetti, do you want to respond?
I know we're the hour's late, Norm. I won't belabor the points. I would state the following very as succinctly as I can, which is, yes, it goes to bias, but it also goes to the adequacy of the evaluation. The two concepts are intertwined. If you're biased or exhibit bias, the defense should be able to argue that the investigation was not adequate. I would note Mr. Brennan is not sitting at defense counsel table in this case. We appreciate the offer to help us with strategy about which witness we should call, but that's solely the province of the defense to determine which witness we want to use to authenticate and admit text messages. That's our choice. And we should not be deprived of that choice because Mr. Brennan thinks there's a better witness that should have introduced the text messages. There is no rule. There's no best witness rule in this case. I believe my co-counsel has already made that argument in another circumstance. His arguments, Mr. Brennan's arguments, go to the weight, not the admissibility. He is fully entitled to cross-examine this witness about all of the points that he raises. And in conclusion, Your Honor, he complains that we have not called Michael Proctor. I think that's the whole impetus for this objection, so that we will call a witness that they do not have confidence in to call themselves. It's unheard of in a murder case that you don't call the lead investigator, but that's what's happened in this case. We should not be forced to call Michael Proctor so that Mr. Brennan can then cross-examine him and lead him through basically his entire closing argument. He is entitled to call Mr. Proctor in rebuttal. He has every right to call Mr. Proctor again. I would rest on that. Thank you.
Okay. And just the very last thing is Commonwealth's motion for reciprocal discovery. Is there any objection to that?
Yes, no, it's not in compliance with Rule 14.
Okay.
We don't have any written communications with Ms. Deborah, and they've asked for all oral communications to be reduced to writing, to be turned over. That's not in keeping with Rule.
All right. So you're saying two different things. So you don't, this information doesn't exist because she has not had communications with you, right?
Written communications do not exist. I'm not saying two different things. Written communications do not exist. They also ask secondarily for all oral communications to be reduced to writing. We have no obligation to do that. We have no intention.
All right, so I'll get a decision out on that before 4:30, and I'm going to do a little more research.
Gonna make 'em do
on
it.
the text messages. Want to be heard, Mr. Brennan?
I thought you were standing up, Your Honor. No.
Oh, no, okay. All right, I'll see everybody Monday morning.
Thank you.
Please.
So she'll do an order before 4:30 on this Rule 14, which means she's going to make them reduce it to writing, even if the rule doesn't require it. Why don't we just go ahead and take a look up the rule. I can't spell Massachusetts today for some reason. Rule Criminal Procedure 14. What is the reciprocal obligation? Well, actually, yeah, Rule 14 is the prosecutor's obligation, right? It's not the reciprocal discovery rule at this point. There's another rule that applies to that. Hang on, I'll find it. Retrial reciprocal discovery from the defense is now Rule 14.1, and it just says anything that is relevant and material discoverable under 14B1F. Hang on a sec. B1, F, G, and H. And a witness statement has the meaning defined in Rule 14B. Okay, so let me just pull this up so we can all take a little look at it. I'm not going to pull up. 14.1 just says that the defendant's pretrial discovery obligation is limited to certain aspects, certain parts of this rule. So 14B1, let's find 14. Oh, they renumbered. How cute is that? Okay, no. 14B1, investigative materials, F, G, and H. Expert, photographs, video, audio recordings, reports of physical examinations of any person or scientific tests. That definitely doesn't seem to be any of those things. Including the names, addresses, known contact information, dates of birth, and written statements of those persons whom the defendant may call as witnesses. And it has the meaning defined in Rule 14B3. So 14B3, what's a witness statement? There is no 14B3 that I'm seeing. Okay, 3, statement definitions. The term a written statement as used in this rule means a writing made, signed, or otherwise adopted by a person having percipient knowledge of relevant facts and which contains such facts other than drafts or notes that have been incorporated into a subsequent draft or final report, or a written stenographic, mechanical, electrical, or other recording or transcription thereof, which is a substantially verbatim recital of an oral declaration, except that it's computer assisted. So how I interpret this is it means a person has either given a statement, like I give it to you orally and you write it down and read it back to me and I say, yes, that's it. And I sign off on it or otherwise adopt it. Or I write it myself and I sign it and I say, this is my statement. Or I'm interviewed and there's a recording or there's a deposition transcript or something like that. This does not mean, as I read this and understand it, that if we had a phone call and this person told me stuff, this rule requires me to write down the substance of that phone call and give it to the other side. I don't have to create a written statement. Just if I do it, it has to be produced. So then back to Rule 14.1, there's nothing in it that says there needs to be oral statements given. We see that this Rule 14B3 also defines an oral statement, which is any communication by speech or nonverbal conduct of a person having percipient knowledge of relevant facts and which contains facts that is not a written statement. So, for example, the contents of a phone call where I tell you about what I know that'll be the subject of my testimony, that's an oral statement. That is not within, I'll switch over to 14.1 now, the defense duties. Okay, we already looked at these ones. These had to do with experts. It's not that. So they have to produce all of those things. Including, names, addresses, known contact information, dates of birth, and written statements of those persons whom the defendant may call as witnesses, and any inducement. Nothing requires production or memorialization of any kind of oral statement. It doesn't require that oral statements be made into writing and then offered to the witness to adopt and then provide that in discussion. There's nothing about that. Nothing about it at all. And yet, why do I have the idea? She's going to make him do it anyway. She's going to say, write it down, give it to him. They've had who knows how long to call this person themselves on the phone, have a conversation, presumably just like the defense did. And she needs to read more. She needs to read more about the text messages. Of course you do, because you need to find something that doesn't apply here. Brennan didn't give you very good stuff that doesn't apply. You need to go hunt down and independently find something else that doesn't apply. I don't know, a rule of interpretation. You already pulled that trick. I don't think it's efficient, so I'm not going to allow it. Completely not what that rule means. In construing the rules, they should be interpreted to promote the fair and efficient and whatever resolution. It's a very common type of statement that you get in statutes. If the legislature bothers to tell you how we want you to interpret these statutes, they'll tell you, yes, we want it to be efficient, fair, promote justice, and so forth. It's not a substantive limit on applying the rules of evidence. It doesn't mean, for example, we'll throw the hearsay rule out because it wouldn't be efficient here. It's not at all what those types of rules mean. But she already did that once, so who's to say she won't do it again? This one should not require research. It is really crystal clear. Of course, it's not being offered for the truth. Of course, it's not being offered for the truth. They don't actually think Karen is a whack job. See you next Tuesday. They don't actually think that. No shit on the homeowner. I bet they're kind of hoping that's not true either. It should fall on him. Pin it on the girl. That ain't true. That's going to be up to this jury. And they're very much hoping that's not going to be the case. So none of this is offered for the truth. It's very, very clear. This is all going to state of mind, his motivation. This really shouldn't, this should not require you to step off the bench to make this ruling. It is easy. Oh, man. It would take it out of context. You have to ask the person about the state of mind. How many implications have you made about Karen's state of mind up here in this trial so far already from varieties of different sources without asking Karen about it personally? Why on earth does somebody's own self-report, when they're confronted with, something embarrassing that they did, their own self-report about why it's really not that bad, why on earth is that necessary? It's not necessary at all. The jury can decide for themselves independently how significant they think that text message is. If you think there's an excuse for it that he should offer, then you call him. Let him explain it. But the jury can infer things from the evidence just exactly like you're trying to do with those interview clips. Literally trying to cut and paste pieces of her statements out of what I would assume were quite lengthy interviews that she gave to all of these different outlets. And some of them were, chopped up and picked out and selected from when it came to producing the final piece. But we've gone through here and cherry picked statement after statement after statement. Why? You literally just made an argument to try to overcome the defense motion for a directed verdict, for a compelled, not guilty finding, based on what you say Karen Reed's words say about her mental state. See, so you understand perfectly well how those inferences work. Because the jury can look at what you said and decide for themselves what they think about it. Of course you want to scramble and try to explain it after the fact. I don't have to give that any weight at all. It's not remotely necessary. You may think it's helpful, and if you do, then offer it. You put him on the stand. This one shouldn't even be difficult. And yet here we are. Bev is back in chambers, desperately searching for some basis to be able to keep this out. Why? Because she had a guy there for voir dire who looked like he's there to do something that he doesn't necessarily love, doesn't necessarily make him feel good, looks stressful for him. My God, his whole forehead made him look like a basset hound dog or something. He's not happy about it, but he's gonna be honest about it. And that's your kryptonite, isn't it? An honest person with integrity on the witness stand? No, can't have that. That might look really bad for the Commonwealth. So we can't have that. I'd love to be more optimistic that reason and law will prevail on this decision, but unfortunately, we've just all been burned a few too many times, haven't we? We've been burned a few too many times. Well, I'm assuming she's going to do a written order. Where it is. I'm assuming she's going to do a written order very quickly, telling us probably immediately, oh, yes, you guys need to go and reduce stuff to writing. Give it to the Commonwealth. And she might have to think over the weekend. She might have to search a little harder to find a way to keep out the text messages. Yeah, you rarely get a group chat that is this thoroughly authenticated. Every single person in it known since grade school, middle school, he said, middle school. They've been friends for 30 plus years. He's texted with all of them. This isn't like you accidentally got added on to the group chat and you don't necessarily know who's who, This is not that situation at all. These are all people he knows, all people he recognizes. He refers to a speaker as Chip. Means perfectly well it's Michael Proctor. You rarely see a group chat, a group text like this be authenticated this thoroughly. He doesn't remember them. What kind? Imagine that. Let's turn the tables for half a second here, Hank. Let's put your defense attorney hat right back on, and just imagine a world where a prosecutor is like, "No, I can't admit the text messages of the defendant admitting to committing the crime because the defendant is on the stand and the defendant doesn't remember them. So that's definitive. That's it. It doesn't matter. It doesn't matter if they remember it. Remembering it is not part of the test for authentication. You don't have to remember it. And it is the most predictable thing ever that anybody that's confronted with a text they wish they hadn't sent would be like, I don't remember that. Of course they're going to say that. And nobody's going to believe it. But that's the game. That's the game. It doesn't mean it's not authentic. It means, hey, you want to be able to explain it? Go ahead, put him on the stand and let him see if he says, I don't remember sending that. I don't remember sending any of these texts. I don't remember saying those things about Karen. Go right ahead. Go right ahead. That'll be considered along with everything else that goes to credibility. You don't remember. Hey, looks like X is nuked again for the afternoon. So if there is a ruling that's going to come in, I'm not going to be able to see it because that's where I would find it. So, oh, guess I can get rid of my banner now. We're done with that. All in one day too, right? Gets filed. Defense has the people in. They are ready to go on the stand. We chew up the day with a lot of unnecessary, cross-examination of repetitive, improper stuff with Matthew DiSogra, but it happens. Things run long. We get it. Defense got to deal with this on the fly with the witnesses here in the courtroom. File a brief even? Oh, no. Oh, no. Nope. Just react to the obstruction that is being thrown up by the Commonwealth. Notice how Bev started that whole argument off saying, you're the proponent. You're the proponent of the evidence, Mr. Yanetti. It's your burden to establish. Hello, foreshadowing. She's going to say they haven't met their burden. Haven't met their burden. Only, I don't know where she's going to go. I don't know. I don't know what her out's going to be. She's just desperately going to find one. She's going to hunt and try to find something. Extremely good voir dire. I thought. Just, I continue to enjoy Mr. Yanetti quite a bit. He's a very good lawyer. He is able to keep it simple. He knows what he needs to establish. He knows how to authenticate a text message. That's what he got in, and that's all. That's all he did. We didn't have to do any drama. We didn't have to run around. We didn't have to, pre-poison the well, so to speak, with like the substance of the text messages, anything like that. Nothing. We just covered it, established who's who knows what. How do you guys know each other? You know these numbers? Yep. Figured out from the content of the messages that the local user was Michael Proctor, and it's accurate and complete. He believes it is. We're done. Okay, we're done. These texts are authenticated. Like you rarely get one this good with a group chat. The group chat, much more often you're getting like, I'm not sure I recognize that person. And then it only matters if that person's communication is the one that you're trying to get into evidence. Otherwise, we just ignore that. It doesn't matter. But if you recognize the group chat as a whole as one that you participated in, even if you don't know the individual participants, you've authenticated it. Unless it matters, like real specifically, who's saying what, you get the whole text chain in. So then when it matters real specifically who's saying what, you got to be able to authenticate those people. And he can authenticate Michael Proctor very clearly, not just by his phone number, the fact that he's texted Michael Proctor on this phone number before. He knows it's Michael Proctor, but he's also got a 30-year relationship with Michael Proctor, and he recognizes the content of the messages. The hurdle is cleared. Like these are well authenticated. Doesn't matter if he doesn't remember them. So they should come in, but we'll see what happens. We'll see what happens Monday. Monday's going to be a full day. We may or may not start right off the bat with Kelly Dever. Just brought in to, be told you're going to have to come back. Be here probably Monday. I guess they'll be in touch. So just advising her she's still under subpoena and is not released from that is my best assumption. Probably what happened is that these witnesses were subpoenaed. They were, required to be here today. But since they weren't able to be called today, they just need to be advised they're still under the command of the subpoena, and they don't get to just forget about all this yet. Unfortunately, I'm sure they probably wish they could. So, well, that's our day. That's our week. First full day of the defense. Nothing real new, shiny, sexy, no new facts really that jump out as like, ooh, got my attention, but very much a mood shift. I think we have very much a mood shift, just in the tone and demeanor of what we get from the witnesses. We have a guy who wants to say yes, but rather than no, because. And it really is amazing. You pay attention to that. If you pay attention to that, like, you can really notice how it really changes the whole vibe. What do you lead with? Do you lead with yes and then qualify it, or do you lead with no? Which part is more important to you? So, with that, guys, what have you guys been thinking? We've got my Mini 67, the Occiput Boner. Hilariously, your Subaru is a Toyota GT86. My Subaru is not a Toyota. My Subaru is a Subaru, but they are both using the same basic technology. I'm trying to remember now exactly how this worked, as far as who designed what and who engineered what. I don't remember the details off the top of my head, but no, you're right. There's a lot of overlap, but my Subaru is still a Subaru. I will stand on that. John Beattybot. Does DiSogra need to correct testimony to the effect that 1162 or in general events alleged on 1229 or 129? I worry about his last statement. Paranoid. What was his last statement then? Do you need to correct anything? Was that was from Brennan during the cross? I didn't write that one down, so I'm not sure at exactly what point that came in. But I don't have an issue with it. I don't have an issue with it. If he's going to be corrected, fine. Then it'll come up in rebuttal. But they kind of already had their chance to pre-correct it. You had Welcher and Burgess on the stand, and you certainly already did ask them about stuff that DiSogra did, because we had to have Burgess blaming DiSogra for including Burgess's data in DiSogra's analysis. So I don't think that that's coming. I feel like that's just maybe a little bit of an empty threat, keep you on pins and needles, or just send the hint to the jury that maybe there's something else here. But I'm not sure that this is a check that's ever going to clear. Rotorman Dan, how many times this morning did Bev say, I will allow that versus sustained? Somebody that would be a good counter for somebody to have done throughout this trial. I didn't think about it. Way too late to go back now and try to track that one. I don't know. Actually, maybe we could do it from the transcript in YouTube. Go back and probably wouldn't be that difficult. Actually, go through those transcripts and count the sustain versus allow. Yeah, great question. But when it's Mr. Brandon asking the questions, she's allowing it. She's allowing that one. Matthew Madu. When did Bev rule Hank could use the amended report? That could explain the wait until the 25th. Now I got to look. When was the 25th? Was Sunday. So it was 5 days ago. So it was on day 19 or day 20. I think we're on day 20 at this point. Did we have a chat about that? I'm trying to remember. No, it wasn't then. I mean, that could have something to do with it. It also could just have to do with the fact that this legal team is in the middle of a trial and people have the schedules they have. It would be nice if Mr. DiSogra is working late hours down there in North Carolina and is available to take a phone call during the, non-business hours when these guys are not in court. But that's not expected or routine. So it could just come down to availability too. We don't really know. But that is a possibility too. Once they knew the amended stuff was coming in, like, all right, go ahead and deal with it, Mr. DiSogra. Amelia, you're my fave. Will the sidebar transcripts be kept under seal after the trial? Can we pay to access them like you did in the Depp trial? Thank you. This trial, my understanding, they are not going to be. This came up. I don't think she's said explicitly. I don't believe she has said explicitly. But what happened is it came up pre-trial because during the first trial she impounded the transcripts of all of the sidebar conversations. The second trial, Ms. Little raised an objection to that. She says that implicates the public trial rights, which it absolutely does, because very little of what happens at sidebar needs to be closed from the public. The things that can be closed from the public eye are extremely narrow, very confidential information, juror names, things like that, people's phone numbers and social security numbers and stuff like that. But you deal with, if that information even needs to come up in a sidebar conversation, you deal with it by redacting it in the transcript and then releasing the rest of the transcript, because we, the public, have the right to monitor what is being done in our names in our courts. We get to see it. What are the decisions being made? What are they based on? How are these people that serve us performing? How are they doing their jobs anyway? We have the right to do that. So she didn't say explicitly, yeah, I'm going to allow them this time. But she did make it really clear. Oh, well, last time there was no objection. This time I'm hearing there's an objection. Yeah. Yeah, you shouldn't have done it the first time, because it's not Melanie. It's not Melanie. Melanie Little. She's on my mind, Probably same thing for many of you guys. Mel's awesome. But no, Elizabeth Little, it's not on her to assert the public's right to attend the trial. That's not her obligation. You shouldn't be waiting for what the parties say to decide if you're going to exclude the public from something. In fact, there's pretty significant part of the case law dealing with courtroom closures that indicate you have to give a meaningful opportunity to be heard to the public. That certainly never happened with that transcript impoundment in the first trial. So anyway, she hasn't said so explicitly, but the implication is that it's different this time. There is an objection this time. If you're going to impound them, you better have a basis for it. So I don't know if that's going to be a deal with it when we get there type of scenario, or exactly how that's gonna all come down. Sometimes, so typically the final transcript, it's not, they might do like draft transcripts at the end of the day. The way that all their software and stuff works now, it lets them put out, working copies, but it might have some errors in it and stuff like that. So they still have to go through and finalize it before it would be an official transcript, like what you can use for an appeal or something like that. But they'll often produce the draft like that, just so parties have something to work with. It's very common to need a transcript to go back and confront you with something that you said yesterday during your direct examination. But those typically aren't going to be available to the public. So my guess is that none of this is going to be available to the public until after the trial is over. And then what's going to happen? Somebody is going to have to order the sidebar transcripts, and then see what happens. That's kind of my guess. Somebody's going to have to order it and see what happens. So let's get through the trial, and then we'll evaluate whether we need to be the people asking for those sidebar transcripts. AK, how common is it for trial lawyers to be so, in my opinion, dirty, slimy, and unethical as Brennan is? Have you seen this behavior and style a lot or rarely? It's not the majority. The majority of people anywhere are not assholes, but there is certainly a probably higher concentration of them in this profession than you might expect to find than in, something like postal delivery. It is a combative profession. It's part of the job. It's adversarial. So it's going to tend to attract people that are not so uncomfortable with conflict. The whole nature of what you're doing is dealing with conflict and dealing with it in sometimes high conflict situations. So you have to at least be okay with that if you're going to thrive as a trial lawyer. If you happen to enjoy that, you like creating chaos and drama and hurt feelings and excitement and outrage and reactions, conflict. Yeah. You might think to yourself, wow, being a trial lawyer is exactly the kind of thing I'm suited for. Yeah, he's really smarmy and unpleasant. I've never run into one quite as bad as him because I've had judges that would never permit that. What the attorney is allowed to do is a direct reflection on the judge and what the judge is allowing. So no, I don't think I've ever had to deal with anybody like this because it wouldn't be tolerated. But yeah, you deal with smarmy people, you deal with rude people. It's one of the reasons I found I couldn't deal with civil litigation, civil practice, because not only was it like the people were extra smarmy, it almost seemed like compared to in the criminal world. But it's over nothing, relatively speaking. I don't mean it's nothing. Everybody's civil case matters, but the cost of moving your boundary fence, the 6 inches, to make your neighbor happy is kind of a small thing versus, are you going to spend your life in prison or maybe be put to death by the state? No, just in terms of what might possibly justify having all of this self-righteous pomposity, civil disputes usually are not going to cut that for me. So, seeing it as prevalent as it is, it was just, I couldn't tolerate that. I couldn't tolerate that. Bunch of fucking ankle biters over this bullshit. Are you kidding me? You kidding me? You're going to take that attitude over this bullshit? No. A lot of that attitude. Don't think I've ever seen it this bad. Certainly not in court, not in my presence. In depositions, maybe, where they can get away with it in their correspondence, the phone calls. Yeah, maybe. A lot of real assholes in this profession, guys. Summertime. Has anyone asked the witness what alerts the driver would receive if close to hitting a human? What would Karen have heard, felt, etc.? Nobody has asked yet. I don't know at this point that Matthew DiSogra was the defense expert that would be expected to answer anything like that. Seems he is very, very narrow in the scope of what he did, just responding to Aperture, nothing else. So no independent review analysis of any kind. So if that's coming, it's coming from somebody who did independent analysis and review. Who might that be? Maybe Richard Green, maybe ARCA. They have another expert whose name I can't remember right now. Don't they have another digital expert? I'm going to pull up the defense witness list real quick and see if I can remember. We got this Derek Ellington. I'm not sure who that is. And then the Matthew Erickson. I don't remember off the top of my head now if we know who either of those are, and if either of those are also vehicle data kinds of people. So I think this is it's a good question, and it's an understandable one that I think people would want to know. I would hope that somebody would come through and give us just a overview of what the safety system consists of, what are some of the main features, and what just highlight what it has that is potentially relevant in this case. And so if it has backup alarms or a backup camera or things like that, let us know how it operates. Let us know what to expect. And then if we didn't get something, would we expect something? Should we expect something? Does it depend on settings? Do we know what settings are? Like this does seem like some fairly fundamental stuff to cover. So I do hope they get to it in a little bit of an overview like that. But we'll have to see. Didn't get it from Mr. DiSogra. Z, didn't Burgess say he found nothing useful on the chip? Yeah, he did. That was in his testimony. Nothing useful on the chip. So I don't know how to reconcile this, if it's nothing useful or if it is the timestamps from the infotainment system. I thought they already had the infotainment, everything from the infotainment, but I don't know. Gray space, angular momentum. I hardly know them. I was thinking about that the other day, like with Judd Welcher's testimony. Oh no, as soon as you have a side swipe, it's just far too complicated. You can't do anything like that. Really? Because like I'm not even the best pool player, but I can deal with angular momentum. I understand pretty well how that works. It's not that complicated. Yeah, okay. It's a little bit of trigonometry, I guess, but you're dealing with harder stuff than that in your GPS analysis. Angular momentum apparently is an insolvable problem for Aperture. T. Shaw, we do work that our clients ask us to do. So if we're asked to do it, we do it. If our clients say, hey, don't do that, we don't do it. Poor man, Shan. I didn't even think about this at the time as that being the counterpoint to, I just volunteered this new report. I just decided I should do that on my own accord. Which of course nobody buys anyway, because your letter gave it away that it was pursuant to Mr. Brennan's request, but also because nobody does this. Nobody just volunteers a report. Nobody's like, oh, hey, you didn't ask me for this, and I have no idea if you're going to pay me for it or not, but let me do this additional work just in case. It doesn't happen. I didn't think about that being a contrast, but I wonder if anybody in the jury took it that way. TCP, in your opinion, was the defense too lenient on their opposition to questionable material? Or is it more in the we don't know how much they objected side of things? Well, I mean, what do you mean by questionable material? It's part of the challenge that we have in this case. Number one, yes, much is happening outside of our view. It's happening at sidebar. The objections are being raised at sidebar. They're being fleshed out at sidebar. All we see at best is that something happens in the middle of a witness that requires them to go to sidebar. And we may or may not be able to kind of guess from the context what their conversation is all about. So we have no idea for a lot of these types of issues what kind of objections have been lodged, what kinds of arguments were raised in support of them, what kind of ruling was made as the result. So it's I don't want to I guess I don't want to, judge the defense on what they are or are not objecting to if it's, possibly dealt with in an arena that we wouldn't know. Now I can see with my own eyes in the courtroom when we're questioning witnesses and there's a question that's being asked and I'm like, hey, that's objectionable, and they don't object. We can see that. Is it critical most of the time? Probably not. These are just those sort of style differences where I would probably be more inclined with somebody like Brennan to go ahead and give him back some of his own medicine. You're going to do improper stuff, I'm going to object. I'm not going to do you the courtesy of not objecting during your questioning and letting you slide. I'm going to have a boundary and I'm going to enforce it. And the judge may not agree with me. I don't really care. I'm still going to make my record that what you're doing is improper. So a lot of that stuff, is just kind of style stuff, really more than anything. But as far as like substantive things that are coming in and how the defense is objected or not, there's just too many unknowns, way too many unknowns. So much is happening outside of our field of vision, if you will. Rusty, can they bring out that blue arm man was holding a glass and not a phone that locked? Yeah, good point. Good point. Where was John's phone in all this? Is John left-handed now? Is John like the only person on the planet who's now using his phone with his non-dominant hand? I would have to think about, I would have to think through mechanically, how do I lock my phone with my left hand and be searching for it? No, it's just a button on the side, but it's my left hand, guys. Like, what do you want from me? What do you want from me? It's my left hand. Every once in a while, it's really good. It's really good to try to shift your perspective, teach your brain a little bit of new things. And guys, switching to your non-dominant hand, it's like a different world. I do it in boxing sometimes, of course. I try to. It mainly just because you get very imbalanced. It's a very imbalanced, sport. You always got the same lead hand, same rear hand. You rotate the same ways and stuff like that. Tend to get hit in a lot of the same ways and stuff. So it's good to shift it just so that you don't, you don't get imbalance in your strength and tightness or anything like that. But where it really, really jumped out at me, like what a difference just shifting your hand makes with your brain activity. So when I was in law school, very first year, second semester, I got hit on my bicycle. I was saying the other day, only time I might have broken a bone, never got confirmed. I didn't bother to x-ray my finger. Might have broken a finger. But anyway, it's because I was in a bike accident and somebody opened their car door into my bike, launched me 5 lanes of traffic, thunk, thunk, thunk. It was a whole thing. So it didn't break, I mean, as far as I know, but what happened is I was wearing a ring and the ring, stabbed me, broke and stabbed me. So I had to come pull it out with pliers. It was pretty gross. And then my whole arm swelled. And I think what happened is my forearm bent. It didn't break. But I think it bent. I don't know. I just had a lot of irritation. So they had me in a soft cast type of thing that I was supposed to wear for a couple weeks. Well, this is right in the last couple weeks leading up to midterms. And so in a 2-week period, I had to learn how to take all of my notes with my left hand. Cause this is guys, this is like the dark ages. Okay. This is still before there were people that had their computers, their laptops that they would be able to do, take their notes and stuff on, but you weren't doing your testing on laptops yet. We were still doing it in the old school blue book that you have to write in. And I did not laptop my notes. I did everything. I did everything written by hand. So I had to learn how to take my notes with my right hand and then write my midterm exams with my left hand. I had to learn how to do that. And the thing that really stood out about it was I took different notes. I could look at the notes that I took when I was taking notes with my left hand. And it's literally different things would kind of catch my attention. I would say things differently. I would like structure. I tend to be an outliner, with how I think. I like to kind of break things down logically. Oh, this leads to that. And then, and then we, move back to something else. And I would see those pathways differently. When I used my left hand, it was really, really eye-opening, strange experience. Never written extensively with my left hand since, but anyway. Yeah, they could bring this out. What exactly is he holding in his hand? Anyway. Maggie Bev doesn't agree with the totality of the law. No, it doesn't seem like she does. She does like to go in and seems like she might like to cherry pick a little bit. I mean, that's the whole problem. The case law. The case law is what it is, but if you've got to go through and hunt through, rules of interpretation, setting out the legislative intent for rules of construction and so forth, and you've got to try to turn that into a substantive limit on what the rules of evidence allow you to do or not do, you are not interested in the totality of the law. Ellie Dimitrova, love your analysis, Andrea. Question, does Bev need to provide written rationale for all one-word rulings she's done recently? Missing it seems so improper. No, she doesn't. She doesn't have to provide any written rationale for her rulings at all. Now, again, specific to Massachusetts, there might be a rule that requires, certain decisions to be placed in writing. Here in Washington, we have, for example, different rules for like a ruling on a motion to suppress, for example, because there have to be specific findings that are made. We have to identify if there are conflicting facts, for example, and identify those. We have to identify what's in dispute, basically, and what's not in dispute. The judge has to resolve those and make findings of fact and set forth the basis for the findings, and then reach certain conclusions. And all of this has to be in writing. So we've got a very specific rule that says with a motion and suppress, you have to do this and it has to be in writing. Absent something like that, saying you have to put this down in writing, you don't have to put it down in writing. You don't have to put it down in writing. And in fact, you may not want to put it down in writing for the same reason you might not want to have objections, the basis for objections being stated specifically, because it pins you down. If somebody just objects and says foundation and you sustain it, and there is an adequate foundation on review, you're going to get reversed. But if somebody just says object and you have no idea what the basis is, it could be anything, then you're going to have to rule out every potential reason why that question would be objectionable to evaluate her ruling. So it just gives her a lot more saving grace to not be pinned down on what the basis is. As soon as you put your justifications, your rationale in writing, they can critique it. And they can decide that your rationale, maybe doesn't add up. But if you don't put it in writing and you just deny it, then if there's any rationale that would support it, it's probably going to be good enough. So it's really, this is just another one of these sort of ironic features of the system that in many ways, less is more, less explanation is better for a judge in terms of do you want to be affirmed or do you want to give them reasons why they might be able to reverse you? Now, if you are trying to do an honest job with integrity, then that accountability wouldn't bother you. And you would, of course, identify what your decision is and you'd lay out your rationale, your justification, you'd put it in writing, because part of the whole reason of having a rule of law is so that everybody is on the same page. We're all following the same rule book. It's predictable. And, I'm giving you what you need to be able to evaluate, is my decision appealable or not? And if I'm wrong, the Court of Appeals will correct me and I'll take the hit for it. That's what having honesty and integrity in the judicial position would look like. But if you just care about winning and not getting reversed and getting this done, might not put so much in writing. D. London 1144. Do you think Hank has any idea that by trying to impeach DiSogra's analysis, he's impeaching his own witness? I think he's got a hint, but he's just trying to blame shift. You know, he's thinking he can get away with the blame shifting. And that's really what this is about. I thought that DiSogra handled that extremely well, and Mr. Jackson also handled that extremely well. Come back on your redirect and just remind everybody: garbage in, garbage out. And where did your garbage come from exactly? Oh, that's right, from them. So it all seems fairly clear and intuitive, at least to me. But I think Hank thinks that, you know, he can shift the blame if he just, you know, asks it the right way or with just the right amount of smarminess or something like that. Okay, guys, I'm going to pause for like 3 minutes just so I can go refill my tea. Just want to, you know, be not completely dry while we wrap up this afternoon. So I will be back in just a moment. Thank you for hanging tight. Okay, guys, thank you for hanging tight. What on earth was that we were listening to? I don't know what y'all thought of that music, but it was a little much for me. Sorry about that. Not on purpose. All right, guys, what else is going on? Factual lie, no laptop, no watch. Thank you for all you do. He walked up to the stand, but nothing but a very thin binder that he didn't look at a single time. Wasn't that refreshing? He did not have to scramble through everything. He didn't start to look away from you while you're answering your questions, while he's typing away in the computer, not even listening to what you're asking, because he doesn't care, because he's going to say whatever he wants anyway. Nice counterpoint. Serious problema. Why are we spending so much time on the phone sync when this is Commonwealth information that he reviewed? I mean, they need to undermine the Commonwealth's case, right? So they need to delegitimize the arguments that the Commonwealth is making. That's the basic defense function. So, I mean, that's why the phone sync. I mean, if we're trying to battle over who has the facts and science and data on their side, the phone sync is it goes to just the question of, is an accident even really possible with the data that we have? Is it even really possible as consistent with the data that we have? Because if, this data means there was a collision, and then after that, John shuts off his phone and takes some steps, that seems pretty infeasible given the nature of the injuries. But if, he did those things and then got hit, that makes a little bit more sense. Commonwealth, of course, is trying to widen their own window by using this equivocation between the event, meaning whatever nebulous idea they have in their mind about a collision that took place, and the event, the trigger event. The trigger event then also just becomes the data, the 10-second period where the data is recorded. And so the Commonwealth has kind of, given itself this room to expand the collision event beyond anything that's in the data, right? They're like, this is just the time the data is recording. It's not what triggered it. Could have been before, it could have been after. Logically, seems like if it's not in this time period, it would have to be after, doesn't it? Because it's hard to believe she hit him and then she slowed and then, accelerated in reverse. That seems unlikely if we're trying to associate it with this particular trigger event. It's not during the part when she was going forward. It's after she went into reverse. So it would be sometime after this trigger event stops recording. They want to keep that door open for themselves. But like, dude, how long and how far do you think she was reversing? You're going to need to add like another 4 seconds on to get to John no longer walking. So now she's accelerating in reverse for like 10 seconds. How far do you think she's going? And just the longer it goes on, the less likely, doesn't it seem like it happened? Because we can all picture, okay, you reverse real fast. Like everybody has probably stepped on the gas by accident and your car, it jumps forward. If you're in reverse, it just jumps back. You didn't mean to. I was doing this in Chile because the first car that we rented was an automatic, and I haven't driven an automatic in so long that I just didn't have the habits. And so there were a couple times when I went to like hit the clutch and slam on the brake, or I just hit the gas to like, because I'm not used to driving this car. And I learned real fast, guys, but I did have a moment or two where things got a little awkward because of that. Everybody can imagine you slip, you step on the pedal or whatever, you reverse, but it would be really fast. It would happen really fast. If something's behind you, you would have that type of collision. A like controlled, steered in reverse high speed maneuver, like the longer it is, the less feasible it seems that is. You know, unless you're like the field driver, the you know, the can't remember what they call them. There's the law enforcement, they learn like the special driving tactics and stuff like that. I forget what they call it now. It's gone. It's Friday afternoon. But anyway, like, you know, maybe you have some technical driving kind of experience like that. Maybe you could pull it off. But I just don't know about like another 4 seconds on the end of all this that culminates in her hitting John O'Keefe. And you also want me to think that's intentional. It's very hard to believe. Where did she go to driving school? Very hard to believe. Michael Muddragon, Hank's whole reasoning is that when Aperture is wrong, it only reflects badly on DiSogra. That's what I'm getting from this. Yeah, he's blame shifting. That's all it was. You didn't correct any of this. Well, no, that's not his job. And, you know, if he was more of an experienced witness, maybe he would push back on that a little bit. Maybe he wouldn't, because maybe it doesn't really matter to him, you know, one way or the other. But, you know, no, I didn't do testing. I wasn't hired to do testing. That's not within the scope of what I did. My job was to evaluate what was given to me. If there were problems with what was given to me, you know, you learn how to turn it around and throw it back. If there were problems with what was given to me, I just took it at face value. If I shouldn't have done that, I guess I won't do that again. No, we're not going to be snotty like Mr. Welcher. I took it at face value because your experts had gone and evaluated the data, and I was just working with their process. So, yeah, trying to blame shift. TCP, if Aperture misrepresented the data, your analysis would be wrong. Correct. That would be leading, so he wouldn't be able to do that. But he could say something like, if Aperture made fundamental errors in their collection and interpretation of the data, how would that affect your analysis? Mr. DiSogra, I'd like you to consider this hypothetical. You could probably do something like that. Nicole Kelly, why do I feel like he's trying to run the clock? He was trying to run the clock. He you know, he wanted to end on his cross-exam today. He didn't want there to be you know, a window for a new witness to come in and just on direct, and then we break before cross-exam, you know, not like that special treatment Jen McCabe got, right? A big break in the middle of that examination. The jury's got nothing to do but sit with it till they come back for the weekend. He doesn't want that happening to him. So I think that's what he was trying to do. Odin's Martyr, not on Twitter, but I'm hoping hashtag biasbev is a thing. Pretty sure it is. I don't do the hashtag game, so I haven't really seen too many of that. But pretty sure I've seen that one around. Frankie's Mom 143. Did you see Aperture was at Massachusetts Bar Association dinner? Yeah, they were one of the sponsors. I did see that they were one of the dinner sponsors. And I don't know how else I can keep telling you guys. This is the game. This is the game. This is how it works. This is the club. This is how you get into the club. This is how they scratch your back and yours gets scratched back in return. This is the game. Nothing about this violates any of the rules of ethics. It doesn't create a conflict of interest. Now, is it maybe pretty improper for a judge to accept an award at a dinner like this that is, you know, funded by Aperture and so forth? Might give the appearance of impropriety, but is there going to be some black letter rule somewhere saying you can't do that? Absolutely not. Absolutely not. Judges are never going to tie their own hands about the kinds of rewards that they can receive. Are you kidding? No, nothing facially improper about it. That's the tell, guys. That's the giveaway. That's how you need to know this is the system. This is the system and everybody's in on it. Mickey P. So if Burgess makes a chart you are asked to analyze and he incorrectly labels iPhone data as infotainment data, it's your fault, stupid. Okay, got it. We all got that. We all got that. Hopefully the jury got that, because that did seem to be pretty clear. I mean, he couldn't have said it more clearly, maybe more times. Do you need to say things more times for Hank Brennan? More times that we should say, I just relied on their data. I did not get any data. I just relied on theirs. So if they called it infotainment data, then that's what I called it. And that's what I worked with the working assumption that that's what it was. Would that throw out my entire analysis? No, of course not. It would throw out some of the possibilities for how the clocks reconcile. It didn't come across to me as a super effective cross. You know, especially if you're going to come with that much hostility, you better have some goods, okay? Alessi was nicer than that about some solid impeachment material that he has. You know how many times witnesses would just dream of having resume inflation to be able to bash the opposing party's expert with, and they just have to take it because what are you going to do? It's like 4 different versions of your CV that you put out there in your own LinkedIn. You're going to have to answer for it. And he was pretty nice about that. He didn't get all smarmy. He didn't get all smarmy and, load up his question. Did it ever occur to you that maybe you shouldn't lie about your credentials? Yeah, he would never. He would never. My Mr. Alessi would never do that. Infoneurs, this guy is sharp, able to recall this much detail under so much stress. Example of class versus being an ass. I thought he was a very good witness, especially for being his second time. Especially for being his second time. He did look a little baffled sometimes. What universe am I in? Really? Seemed to be, the rolling ticker going through his mind, just going by his facial expressions. That could be accurate or not. Who knows? Don't want to project too much on how people present themselves on the stand, but I thought he handled it extremely well. He remained very composed. Didn't fire back, didn't get mad, didn't get pissy, didn't get argumentative. None of it. He stuck with yes, with the caveat. Even with this guy being a jerk to him, he's focused on the substance. I think that's what comes clear from it. And that's the distinction. You're being an asshole to me, but I'm going to look past that. And I'm going to look at the substance of what you're asking me. And if it's fair, I'll give it to you. That's what I saw from this guy. And he's very sharp. He's able to follow the question. He understands it. He can see how it's loaded. He can see, he understands, he's listening to what exactly is being asked. And so I found him very effective. Some guy with cancer. If you're in a hole, stop digging. Brennan keeps digging and is an asshole to people that try to help him. Well, you got to be careful about who you choose to be near, don't you? Don't you? If you're in a position where Mr. Brennan is trying to help you, consider carefully if that is an alliance or a relationship that you want. Consider that very carefully. Are you able to rely on this assistance? Do you trust this assistance? Is this assistance real or is it a sham? Is it going to come with a bill later on down the road? Is it going to be yanked away from you at some point unexpectedly after you've been lulled into not paying attention? People People who are treating people badly, you're aware of that. Be careful about whether you let those people help you. He did. He just wouldn't stop digging, but he had to keep trying. Mark Lyon, what is Judge Bev so desperate to do every night? I don't know why she's in such a rush. I've seen some commentary around, oh, they have very strict court schedule. The public employees are unionized, so they all leave at a certain time, et cetera, et cetera. That doesn't compel her. You can stay late. You can stay late and do work like all of the attorneys and everybody else is having to do. It's part of service, is doing what needs to be done, regardless of whether it's convenient to you or not. I'll just take this opportunity to kind of give my routine bash on public employee unions. Do not think that should be a thing for anybody, any public employee, certainly not police officers. Holy cow. But just in general, setting yourself up in an antagonistic oppositional position with the public that you are here to serve doesn't sit well with me. It doesn't sit well with me. You do a good job, the public will reward you. That's how the system should work. So that's my own little personal beef, that there should not be an issue with public employee unions. But apparently that does factor in here, and that's not uncommon either. It's not uncommon to have public employee unions that apply to court clerks and court reporters and that stuff. And that's why they have to take their breaks when they do. And a lot of that stuff is all, it's either in labor laws or it's specifically negotiated in the collective bargaining agreement or whatever. So I buy that has something to do with her strict court schedule. The employees have to get their breaks. They have to get their end of their day job. Like, that's just kind of built in, but it doesn't mean she has to, You can keep working. You can sit around and keep working. But as far as being in open court, I buy that as a reason why. Law and Order. Brennan is a jerk who just impeached his own experts' data and reports. Now I would move to directive verdict and to dismiss. Well, you're not going to get it on this one either. Prosecutorial hypocrisy is not a basis for dismissal of a prosecution. If it was, you'd see a lot fewer prosecutions out there in the wild. Buttercup 203. Andrea, thanks for another great week. Hank's accusations-y cross is unlikable. Go Phils. Taiwan Walker tonight. Hey guys, go Phils. JT, go JT. Versus the Brewers. Oh, that's right. That's right. Reese Hoskins is on the Brewers now. That's going to be an old showdown. They'll respect him. They will absolutely respect him. They've done that every single time. They got, we play old Phillies sometimes and they get their respect. I remember when we played Juan Soto last year, and pretty sure, if I remember right, it was Juan Soto, and he got an ovation from the crowd. Like, the Phillies respect the former Phillies. So that'll be fun. I've been all about the Ty turnaround this year. I'm so into this, guys. Taiwan Walker had like the worst year last year. It was awful. It was excruciating. Everybody hated him. I hated him. You can't send your $20 million pitcher down to Lehigh Valley, and it's what he needed. Like, it was just a disaster, absolute train wreck. And it was the worst because he was injured. So we had Spencer Turnbull as a starter in the rotation. And then Spencer Turnbull goes and has this historic period of starts and wins. And he's just hot. He's so hot. And then Taiwan's better. So they yank Spencer Turnbull out of the rotation in the middle of his hot streak and stick him in the bullpen. And they put Taiwan back in the start. And then Taiwan bombs. He's got like an ERA of like 17 or something like that. I mean, it's just a nightmare. He can't pull it together the entire season. Spencer Turnbull gets injured in the bullpen. And that's what we had. It was awful. It was awful last year. Hated Taiwan Walker so much. And so this year, feeling a lot better about Ty. He's not, throwing as much junk. His velocity's back up. He's got his splitter back. It's moving again. Seems to have his confidence back. So good stuff. Go Taiwan Walker, go Phillies. Lucy Fair, sir, you're wrong for trusting our data, right? Sir, did it ever occur to you that our data couldn't be trusted? Did it ever occur to you that you should double check anything and everything that we represent to you as fact? That might be funny. That might be funny. Hey, Bored Adam is a YouTube member. Welcome to the channel, Bored Adam. Hope you won't be too bored here, but you know, you're an Adam. I can't promise to electrify you. Beverly Alford, I need a defense witness to respond to Hank in the same manner Morgan Tremaine handled Elaine Bredehoff following her 15 minutes of fame accusation. I might say the same thing about you. There was an opening there. There was an opening there for Mr. DiSogra. He didn't take it. He's not an experienced witness, and he's very professional, so he probably wouldn't take the opportunity anyway because it is combative. But I think he had that opening. I think he had a little bit of an opening there. Mr. Brennan, are you saying I shouldn't have trusted your expert's data? Simple as that. It's improper. It'll get objected to, stricken. But it's nothing Mr. Welcher didn't do, right? Ask questions. It's not his place to ask questions, but it didn't stop him from doing it. There was room for something like that in there. The thing with Hank is if he's going to lead with that kind of attitude, he's going to get caught. He's going to get caught at some point. I don't know if it'll be in this trial. I don't know if it'll be by this witness. But yeah, if you want to scrap, you're going to find some fighters. That's inevitable. You want to throw down, you're going to find people more than happy to do that. So see how confident he is, because I got to tell you, a lot of this looks pretty sloppy to me. If Matt DiSogra could have jumped on one of those openings, a witness who is more inclined, perhaps, to be able to more inclined to get into the scrap, then that witness is gonna take that opening. And he is not so tight and technical that he's leaving big openings. Big openings. Jennifer Hill, odds of experts discussing Karen's Lexus going into outer space. Please say the odds are good. Hey, once again, another opening that was out there. Could have taken it. These guys are directly, this guy, Matt DiSogra, he's directly hired to respond to those guys. And those guys say, we can't say it's impossible that the Lexus went up into outer space. Mr. DiSogra, can you say that that's impossible? Oh, Hank would object to that because it would be beyond the scope of the expert disclosure. He didn't disclose that he would be offering an opinion on that. Would be my guess. That's an opening. Someone's going to jump on it at some point. AC75, the Lexus knows where it is at all times. It knows this because it knows where it isn't. One for the missile inertial nav geeks. If you know, you know. I don't know about missile inertial nav, but I do understand it's like a meme. Don't necessarily get it, but Alexis knows where it is at all times. It knows this because it knows where it isn't. Summertime, why would Proctor's friend need counsel? If I'm hit with a subpoena, I'm hiring a lawyer. I don't care about anything else. I don't care who's subpoenaing me. I don't care who it's for. I don't care what it's about. I don't care whether I agree with it or not. I don't care if it's my friend. I don't care if it's my enemy. I'm getting served with a subpoena. I'm getting a lawyer. So that doesn't bother me at all. He got served with a subpoena, so he got a lawyer. That's my answer to that. It doesn't trouble me at all. You want to know what your obligations are and so forth. Have some assistance navigating it. Sandra, AB, isn't rebuttal limited to only any new information provided by ARCA? Why the fuck would the Commonwealth be able to rebut everything? So with the experts, the rebuttal is supposed to be limited to the new stuff from ARCA. And that's because Massachusetts, they don't allow expert sur rebuttal. And so what's supposed to happen, I'm the prosecution, I go first, my experts disclose all of their stuff to the defense first, and then the defense has some time with it, and the defense has to disclose their stuff back, and then I get the defense stuff. And if we still have some time, maybe I can respond to their responses and produce that. And then when I call my witness to the stand to testify, they're going to testify to their direct. And then if they're going to anticipate the criticisms from the defense, they're going to testify about that too, but it's going to be on direct. And then you're going to have the defense, and the defense is going to give their position and their criticisms and so forth. So that's like how I think in theory it's supposed to work. And that's why they don't get a sur rebuttal. You don't get to come back after the fact and respond to the criticism. You both, exchange your own, and then your response to them, you're kind of presumed to deal with that in your direct. So it's just different in this case because of the timing of everything. They can't or weren't able to or didn't want to have to respond to ARCA before they did their direct. They wanted more time. Bev said, sure, you can have more time and we'll decide exactly what you'll be able to talk about with respect to ARCA's new stuff after ARCA testifies. So we don't even have any idea still at this point what the exact parameters of what Aperture is going to be allowed to do or not do are. We have no idea what those parameters are. She's left them completely open. She's given us no guidance on what the standard is because she's making it up. There isn't one. She's just making something up. And so whatever hits her fancy at the time, she'll say, Aperture can rebut on that. So basically, since she's inventing an exception to the norm, she doesn't have to follow any particular structure for how to do that. She's making it up on the fly, so she'll continue to do that. Summertime, do you think the Karen Read clips helped hurt neutral the Commonwealth? I mean, I think different ones in different respects. Some of them I think have the potential to be more damaging than others. The Karen, I'm being tipsy. Maybe I was driving a little bit more. I mean, not unsafe, but like relative to if I hadn't been drinking, those kinds of things were not helpful. Her own drink count, that was not helpful. Is it super damaging? No. If she was just charged with drunk driving, it would be very damaging. But there is, of course, a lot more to it than that. I think a lot of these clips that they've used I would say, I guess, probably most of the clips I read as largely neutral because they either don't say anything that we don't already know, they just kind of confirm what we already know, or they just don't really necessarily tell us anything at all. The one with like the Peggy O'Keefe came over the counter. It looked like he was hit by a car. That one, to me, I didn't take that. I didn't take that as a negative. I think there are many ways you could see that as being helpful to the defense. Oh, so you mean there is some bias? There is some bias against Karen, and the victims share it. That explains a lot. It explains a lot about what we see and the motivations and the faces and all of that type of thing. That explains a lot. That might actually help the defense. But he, clearly thought it was going to be justified because, it makes Karen look like like she's mean or something like that. But a lot of these things, like the clip, Jen said it was near Ashley's house and she and John had dated. These are neutral at best. These are neutral at best. Nobody is caring about the Bella's mom issue in this trial. Nobody cares about Bella's mom. Nobody's buying Bella's mom has something to do with like motive or anything like that. They're brainstorming. Probably one of the worst ones was the one about, he looked like a buffalo on the prairie. He was like a heap. He was a weird shaped lump in the snow. And she was looking because she was expecting to find him. And she was feeling the fear and anticipation of what she was going to see that was extreme as the grief. That particular one, I think, is probably the most damaging because it's the one that gets the closest to sounding like it is an actual admission. It sounds like she's saying, I don't read it that way. I think she's just saying, I expected the worst. I was afraid of what I was going to see. So I'm worried about it. That's what she's trying to articulate, is that she's creating all of these fears and worries and stuff in her mind that are not real, because that's how worry is. Worry is not real. Worry is a thing you've created in your mind that is not actually right here, right now. It might be right here, right now at some point, but it's not right here, right now at this point. And that's part of what makes it anxiety. So I kind of understood. I think I had, my interpretation of it, but if you wanted to look at it in a bad way, it could sound like she's saying, I knew I was going to find him there outside of 34 Fairview. It's not a helpful thing to say. So summertime, I think it's a real mixed bag. It's a real mixed bag. If you're going to have me like average all of them total, I'm going to say neutral. Just because I don't think there were that many that were particularly damaging. And there were like a couple that, I could see how that could be potentially a little bit helpful to the defense. But by and large, I don't think they move the needle. What do you guys think? How do you guys think these have landed? What sort of effect do you think the clips are having? Is this significant to the jury? I think it's moving the needle at all for them in terms of like whether Karen should testify or not. I can see that one both ways too. I can see on the one hand people thinking, oh, she better testify to explain these things, but I can also see people thinking, hey, otherwise I might expect her to testify, but she did all these interviews and she told her story there and the prosecutor told us, so now she doesn't have to. I mean, I can see that as being kind of neutral too. So I don't see this as a particular win for the Commonwealth, but just piece by piece, there's some that are better than others. TCP, how is it different to have Proctor's friend read the text messages versus Buchanan reading them in? So Buchanan read them in because they were already in evidence because Nick Guarino extracted them and he authenticated the extraction and offered it and there was no objection to it. That's the simple technical answer to your question. That's why he read them. They were already in evidence. Why were they already in evidence? Because Nicholas Guarino authenticated them and they got in that way. So the issue here is that initial foundation of getting it into evidence. That's what the issue is. That's what they're trying to grapple with. Miss Shorty, couldn't get through this trial without your insights, wisdom, and humor. Andrea, thank you. Well, thank you for that. It's a very nice thing to say. Trials are not easy. I've said this many times. Trials are not easy. And we're kind of taking on, let's not go crazy. We're obviously not anywhere near the position that the parties are in. But we are, spending a lot of time on it. We're having to focus on it the way they are. We're having to kind of think about things as they unfold the way that they are. So we are at least in a similar kind of vibe, as both of the teams, the defense and the prosecution. They're having to kind of live and breathe this case a lot right now. And so we're getting some of that sense too. It's not easy to get through trial. It's an endurance sport. There's a lot of emotion. There's a lot of difficult stuff to have to deal with. By the time you have a criminal trial in the first place, you already have a wrong that's never going to be made right. You already have something that, if you could wave a magic wand and make it not happen, you would. Everybody would wave a magic wand and be like, John O'Keefe didn't die. You would just take it away if you could, right? Nobody wants, nobody wants John O'Keefe to die. So I'm just trying to, kind of help keep us through it, help motivate us, stay interested, make sure we understand, make sure that we're taking care of ourselves. We're looking out for our own mindsets. It's a very, very important thing. If you're gonna, follow trials, put in that time, give it that attention and in that focus. Maybe is just one of the things I had to learn from experience, how to kind of self-moderate a little bit. Because you can get real pissed off. You can get so frustrated. Oh my God, the injustice of it. It can eat you up. It can absolutely eat you up if you let it. Joe Flipperhead. Brennan had Yuri read Proctor's text with the other troopers this trial. Now he's objecting to a friend of Proctor doing the same. How does that make sense? Also, whose jersey you wearing? Hey, I showed you. It's a JT jersey. Jeff got me this. It's JT only because they weren't making Kirkering jerseys when he got this for me last year. I would my preference, everything else being equal, I would get myself a Kirkering jersey. I'm still in on my future Hall of Fame pitcher there. Okay. I see it. It's gonna happen. He's already doing better this year with the, little bit higher leverage situations and stuff like that. But he's still young. He's still young. But yeah, this is the same answer to the other question. It's because they got Yuri's, or they got oh wait, Brennan had Yuri read Proctor's text with the other troopers this trial. Did he? No, he read the Brian Higgins text. That's what we were talking about, right? He read the Brian Higgins text. He had Yuri, but that was Alan Jackson. Have I forgotten something? Have I forgotten something about Yuri's testimony? Oh, let me go through my notes now and find it. Let me remind myself what day Yuri started. He started on day 12. So let's go back to day 12. Start thumbing through. I mean, the text. So, I know what it is. He read the text that he was a part of. Yuri read the text that he was a part of. The text chain that included him and Tully and I forget who else was on it. I don't think Connor Keefe wasn't on it. He was too rookie. Proctor and those other guys. And so yeah, he read those into evidence. So, I mean, you're making a good point about kind of the hypocrisy side of it. Yes, he's doing it when it works for him, and then he's objecting when the other side tries to do it. But again, the kind of simple answer to this is, well, the defendant didn't object when they're eliciting those bad texts on direct examination with Buchanan, because they're going to bring them in anyway. So they're not going to object to it. It was the rare occasion when Brennan decided to bring out, the sting, not let the witness be slapped with that for the first time on cross-examination. So it was one of the few times that he actually tried to do that and give his witnesses a break. So the defense didn't object to that because it was going to come in anyway. I think that's the simplest answer that I can give you. If he had to go through and like authenticate everything and overcome an objection and make a different argument, it would be even more overt how hypocritical he's being. But it's just not. It's not quite apples to apples situation as I see it. I'd change my name to Cora too. Refreshing DS didn't put down the Commonwealth witnesses. Yeah, I mean, there's no need. There's no need to put anybody down. That's not what the job is. Even Matt DiSogra, like, you know, who I think you're talking about here with DS, Matt DiSogra, he was invited. He was practically begged, say something nasty about Shanon Burgess. And he wouldn't do it. Very proficient, isn't he? All he said, he successfully acquired the data. I mean, that is the most diplomatic response to the guy is an absolute dumbass, but he happened to stumble on the right answer. The broken clock. Shanon Burgess is the broken clock of this trial. It was like the nicest way to say the man is a broken clock. But he didn't actually have to come out and say it, and it was nice. My Mini 67, the Occiput Boner, Subaru 4-wheel drive boxer engine equals Toyota. Aha, but I don't have 4-wheel drive. You don't have 4-wheel drive in the BRZ. It's like pretty sure it's the only Subaru that they make that doesn't come with the all-wheel drive. It does have the boxer engine. Yeah, it comes from Toyota. Trying to remember right, like how I can't remember now off the top of my head. Like the engine design came from Toyota, but the engineering of the rest of the car is Subaru. I forget the exact details, but I accept that there is some Toyota. There is some Toyota in my Subaru, but it is still a Subaru. There are still uniquely Subaru things about it. Carolyn Smith, my dad was a renowned defense attorney in his part of the South. RIP. Once he had an older lady on the jury say amen during his closing. He'd never be hired again if he flipped to prosecutor. How does this impact Brennan? I don't know. I think there's different perspectives that different people are going to have on it. On the one hand, as far as the legal community, the defense bar will almost certainly regard him as a turncoat. So there will be some exceptions, individuals, they won't like necessarily, snub him in public if they run into him at a bar or something like that. But there's quite a few that would. But just in general, the defense bar is going to look at him as a turncoat. And so that means they're not going to refer to him. They're not going to talk him up. If they, are in a context where there are war stories being traded and stuff like that, they're going to tell their bad stories about Hank Brennan. He's an enemy now. So he doesn't get protection. He doesn't get his back watched by the defense side. That doesn't necessarily affect what clients are going to want. I mean, there's some overlap. It's probably different in a very, very super urban environment like Boston, Boston, Massachusetts, and kind of the surrounding area. It's just so many people that I doubt everyone is real reliant on word of mouth to hire a lawyer. You have so many options. Don't really know how the referral network is going to work in a place like Boston. Looking at the mob clients, for example, I could see a situation where the mob would be thrilled to have their guy be a prosecutor. They would love that. They would love for him to stay a prosecutor and be their prosecutor, right? Wouldn't that be appropriate? But even if he can't stay a prosecutor, maybe there's an expectation that he made connections as a prosecutor that will pay off, that he's owed favors by his work as a prosecutor that will pay off. So I could see a scenario where like to, mob clients or something, this might look like a good thing. Might look like a good thing that he's done that. And then he's going to come back and take care of you. by and large, a random, Joe Schmo who gets arrested on a Friday night and needs a lawyer or whatever is not going to care about any of this. He's probably not even going to know that Hank was a prosecutor. He's not going to, research it likely real thoroughly before choosing who you hire. The reality is that most criminal defense clients, the overwhelming majority, are public defense anyway. Okay. So, if he's not a public defender and he's competing in the pool of lawyers who take on, private paying clients, there's not that many private paying clients. And so there's more competition for them. Not being part of that referral network of the defense bar, that could be an issue. That could be an issue because, I get a call. I get a call from somebody. Hey, I want you to represent me on this, and be like, look, I can't handle this right now. I got too many other cases that I'm in the middle of, but give this person a call. Everybody has a referral. He's out of that network. So that's probably the biggest effect that it's really going to have. How much that slows down his actual client acquisition remains to be seen. I love that story about your dad. That is hilarious. My God, that my heart would sing. Somebody said amen during my closing. I have two like strong memories of juror reactions during a closing. And one of them was this juror who was just on the edge of her seat, and her eyes are big, and everything I say, she's just sitting there nodding. And it was the most validating thing I think I've ever felt. Like, this juror just believed everything I said. Then I remember this other juror. I remember this other juror. I was in the closing, and it was just an area where I outline my closing. I don't write a script or anything like that. I outline the closing and then I speak off the cuff. And it's just to give me structure of, these are the topics I need to cover. Here's the basic evidence, the things I need to refer to. It's like a checklist. Make sure you've mentioned all this stuff, but how you actually get to it just depends, because we're on the fly. And I remember I'm at this part in my closing where I'm just trying to, had to pause for a second to think about how am I going to articulate this particular point. And so I pause mid-sentence, and this juror is watching me, and I see her do this. Well, and it was the most hostile thing. Didn't matter what I was going to say. She was going to hate it no matter what. So, you get mixed feedback from the jury sometimes, but boy, amen. That's a good one. That's what keeps you coming back. That's what gets you hooked on the trial work. Rudy Dub, Lowell Andrea, I am a recovering criminal defense barrister, UK 25 years, now working for UK Postal Service. Oh, defo more assholes in the criminal bar, specifically prosecution. By and large, my experience, way more assholes in prosecution than in defense. It just kind of goes with the turf. You have people that are judgy and like accusing people and calling them, murderers and stuff like that. And you have people that don't like that. Which one sounds nicer? It's really kind of basic in that sense. Just so much of it lines up with your personal, your personality, some kind of core features of your personality and how you interact with others. And I've said so many times I could never be a prosecutor, and it's not because it isn't an important job to do. It is an important job to do. I think the thing that gets lost a lot of time when we focus on high profile cases and cases where there's a lot of injustice and people aren't getting a fair trial, and very, good chance maybe we have the wrong person, or that there's no crime here that should be prosecuted. We lose sight of that massive volume of criminal justice that goes through the court every single day. And how many of those cases involve people being pretty badly victimized? Like, you can't overlook that. People are wrongly accused. It definitely happens, but a lot of people did some really bad shit, and that's why we need the system. So it's very easy to forget that, and it's an important role that the prosecutor has to vindicate that. Establish, that person who was victimized, that shouldn't have happened. They do have rights. It is wrong what was done to them. It's a very important role. But it's just not my personality to j'accuse. That's not me. It's not a good role. Not a good role for me to take on. So other people are going to find that role really, really consistent with what they already want to do. I love judging people. I can't wait to accuse people of doing horrible things on marginal proof. There are people out there that would like that, and they're going to tend to congregate more in the prosecutor's office than in the defense office. Obviously, there are defense assholes. I would say they're just a different flavor. They're a little more of I would say when I've run across a defense attorney asshole, it's usually it's almost always a lone wolf. For one thing, it's not somebody that's like in an office. It's somebody that's been a solo practitioner for 20, 30 years. They have their own way of doing things, and they just have a kind of fuck it attitude towards everybody else and people in the process. Often just very jaded. Easy to happen in that profession. But it's just kind of a little bit of the mirror image of the prosecutor. They really want to win. They don't care what you think about their tactics. So they're willing to go and stir up shit to make that happen. How successful is it? Probably varies with the individual, and it also probably varies with how good are you at concealing what an asshole you are. I would just say in general, assholes probably don't win as many cases, but maybe that's just me wishful thinking. Feral AF, DiSogra was there to disprove methodology only. Yeah, he was very limited. He was just there to point out that if you actually take what they tried to do at face value and don't cherry pick it, here's the conclusion that it leads to. And the conclusion it leads to, given all of these pieces that they identified, but never bothered to put together. Oh, okay, I put them together, and guess what? That lock event, every single time it occurs after the end of the trigger. Z, DiSogra's 2 testimonies superior to Welcher's 600. Welcher has learned some different tricks in his time. That is for sure. But there's a just very observable difference in the attitudes that they brought to it, isn't it? You can just tell. You can tell DiSogra is there. He's trying to be helpful, trying to give the information. When he wants to explain something, it's because the explanation helps, and not just because it contains a lot of technical words that lets us get lost or makes us think, wow, this guy must be really smart, so I guess I'll just side with him. It was the especially on cross. He's still trying to be cooperative and helpful on cross. Very, very different than what we saw for Welcher. Mickey P. Andrea, do judges always rule in favor of the prosecution on 95% of motions like we are seeing here? It's so egregious. Is the system always this rigged? Not uncommon. Not uncommon. There are judges that will routinely, it's like you're talking to a wall. They're never going to rule in favor of the defense. It's kind of a rarity as a defense lawyer when you find a judge that will entertain defense arguments and maybe even occasionally grant a defense motion. You cling to that judge like a rare and precious treasure, because it is. It is a rare and precious thing to have a judge that will entertain a defense motion fairly. And if it's called for, they'll grant it. I think it's far more common for judges to either just intuitively, their natural instinct is we're going to side with the prosecution. We just have a pro-prosecution bias. We believe that the police are good and the prosecutor is good, and the decisions that they make are well-intentioned. And so therefore, if they arrested somebody, it's probably valid and they're being honest about it and so forth. So some judges will walk in with that kind of mindset, just already hardwired almost. And then probably, like I said, the time we spend focusing on these kind of miscarriage of justice, high profile types of cases, they really do hide how much like legit crime and harm and devastation there is in the criminal justice system. And so judges see that. Judges see the volume that goes through, and they see, case after case of, the guy, this guy is back, and he, I just saw him a month ago for robbing Walmart, and now he's here carjacking somebody. And so they come in with that mindset already of just leans them in favor of the prosecution. The prosecution is probably right. We're going to err on the side of giving the prosecution what they want. But then you also have a little bit of institutional favoring of the prosecution as well. Politically, it tends to serve your interest to be aligned with prosecutors and law enforcement, because they're the ones who can give you an endorsement if you want to, say, get appointed to a higher court or something like that. Defense lawyer in front of you, nobody gives a shit if they think you'd be a good judge on the Court of Appeals or not. But the law enforcement union, yeah, they would. That would make a difference. So there's some of that institutional stuff. Seeing you in the court every day, I might not see this defense attorney ever again, but this prosecutor I'm going to see, maybe once a week, maybe a couple times a week, maybe every day. It depends on your court. So yeah, guys, I mean, there are judges that would probably gone through their entire career and never granted a defense motion. Oh, and I forgot, part of the idea too is maybe not so much the case where judges are appointed, although there's still going to be these types of political considerations. But like over here in Washington, where we elect judges don't get elected for being soft on crime. No judge has ever been like, run a campaign off of, I am going to, well, maybe not where I am. I am going to, let more people out on pretrial release. I'm going to apply the rules the way that the rules were intended to be applied, which is presumed that you are innocent until proven guilty, and therefore there has to be a good reason to deprive you of your liberty before you are judged by a jury. I am going to, err on the lenient side of sentencing when I see that there, in my judgment, I think there's potential for rehabilitation here, or that I think it's the law is too strict. So I'll exercise my discretion in favor of, more freedom. Judges don't get elected on that stuff. Judges lose their seats on that kind of stuff. Oh, you let this guy out on bail and then he committed a new crime. You're out. So it's just by default so much easier. I'm just going to give the state everything that they want. And if I'm wrong, the Court of Appeals can take the heat about it. I did what I need to do to make the voters happy. I showed myself to be tough on crime. Big piece of it. So yeah, I would bet there are judges that have gone their entire career and never granted a defense motion. Now, I'm being a little not in the course of a trial objection sustained, not that. But substantive motions to suppress, motions to dismiss, motions, significant motions in limine. Yeah. Yeah. Just will not do it. We'll never do it. We'll get reversed repeatedly instead. Yeah. Oh, well, hey, lo and behold, what do we have here? Did we call it, guys? Or did we call it? Let me find it. There it is. Endorsement on motion for reciprocal discovery. It's allowed. In the interest of fairness, the court orders the defendant to produce this information pursuant to Rule 14.2D. 14.2D is, of course, not what was cited as the basis for the Commonwealth wanting, witness statements and so forth. So let's just go ahead and look it up. Massachusetts. 14.2, huh? Let's find it. Rule 14.2, pretrial discovery procedures. D, oh my Lord, this is really it. Rule 14.2D is what she relies on. Rule 14.D is entitled Motions for Discovery. And it says the defendant may move, and following its filing of the certificate of compliance, the prosecutor may move for discovery of other material and relevant evidence not required by Rule 14B or Rule 14. Within the time allowed by Rule 13D1. This is what she relies on. Seems to say, yeah, the prosecutor can ask for stuff, so can the defense. That isn't a mandatory disclosure under Rule 14 or Rule 14.1 for reciprocal defense. But it's qualified here, isn't it, within the time allowed by Rule 13D1. What does Rule 13D1 say? It says any discovery motions shall be filed prior to the conclusion of the pretrial hearing or thereafter for good cause shown. A discovery motion filed after the conclusion of the pretrial hearing shall be heard and considered only if A, the discovery sought could not reasonably have been requested or obtained prior to the conclusion of the pretrial hearing. B, the discovery is sought by the Commonwealth and the Commonwealth could not reasonably provide all discovery due to the defense prior to the conclusion of the pretrial hearing. Or C, other good cause exists to warrant consideration of the motion. Nothing in the ruling about why there is cause to be doing this now when it's not required in the first place. Why are we doing this now with this particular witness? Is there something special about this witness that requires us to create written statements for her that we're not required to do under the rules of discovery? Who knows? There's no justification for any of that. We knew perfectly well Bev was going to grant it, so now we know. Now we know. She was able to go back into her chambers and dig through the rules. Say it's going to be granted. It's okay to bring a motion. No consideration of that qualification, why we're doing it this late in the day, but just fairness. Fairness says you, the defense, must scramble to provide the Commonwealth stuff that they are not entitled to, that they certainly did not provide to you. Enjoy your fairness. Rudy Dubb, Hank is example of Darvo. He does do quite a bit of that, doesn't he? It's your fault. Your fault, Mr. DiSogra, not the guy who actually made the data error. It's your fault for not fixing it. Pantoufel, can you and Jeff do a live together? Hey, Jeff and I do lives together all the time. Here he is out here in the chats, sharing it. It would be a whole different thing, like doing a live with the both of us doing a live. We'd have to, yeah. Don't get your hopes up. Not going to say no, never, but it would just be something very different than what we already do. So don't think it's probably on the table, but I won't say no, never. Nikki Lewis, P friend to get texts in. Is this in case he pleads the fifth if called? I can't see downside of calling Proctor unless he can plead the fifth. Feel bad for his friend. Yeah, his friend didn't look real happy about the situation, but he also looked pretty, resigned to it and like he was going to do the right thing. What he's doing with a friend like Proctor, but, some people have a more casual relationship to friendship, I guess, than maybe I do. I think a lot of people have folks that they call friends that I would not call friends, and I would call acquaintances. I consider friends to be pretty few and far between. They're special people. They're very trusted people, and you don't just land there. You're not my friend just because we went to middle school. Even if I've known you for 30 years and we chat, we may not be friends. We're potentially just acquaintances, because it depends on the depth of the relationship. It depends on the trust involved and stuff like that. So maybe he just has a sort of superficial definition of friendship, but it does make me wonder if that reading is right. What's he doing with a friend like Proctor? So is it in case he pleads the fifth? I don't think it's in case he pleads the fifth. It's so they don't have to call Proctor. All they really want out of Proctor is the text messages. And so if they can get those in another way, they don't want to have to call him. I think that's really what it's about. Proctor can plead the fifth either way. If he gets called, he can plead the fifth, whether the defense calls him, whether the prosecution calls him. So, I mean, if he did get called and he did plead the fifth, you're not going to get the text messages in through him. If judge is going to, allow pleading the fifth to that series of questions, to that authentication. I mean, is it possible that authenticating these texts could put him in legal jeopardy? If the texts are proof of a crime, maybe. I don't know that inherently they are, but certainly there's suspicion that they are, that this guy is corrupt and that this was part of a cover-up, and this is evidence of the lengths that he would go to, for example, sprinkle some little bits of glass on the back of a bumper, make it look like that's how the cup got broken. Maybe miraculously come across some big pieces of taillight plastic in the yard several weeks later. So she'd probably allow him to take the fifth. I think she probably would. And if he did, then they can't authenticate him and they'd have to call this guy anyway. So I mean, yes, it would work as a backup plan, but I don't think that's their intention. Their intention is to avoid having to call Proctor in the first place. Giovanni Canizzaro, how do you take notes? You are great at recalling info quickly. Thank you for all you do. I scribble rapidly. I mean, I will show you how I take notes. I scribble very rapidly. My handwriting gets worse and worse and worse as the day goes on, but I can typically interpret it pretty well. You can see like what I was describing. I do all these little things where I have like the main point and then like a sub point and then like an arrow, like then it leads to this. And so it's outliney, but with as much detail as I can cram in. So that's how I take my notes. Memory, I can't take credit for. It's probably mostly genetic again, how your memory works, what you're good at remembering, what you're not good at remembering. I've just always been good at being able to remember a lot of details. It's one of the things that just made trial work. It worked, worked really well in trial because you just have so many volumes of information that you have to keep track of, and you have to be able to locate it and find it. So then you got to remember not just what do I need, but where is it? Where is it in location, in reference to other things that I, might need to flip through? When you need to cross-examine a witness on the stand and there's a fact and it's somewhere in your, banker's boxes worth of documents, you got to be able to find it like that. So I think it's just a combination of, I've always been good at remembering details, but then I've also had a lot of practice having to be able to, sift out what matters and what doesn't, and be able to locate it and being able to relate it to other things. So I can't really take a lot of credit for that, but I appreciate the kind words. CG, if Bev denies the admission of the Proctor text, then is there any such thing as an emergency appeal to a higher court in order to reverse her? Only theoretically. For all practical purposes, there's not. Yes, if you go and look at the rules for Massachusetts for appeals, there is such a thing as an interlocutory appeal, as a discretionary process where you would go and you would petition to the court to take a look at it on an emergency basis, because there would be, irreparable harm if they don't deal with this right now. It's never granted for evidentiary issues. The court considers your remedy to be to get through trial and then worry about it. If you get convicted, okay, then you can worry about it because you can have your appeal now. If you don't get convicted, then we didn't need to spend our time on it anyway. So as a practical matter, no, there's not any such thing. Theoretically, yes, it's on the books. It's not impossible, but you're not going to waste your time on it because you have other priorities right now. You need to get through this trial and you need to win it. And that's what your focus needs to be. You don't need to be distracting yourself by having to go write a petition for discretionary review and argue it and all that. You got to keep your eyes on the prize. And especially when the odds of it being granted are minuscule. It's almost certainly going to be denied. So yes, in theory, but in practice, no, there's really not. Madison Weaver, I like defense strategy, not calling Proctor if they get the messages in the other way. Jury hears them, thinks he's a scumbag, then argue in closing, Commonwealth hid him. Yeah, I think there's definitely some appeal to this. Another part of it too that I've been thinking about with the difference between Lally's presentation of the case and Brennan's presentation of the case. Lally gave us everybody and everything, whether they mattered or not. And so we got to actually see Jen McCabe, Matt McCabe, Julie Albert, Chris Albert, Brian Albert, Nicole Albert, Caitlin Albert, all of these people, Colin Albert, all of these people that we kind of hear about, Brian Higgins, like they may be involved. They in this trial, they're just these kind of murky party goers that other than Jen McCabe, we haven't been able to assess for ourselves. And Jen McCabe is just shady as fuck. Oh my God. Jen McCabe is super shady. But everybody else, we don't really know them. They're a mystery. I keep saying how Brian Albert has disappeared this trial. He was the boogeyman last trial. This trial is like we hardly even think about him. And so I think one of the reasons why that might have been a good idea by Lally is because when you have these people that are the subject of these theories, did they or didn't they? Are they involved? What did they do? Why did they say this? Why did they behave this way? When you get the real life people, it's harder to project your expectations onto them. You get confronted between like, oh, this guy, doesn't look or sound like I thought he would. Even just basic things that highlight this is a disconnect between what you're imagining in your mind might have happened at 34 Fairview and then being confronted with the real concrete reality of, oh, these are people. And so I think in a way that worked to Lally's advantage because most people really do want to give people the benefit of the doubt. And so as soon as you have made this idea of Brian Higgins concrete by putting him on the stand and presenting him to everybody and having him talk and having him explain stuff, is really very humanizing. It's harder to imagine Brian Higgins, the boogeyman, who did all of these terrible things. Had all this seething jealousy and called out John and probably hit him and lied about his car and went to the police department to cover it up, all that stuff. It's harder to project that onto Higgins if you have him in person there and he's denying any of that and you want to give him the benefit of the doubt. If he never shows up, it's so much easier to keep him as a ghost that you can imagine anything. So I think a lot of that applies to Proctor too. If you turn Proctor into a real live human being, might make it harder to see him as the boogeyman. I mean, he does a lot of harm to himself. A lot of harm to himself with those messages and the choices that he made. But like turning that into, would he actually plant plastic taillight? Would he actually sprinkle a little bit of glass on the back of the bumper? I think it's really harder to conceive of that type of thing, with a real person in front of you. If it's just an imaginary person, we can all imagine monsters and boogeymen and demons and bad cops and so forth. But when it comes to sticking that label on a person that's in front of us, much, much harder to do. So that's the big reason why I like Proctor not making an appearance, because I think it makes it easier for the jury to, not be swayed by wanting to be nice to him, wanting to give him the benefit of the doubt, being affected by, oh, he's a human. Yeah, he is a human. It doesn't mean he's not capable of really bad stuff, though. Yuri's math teacher. Agree with you about police unions, but respectfully disagree about other municipal employees. I worked for a town with meager resources. Our SEIU local made it possible for us to earn a living wage. I get this. I do. And I'm not like, I'm not like a 100% anti-union person or anything like that. And I would also acknowledge that, there are situations where, whether unionized or not, workers need protection. Workers are in a vulnerable position and they would need some protection. I think part of the issue is just the practical one. What happens, in a small, a town with meager resources, the damage that a union can do is going to be limited because you only have so many people and so much influence and stuff like that. But when you get into something like, for example, I don't know, the California Public Employees Union, and like you have the entire like, I did not join the union when I was in California. I briefly worked for the Superior Court down there before I went to law school. I did not join the union as part of that, but you still have to pay the dues, because you get the benefit. You get the benefit of the collective bargaining and so forth. So I saw the process. I understand. I understand the system. I understand the upsides, but I also see the downsides. And boy, are there significant downsides. And one of the big significant downsides to me is that, it just protects a massive amount of bad behavior and incompetence. And that's not what we want in public employees. That's not what we want. Should not be a system where it's hard to fire a public employee for incompetence or malice or anything like that. That's just my perspective. But I appreciate this. And, I do. I get your perspective. And I could see situations where, it's maybe the lesser evil relative to the other options. So plenty of room for difference of opinion on that one. Amy V is a YouTube member. Welcome to the channel, Amy V. Appreciate you being here. My Mini 67, the occiput boner. How many times are you going to make me say your name today? You just want to hear me say the occiput boner, don't you? Bloody lawyers and maths. Minus equals minus. Reread. Did I miss something? I don't know. Minus is minus. Is that dash minus? I don't know. Was it in one of the pleadings? I missed it. Minus is minus. I'm going to agree with you on that. Saint Julio Suave. Did Hank not learn from Marcia Clark what can happen if you change your hair dramatically during trial? He dyed it, didn't he? It looks like he dyed it. He's trying to get a little bit more like coverage over that scalp. I mean, I noticed it. It's far from the worst hair transformation I think I've ever seen, but yeah, you're gonna notice somebody changes their hair. Maybe wait until the trial is over. Then again, maybe it's like baseball. I mean, I gotta say, Bryce Harper, he was in quite a slump at the beginning of the year, and he went and he shaved off that mullet that he's had for, I don't know, a while now. It's like paradigm of Philly sports right there. That big mullet, he went and shaved it off. Not instantaneously turned it around, but like within a game or two. Turned it around, started getting hot again. He's been having a good run ever since. So maybe it's like that, he's been flailing so much. He needed to change his lucky socks. That didn't work. So now it's time to try the hair. Could be something like that. Just a little bit of a like superstition. So much superstition in baseball. Mindy Westenhaver, why could Buchanan read Higgins's text versus why can't an officer read Proctor's? Because Higgins's texts were in the extraction that Nicholas Guarino authenticated, and the defense did not object to that being moved into evidence. So it was already in evidence. Just reading it out loud didn't add anything to whether the jury would be aware of the text messages or not. So the issue that we're running into here is does the jury even get to know about the text messages? The focus isn't on the reading. It's how did the messages come in? And so with Guarino, they didn't object. So they came in. Now we have Proctor objecting, or Proctor. We have Brennan objecting. So it's not quite an apples to apples situation there. Z, where is call details on Fed investigation closing? Didn't Bev tell defense she won't make Commonwealth produce non-existent metadata in chain of custody? Hypocrisy. Yeah, they don't have to do anything. They don't have to explain anything. They don't even have to have a voir dire to account for all of their misstatements, their certifications that they made a diligent inquiry that clearly were not the case because Proctor was hiding stuff in his file. All of that. No. Fed investigation closing. You're justified if you're skeptical of that. We haven't heard it from the horse's mouth. A Cool Breeze has gifted some memberships. Thank you so much for doing that. Very, very cool. Appreciate that. Going into the weekend, some folks are going to have some nice green coming back Monday. Michelle, if Karen manually set her car's clock, would the infotainment system log the time as the time the car was turned on? I have no idea. I don't know if her clock allows itself to be set manually. If you change the clock display on your car to be, I don't know, London time. Pretty sure London time is 8 hours ahead of me right now because we're in daylight savings. So say I want to set my clock to London time, so I set my clock forward by 8 hours. It's now 11:30 at night. Is the Lexus going to allow me to do that? Or is it going to just not even have an option for me to input my own time? I don't know. I mean, I know with my own clock on my Subaru, I can manually set it, but that's because it's literally just a clock. It's not tied into GPS or anything like that. It's just a normal digital ticking clock. So I get my clock lag and all that stuff that that we talked about that they have to go in and deal with and correct every so often. I think my clock is it's probably off about 10 minutes right now because I haven't fixed it. I haven't fixed it for quite some time. It doesn't really bother me because I never use that clock. I've got a different clock that's like the Subaru clock that's built into the Subaru, but then because I did upgrade the sound, which I guess would be the infotainment system here, it's got its own clock too. And that one does run. I mean, I can tell maybe it's off of my phone. I don't think it is because I've also got a nav system in this car that runs independent of my phone. And whether my phone is in the car or not, the infotainment will give me a time. So it's got its own way of connecting with the satellites and giving that information. That one is always spot on. But my little it's not an analog clock, but it's, relatively speaking, I guess. That one has the drift and we have to change it. So I don't know if she can change it or what the infotainment system would do if she did. I really don't know. I think that's a good question. Fetalbism. Fetal bosom. Fetal blossom? I'm going with fetal blossom. I hope that's not offensive, but that's what I'm getting. Thank you so much for your support, for your super chat. If there's a different pronunciation of that, I invite it. But I'm going with fetal blossom. That makes me happy. Fetal blossom again. Maybe Proctor's friend made a deal with the FBI. We'll never know, right? Actually, I guess it would have to be, well, no, it wouldn't have to be disclosed in this prosecution unless it's something, one, that the defense knew about, and two, it's impacting his testimony in this prosecution. It's usually not, but sometimes, it might be. So possible. I don't know that we could ever say. Doesn't sound like the friend is particularly involved or implicated in anything that would require him to make a deal. Sounds like he wasn't even particularly involved in this text thread, which is probably one of the best judgment calls this guy has made in quite some time. Makes up a little bit for the bad judgment call of being in this group chat in the first place. Miriam, I'm so behind, but I feel the Commonwealth's motion comes off like trying to goat the defense to call Proctor. Well, he just came out and said it explicitly. That's what they should do. That's what they should have to do. Basically, Judge, you should make them do that. That's what he wants. I think it's very clear. He wants to be able to cross-examine Proctor and not call him on direct. He wants the defense to have to put this human form on the stand to get the text messages authenticated. Of course, in a normal courtroom under normal and predictable rules of law, we know that if the defense, somebody just rang my doorbell and it's stuck. One moment, guys. All right, had to get that fixed. I guess UPS came or something. Where even was I? Oh, in a normal courtroom, following normal predictable rules that we're all used to, the defense could call Proctor for the extremely limited purpose of authenticating these texts. That's all that they would ask him about. Is this your phone number? Did you send these text messages? Admit it into evidence, and then we're done. And in a normal courtroom, then cross is limited to that. It's limited to that. You don't get to cross him on anything and everything you want to under the sun. In this courtroom, do we expect that restriction would be applied? Why do I think it wouldn't? She would just let him ask about anything and everything he wanted to ask about, and she would allow him to treat it like it was a cross, even though technically, once you're beyond the scope of cross, you're on direct. Yeah, he says it. He says it explicitly. He says it explicitly. He thinks they should have to call Proctor to get this in. He thinks that that would be a win to, I guess, force them to do that. So that's exactly what he's trying to do, guys. That's it. Well, hey, another week in the books. Another week in the books. At least we're finally done with the Commonwealth's case. It does feel like that lasted a really long time. Not as long, of course, as Lally took. Lally sure did have a way of, making things really dull and repetitive. But it was just an awful lot of time to spend on getting what felt like very little at the end of the day. Once the Commonwealth rested, what have they proven? Well, it feels like at best they proved that she might have done it. Maybe it's possible. But when your own experts are like, we don't have enough to know how it happened or any of that, that's not good. That's not a burden of proof. It's not a burden of proof, and you definitely haven't established why. You saying there's not enough information to be able to make a decision about this, but I'm going to say there was a collision anyway, should be better than the opinion of the medical examiner, who's considered all of this and the possibility that it's a motor vehicle collision and decided that it wasn't. So it's like the kind of best case scenario for the Commonwealth. Maybe she did it, and their own witnesses kind of neutralize each other on that. But, if you want to mentally shortcut, if you don't want to have to sit down and think real hard about all the details and go through them and keep track of them, and you just want an easy answer. Look, she's there and she was drunk and she said these things. The Commonwealth did deliver that. In a perfect world, that's nowhere near enough. But we live in this very human world with all of these frailties and failings that we all have, every single one of us. And our justice system is very much a reflection of that. So can't take it off the table that there's going to be jurors looking for a shortcut. Be like, you know what? We're 8 weeks in here, ready to be done and go home. Can't we all just agree she was drunk? She was there. She said some things. It's a very easy mental shortcut. But we've only heard the very first of the defense witnesses. And remember what David Yanetti said in the first trial. He didn't say it in this trial. I'm like, ooh, it was such a good thing. Definitely the kind of advice that bears repeating. Wait for us. You'll be glad you did. Gotta wait for the defense. Whole other perspective still to take on this case. What we know, what we don't know, and there's a lot of mystery the second time around. Kelly Dever, probably going to be told to be back first thing Monday morning. No idea what she's going to say. We have no idea what she knows or what she's going to say, or if it's important or not. We got new experts. No idea. ARCA's doing new work. No idea how all that's going to play out. So we got to wait, guys. We got to wait for the defense. Remains to be seen if we'll be glad that we did. But, in general, it's a very good caution for Mr. Yanetti to have given, because there is that tendency everybody, I think, starts to have, where you start to think, I've heard enough. I don't really need to hear anymore. And you don't want people reaching that point while we're still in the Commonwealth's case. We're getting bored by the Commonwealth, so you decide, hey, I know enough, we're done. It's not a good place to be. You gotta wait for the defense. So we've all waited very patiently. We have continued to show up here in the mornings. We have brought our attention to this trial. We're ready for that. We're gonna wait for the defense. We're gonna see what they have to say about it. But hey, in the meantime, we got a weekend to look forward to, guys. I hope you guys have some fantastic plans. It's finally gonna feel like summer, because even though it's the unofficial summer, the week after Memorial Day, it's still May, and even tomorrow, it's still May. It's like so weird to me to have Memorial Day and still have this entire week of May. It's just, it hasn't quite got me in summer mode yet, but summer mode is good. Everybody loves summer. We got graduations to look forward to, people moving on, people getting out of school, having their vacations, getting into the thick of that season where there's so much to look forward to, so much to be thankful for. Remember when you were a kid and you got out for the summer and it just felt like it was going to last forever. Like you just had this abundance of time stretching out before you, so much time that, if we spend an entire day in our pajamas watching cartoons, no loss, no waste, nothing. We just have this wealth of time, and it's one of the things I miss about youth. That sense of just having all the time in the world. So why worry about what you need to do or what's on your to-do list or what have you been putting off? All that stuff. Kids don't worry about that stuff. You don't worry about that when you were 8 years old. You just had that raw joy of waking up in the morning. You didn't have to wake up to an alarm. You got to wake up naturally, and you got to look forward to the entire day that you could spend however you wanted. You didn't have to go to school. The entire day was yours. It's just limitless opportunities. We don't get to be kids anymore, so we don't get that total freedom, but it's still just such a wonderful perspective to have. And it's summer. Summer always does a good job with me of helping to encourage me to have that kind of mindset. Summer just gives me a sort of hope and optimism that the winter doesn't, even though it's not necessarily more pleasant outside in the summer here than it is in the winter. We're starting to enter the season where it will be, 120 degrees would not shock anybody. It would be very high, but not unheard of. 100 be like routine. Get pretty sweltering. You got to be covered in sunscreen all the time. Got to wear your big hat. That's the other piece of my my skincare routine for that chatter who asked. You wear big retarded looking hats, okay? Like so massive that you look like an idiot, but they really do keep all of the sun off. I'm not that great about I'm not a total sun avoidance person. I just, try to do my best, but yeah, I'll swim and the sunscreen will come off and I'll get sun. Like it happens, these things happen. I'm not going to be paranoid about it. But yeah, the summer just has always, and I think part of it's the light. The days get longer. The days are so long. There's so much light. Feels like you got a lot of time every day. Be able to spend it how you want. So maybe that's just me, but if you guys can connect with that and sort of feel that summer vibe and that kind of hopefulness, that optimism that you get from summer, that would be cool. Be cool if you did. Nicole Kelly, I would ask the friend, when was the last time you guys spoke? I'd think Proctor is dead if I was a jury. That's a good point. I know some folks have brought that up. possibility that they could think, we haven't heard from Proctor because he's dead. So problem is, if this guy hasn't talked to Proctor for a while, if the reason why, this guy is the witness and the cooperative witness is because he was like, okay, that doesn't work for me, then maybe he hasn't talked to Proctor in a while. Maybe they're not even really that good of friends. Like I was saying, some people might categorize a more superficial relationship as friendship than I would be inclined to do. So, he might have dropped him. But it's not a bad idea for how to kind of get some sense of, at the very least, you can ask, Proctor's still alive, right? Yeah. Done. Done. Problem solved. I'm going to pull this up. Thank you, Shane, ASR, for reminding me that we do actually have a lot of folks in other parts of the world. Australia. Now we get a lot of folks tuning in from Australia where you're not going into summer right now. So don't want to be like too center of the universe up here with my own experience. But I am a little summer minded. I got to admit it. I got to spend my winter in summer this year. Went down to South America. It was winter up here. It was summer down there. It was wonderful. I really barely had winter, and it was kind of awesome. Honestly, not gonna lie. I do love summer or winter. There's good stuff about winter. Loved my winters in Tahoe, all the snow and the snowboarding and the sports, the winter sports. Going out in the snow in the winter is wonderful. It's so quiet. It's beautiful. Winter wonderland stuff. Not that I don't love that too, but those days do get real short and real dark. And you just start to feel more limited, start to feel that window of opportunity closing a little bit more than you do during the summer. So, but I don't want to forget that, yes, some of you are going into winter right now. And there's nothing wrong with that either. That's good. That's good. There are good things to take away from it being winter. Just not where my headspace is at right now is all. So thank you for the reminder. Well, hopefully you guys, whether it's winter, whether it's summer, hopefully you guys have some fun and enjoyable and rejuvenating kinds of things set up for yourselves for this weekend that we get to enjoy. You're going to spend some time on what matters to you, not what matters to Karen Reed, not what matters to the rest of the world. Yeah, we need to consider those things. We're not going to be like completely self-centered. I don't care about the rest of the world. No, but you really do need to put yourself first. Got to put that own mask on first. So find ways to feed yourself, your soul, do what you need to do. Have some fun over the weekend. Enjoy some lightness, some laughing, some joy. It'll really help carry you forward through what may be the hard days of trial that are often still to come. Do you have your eyes on the next trial you'll be covering? The only trial on my horizon right now that I intend to cover is Kohberger, and that is a ways down the road. Set to start as of right now, July 30th with the jury selection. However, there has been a defense motion to continue that's been filed. Decent chance, in my view, that motion is going to be granted. It's based on a whole bunch of different things. Ann Taylor has been saying for quite some time that she is not prepared and cannot be prepared. The volume of information that they have to go through is just too vast. They also have, because it's a capital case, a whole mitigation investigation that they have to do into Brian Kohberger's personal history and like basically everything about him, anything that could possibly help him in a plea for leniency should the case get to that. So a lot of demands on the time. The judge has not been pleased to hear that. Well, you could have done this. You could have hired something that. Yeah, because it's always easy to shit on the defense lawyer who is, getting paid peanuts to do the dirty work that you didn't want to do. I get it. Always easy to shit on the defense lawyer. But the bottom line is it doesn't matter if you think she was wrong for being ineffective or not. The bottom line is she ineffective if she goes forward to trial without being fully prepared? And the answer is unequivocally yes. The only question is, because of that, would she be forced to overlook something that could be game changing, either for conviction or for sentencing? And that's quite a gamble to take. So that's a piece of it too. But then she's also relying on the Dateline show that just came out about Brian Kohberger, which I did not watch, but I read some of the takes about it, and it sounds to me like it's largely just more of the same. It's stuff that is not vetted as evidence in court, at least not at this point in time. There are purported things, pieces of evidence, information, video, phone information, stuff like that appear to be legit in the sense that the court has acknowledged. Looks a lot like there's been a breach of the non-dissemination order that's been in place in the case since day one. Somebody had to provide that information to Dateline. Court is at least making some sort of a display of being a little bit unhappy about that. Is the court going to actually do anything about that? Seems pretty unlikely. The court is going to run out of time to address it in the only practical way I think the court has to address it, which is to go to Dateline. You're going to have to get this information from Dateline, who the leak came from. And they're going to resist giving it to you. In July, the law in Idaho will change because Idaho just adopted a reporter's shield. So until July, reporters have no right to refuse to disclose their sources if they are ordered to do so by a court. After July, they will be able to do that. So court has until July. If it doesn't happen before then, it's not going to happen. It's not going to happen. If the leak is from the FBI, there's no way to enforce that either. Court doesn't have jurisdiction over federal officers unless they are, committing a crime in his jurisdiction, and violating the NDO is not a crime. So he can't even subpoena them into court to answer questions. That's part of what the 2E process requires. The supremacy clause of the Constitution says those federal agencies, those are above the state courts, and the state doesn't have power to require them to come in and answer. So anyway, that was a very long and roundabout answer for me to say. My focus has been on Kohberger, but that said, I don't know at this point if it's actually going to go forward at the end of the summer as it's scheduled to do. So we have to wait and see how that's going to unfold. If Kohberger doesn't go, then my goodness, my schedule, my life for the rest of the year is going to suddenly look dramatically different. So I'd probably start looking around and seeing if there's anything out there that catches my interest. So short answer, Kohberger. Miriam, someone gave me a piranha. Thank you. Oh, I'm so glad that you got that. That's awesome. You have the, and you're green, you're beautifully green. Welcome. Z, Brennan will have the same downfall as Carrie Morrissey. Not without the same judge. Not without the same judge. Maybe eventually he'll end up in a court with that kind of a judge, but I don't know how much longer, how many times he's going to be a prosecutor again. He's not going to end up like Carrie Morrissey with a judge that doesn't care if he violates Brady, that doesn't care if he misrepresents the facts, who doesn't care if he is repeatedly improper and flagrantly ignores her authority and her instructions and the decorum of her court, if she doesn't care that he wants to walk around and, let a big old fart out in the middle of her courtroom and call it a cross-exam, then he's not going to end up like Carrie Morrissey. But yeah, I understand the common thread. These are both defense lawyers that went turncoat, became prosecutors, prosecuted high-profile cases. Arrogance perhaps got the better of them. But yeah, he's not going to have that downfall without that judge. All right, guys. Hey, it's been a little bit over 10 hours. We're going to just go ahead and wrap it up now, guys. It's been a good day. It's been a good week. It's been good to see how things are wrapping up in terms of the Commonwealth's case being done. What did they actually accomplish? And now starting to dip our feet into the defense case. Already got a bit of a vibe shift. Not really any major facts or truth bombs or anything like that out of today's testimony. Nothing we hadn't already anticipated from how cross previous witnesses has gone. But still kind of helpful to distill it down in concrete terms. 30 possibilities for how this clock could be oriented, configured. All but 3 of them have the lock trigger event being before or after, before or after. At the same time or after. Let me say that correctly. All but 5 possibilities have the trigger event occurring before the end of the lock. And then, of course, as Mr. Jackson pointed out, you take the steps into account. I mean, that goes even beyond. So, the defense is still very much in the battle for the facts, the science, and the data. I don't think the Commonwealth has quite conceded that they lost that battle. But they did. When your own expert gets on the stand and says, we just don't even have enough information to be able to tell you what possibly happened here. We just know it was a collision. It's not based on fact, science, and data. It was the Dr. Hughes defense. Let's just turn him into a implicit fact finder and have him present that and just do the subterfuge, pretend that it's an engineering type of decision when it has nothing to do with engineering analysis at all. So guys, good day, good week. Do enjoy your weekends. We got sunshine outside. Don't know what you got, but I'm looking forward to getting out and enjoying a little bit of a nice day. I did not, in fact, get my grass mowed yesterday. I did think about it, but it was really windy. Not all that pleasant out, so I decided to watch the Phillies doubleheader instead. We got Phillies baseball on right now. In fact, hopefully the Brewers will not dog walk us the way that the Braves did in Game 3 of our series yesterday. So, hope springs eternal, guys. As long as there is life, there is hope. Erica M., have you seen Diane Menashe? Defense attorney, Matthew Moore and Dr. Husel cases in Ohio. She's amazing. I rewatch more close, like twice a year. I've heard about her, and I remember her. That the doctor, I don't know how to pronounce his name, but I remember seeing her. Seeing that she was involved in that particular case. So no, I haven't watched or like read transcripts or anything like that, but I have heard about her. I'll take your recommendation maybe and check her out. I have my random sticky note where I write things down sometimes. It's always good practice to watch good defense lawyers who know what they're doing. It's one of the benefits of working in like a public defender's office is, yeah, you get your own experience, but you also get to go watch the old grizzled 20, 30-year-old vets go try cases. And that's where you learn some shit. That's where you see how it all really works. So I have heard of her, haven't seen her personally, but I got her name written down. So I'll see if I can make time to check out a good examination or cross-examination or something like that. So thank you for that recommendation. Guys, Monday's going to come soon. It'll be early. It'll be a full day. Don't know yet if we're going to get a full week all next week. I find it hard to believe that Bev would go through this, short vacation week and then, pedal to the metal, nose to the grindstone, have us work through the full week next week. Seems a little just atypical, not really consistent with how she likes to do things. But we don't know. We got to make sure the jury doesn't think we're behind now that it's the defense case, right? Got to keep pushing things forward. Slinky says, ARCA did the ultimate accident reconstruction with NASA, the Challenger. I think I did remember that. They discovered it was the O-ring, right? They discovered it was the O-ring. It was the O-ring. I don't even think it was like off spec. It was like just the material or something like that. I can't remember the details now, but it was an O-ring failure. The reason I remember that is because I went to college with a guy whose family had a company that manufactured O-rings, and they ended up getting contract with NASA after Challenger when NASA apparently thought it would be prudent to find a different source of O-rings. So I didn't know that ARCA did that. That's interesting to know, but also quite impressive. Also quite impressive. So, guys, we're calling it done. Appreciate you spending the time with me here. Appreciate the conversation, the clever jokes in the chats, all that stuff. Your great names. I did say occiput boner a lot of times today, so thank you for the opportunity to let that roll off the tongue. So Monday will be here soon enough, but let's make sure that we do take time to enjoy our weekends here. So thank you again for joining me. Thanks for all your contributions. Thanks for your support. Thank you to the mods. Thank you everybody for the this great environment that you create here, that you all contribute to. It's a fun vibe, and that's why we do it. It's what makes it enjoyable to watch a trial together instead of just all of us sitting, individually watching the live stream on NBC or wherever you're watching it. So that's all because of you guys, and I really appreciate it. So thank you so much for that. And I'm going to go enjoy my weekend now, take in some baseball, whatever else, limitless opportunities, just like when we were kids. Boundless time. I'm going to go into that kind of mind state. So thank you, everybody. Really appreciate you, and enjoy your weekends. And I'll look forward to seeing you Monday morning. Take care, everyone.